morning and welcome to today's public hearing uh, held jointly with the Senate Judiciary, Codes, and Housing, Construction, and Community Development Committees on the operation and reopening of New York's courts during the COVID-19 pandemic. I'm State Senator Brad Hoylman, Chair of the Senate Judiciary Committee. I'm joined by my fellow committee chairs, Senator Jamal Bailey, who leads the Codes Committee. Welcome. And Senator Brian Kavanaugh, who heads up the Senate Housing Committee. We've also been joined by the ranking members of the Senate Judiciary Committee, Senator Tom O'Mara, the ranking member of the Senate Codes Committee, Senator Andrew Lanza, as well as other colleagues, including Finance Chair Senator Liz Krueger, Senator Diane Savino, Senator Robert Jackson, Senator Kevin Thomas, and probably others who will be joining us, and I'll be acknowledging them as they appear. This is the latest in a series of hearings that the Senate's held on the impact that COVID-19 has had on the lives of New Yorkers. New York's unified court system is a full 1/3 of our state's separate and independent branches of government, operating 12 trial and appellate courts in more than 300 locations across all 62 counties, in addition to over 1,250 town and village courts. The unified court system is also a major employer with more than 16,000 judges, officers, and court employees statewide, all of whom work to support the 3 million plus new criminal and civil cases filed each year, and the countless attorneys, parties, witnesses, and jurors that come before them. Overseeing the shutdown, virtual operations, and physical reopening of such a vast and disparate system amid an unpredictable global pandemic, all while striking a careful balance between ensuring access to justice and due process with protecting the health of the public and court employees, is a Herculean and unenviable task. It's an unenviable task, but that doesn't mean it's an unaccountable one. And it's precisely because of the enormity of the challenge that it's crucial that we have a transparent and open discussion about the impact of COVID-19 on our courts and how we can best restart court operations in a way that includes a meaningful opportunity for input from all of the necessary stakeholders: court administrators, judges, attorneys, court employees, legal service providers, and litigants themselves. Today's hearing is going to provide that opportunity for us, state lawmakers, to hear directly from impacted parties. The full witness list is available on the Senate website, and written testimony will be uploaded to the site as it's received. We're going to start with Chief Administrative Judge Lawrence Marks from the Office of Court Administration. Our second panel is going to feature representatives from several judicial associations. Our third panel is going to focus on criminal practice. Our fourth panel is a professional bar association panel with legal services staff unions. Our fifth panel will feature representatives from several court employee unions. Our sixth panel focuses on civil practice. Our seventh panel is dedicated to eviction and foreclosure issues. Our eighth panel will hear about accessibility and technological issues with virtual court proceedings. And our final panel today will be about family practice. I think we should all be entitled to CLE credit for the entire year based on this hearing, but unfortunately that's not an offering. But to be frank, many of these stakeholders haven't felt like they've been afforded the meaningful opportunity, even as the Office of Court Administration has moved ahead with the physical reopening of the courts. And I suspect that's a refrain we're going to be hearing about today. I, for one, and I know my colleagues share this, am particularly concerned about the looming eviction and foreclosure crises that threaten to displace hundreds of thousands of tenants and homeowners amid this global pandemic. According to the OCA, there are over 200,000 residential housing cases pending. In New York City alone, there are more than 14,000 eviction cases. If we're going to consider ourselves a just and moral society, we can't allow this to occur. Without a concerted effort to stave off this disaster, we risk overwhelming the court system, stretching the social safety net to a breaking point, and most importantly, putting New York's most vulnerable populations directly in harm's way by forcing them to participate in in-person court proceedings and displacing them from stable housing. And what we're trying to get to today as well is some clarity as to how impacted groups can provide input to OCA and what the charted course forward is going to look at. I want to thank everyone, the witnesses in advance for agreeing to testify today, and to our colleagues who are joining us, and of course Stanley and the rest of the staff who are helping us conduct this hearing remotely. Before I turn it over to my co-chairs to see if they have anything opening in terms of opening remarks, although I think all of us want to get straight to the questions, just a few housekeeping items. For the witnesses, witnesses will each have 5 minutes to testify, and there'll be a clock. Please don't read your written testimony verbatim. We'll read all we'll read all the submitted testimony because it's going to be available to senators and for the public to read on the Senate website. Please instead summarize your testimony and highlight the main points you'd like to convey to legislators gathered here and to the public watching at home. For senators, chairs and ranking members will get 5 minutes per panel for questions. All other members of the Judiciary, Codes, and Housing Committees will be allotted 3 minutes of questions per panel. Please use the raised hand function in Zoom to be recognized if you wish to ask questions during a panel. It's important but necessary to remind all participants on this Zoom they should not be operating a motor vehicle or crossing the street. And if you live in Manhattan. And I'll turn it over now to my colleagues who are co-chairing this committee, Senator Jamal Bailey and Senator Brian Kavanaugh. Do either of you have opening remarks you'd like to say, Senator Bailey?
I just want to say thank you for convening this, and I want to thank all my colleagues for coming together at an important time. The court system is one of the underappreciated gems that we have in the state, and we have to understand and realize that we have to have a functional court system even in times of pandemics. And this hearing and under the leadership of you, Mr. Chairman Hoylman, I think it's critically important to figure out what are we doing, what will we be doing, and how can we help to get the court back and going where it needs to be. So I want to thank you for the opportunity. I want to thank all of my colleagues for taking time out of what I know are busy and trying times in your district. And I will say it's good to see you all.
Thank you, Senator Bailey. Senator Kavanaugh, would you like to open
Yeah, thank you, Senator Hoylman, and thank everybody who is joining us today. And I particularly like to thank my co-chairs, Senators Hoylman and Bailey, for the great work and leadership they provide on so many issues, and particularly today on the issues related to the courts and criminal justice. I also want to thank all the experts and leaders and stakeholders and community partners that we're going to hear from today, many of whom have been working very, very hard over a long period now to support New Yorkers during this tremendously difficult time. We're here to discuss the status of court proceedings as we begin to see a reopening of many processes that have been shut down for quite some time. It's been a long road. Senator Hoylman and I and many of our colleagues had called in the middle of March for a suspension of all kinds of non-essential proceedings, particularly as the housing chair. I've been focusing on the questions of foreclosures and evictions and all of the processes that potentially lead to those outcomes. So we're concerned today about the safety of litigants and attorneys and judges and jurors and court staff and also the general public. And I think there's still a fair amount of uncertainty about how a lot of these processes are going to work and what the effect will be on the public health. We're also concerned about the ways legal determinations that negatively affect New Yorkers and potentially threaten basic needs like housing will impact families and individuals, many of whom are already very vulnerable because of the pandemic. Obviously, all three branches of governments have a big role to play here. So we had worked with the governor on some of the executive orders that he issued early on that were in place, particularly through June 20th, which was a blanket moratorium. There have been subsequent orders from the governor, and there's also been some legislative action. We have pushed for some changes in the way arrears in housing cases have been handled. Senator Hoylman's bill, we passed the Safe Harbor Act, which makes it such that payments of rent that are were due because during COVID, to the extent the tenant couldn't pay them, cannot be the basis for an eviction if they result from a hardship due to COVID. We also passed a bill that is intended to begin to address the financial impact, the Emergency Rent Relief Act, which put $100 million out there to try to pay some of the rent of our most vulnerable tenants, those who were low income both before and during the pandemic. There are about 90,000 applications for that program, and HCR, the state housing agency, is making determinations about how that money will be spent. We've also had legislation around extending the moratoria that have been in place, particularly in housing. So Senator Myrie has a bill that would be a very long extension for a year after the pause orders expire that are in place on both evictions and foreclosures. And I've been working with Assemblymember Dinowitz, the chair of the Judiciary Committee, on a bill that would suspend evictions and eviction proceedings. And that the current version of that bill would do so until January 20th, 2021. Because we have a belief that tenants should not be forced to appear in housing court, and they shouldn't be forced to fight for their ability to stay in their homes, and they certainly shouldn't be put out on the street. Having said that, the court has taken very big steps on its own, including the recent orders by Judge Marks, who we'll hear from in a moment, who really, I think, has shown leadership in going to some extent beyond where the policymaking and political branches, the governor and the legislature, have gone by putting a moratorium in place until the end of September on evictions. So we're grateful for that. And so without further ado, thank you again to everybody who's participating and viewing our proceedings today. And I look forward to the testimony.
Thank you, Senator Kavanaugh. Would Senator Lanza or Senator O'Mara have any brief opening remarks? Or would you like just to get straight to questions and Judge Marks' testimony?
Proceed with the testimony.
Okay. Senator Lanza? Okay, thank you.
Judge Marks, and I just want to thank all my colleagues here. Thank you, Chairman.
Thank you, Senator Lanza. So our first witness is the Honorable Lawrence Marks, Chief Administrative Judge of the New York State Unified Court System, Office of Court Administration. And as is our practice, we ask you, before you testify, do you swear or affirm that the testimony you're about to give is true?
I do.
Thank you, Judge Marks. You have 5 minutes.
Okay, good morning. Pleased to be here today to speak about the impact that the COVID-19 pandemic has had on the judiciary and the administration of justice in New York. Coping with the pandemic and the unprecedented threat it has posed to public health has been an extraordinary challenge for the judges and non-judicial personnel of the court system, for the legal profession, and for all others involved in the administration of justice. Every day in normal times, thousands of people gather in courthouses across the state to conduct business that may be vital to them personally or vital to their communities. And most of this business is conducted by people often in large gatherings in close proximity to each other. But with the advent of the pandemic, it became apparent that significant changes in the operations of New York's courts had to be made. So shortly after the governor declared a disaster emergency in the state in March, the chief judge, Janet DiFiore, made the decision that while the trial courts would remain open to handle essential and emergency matters, all other court matters would be postponed for the foreseeable future. And clearly that was the only choice. Since that time, the judiciary has been engaged in two major efforts. First, we've worked to make the best possible use of technology to permit the conduct of court proceedings through the virtual appearances of judges, attorneys, and litigants. For example, we instituted a virtual arraignment system, first in the New York City Criminal Court and then in courts statewide. This system has allowed arraignments to continue uninterrupted during the pandemic for all those held in custody. Nearly 47,000 virtual arraignments have been conducted since mid-March. In every county across the state, in very little time, we undertook the creation of an entire virtual court system capable of hearing all essential applications in all of our courts. This included Supreme, family, county, surrogates, and local courts. As part of this effort, we established toll-free helplines and public access kiosks to address technological barriers for those who are unrepresented or who lack adequate computer and internet access. By mid-April, this initial effort was soon expanded to permit the virtual hearing of non-essential matters as well. And to date, hundreds of thousands of civil and criminal proceedings have been conducted virtually, with up to 1/3 of those cases settled or otherwise resolved. Moreover, by the end of May, all of the judicial districts outside of New York City had cleared their entire Supreme Court undecided motions backlog. And since then, the New York City Supreme Court is now on the verge of eliminating its motions backlog as well. In total, our judges and staff have worked to issue over 32,000 formal decisions during the pandemic. Our second major undertaking has been to resume in recent weeks in-person court operations. This is being done in a gradual and deliberate manner. To guide us at every step, we engage the services of an independent epidemiologist. In following the governor's lead, as the state's regions have reopened their economies, we have created a parallel phased approach to allow some matters to be heard in person in the courthouses. And guided by our epidemiologists, we have followed state and federal guidelines in implementing stringent health and safety protocols statewide, including mandating PPE for all judges, staff, court users, and the public, and requiring temperature checks and screenings of all individuals entering court facilities. To limit foot traffic and enforce social distancing, we have reimagined court calendars and have continued to rely primarily on virtual capabilities. But where an in-person appearance is warranted, designated courtrooms have been retrofitted with plexiglass and social distancing markers. Further, all reasonable accommodations for attorneys and parties suffering from any COVID-19 related preconditions, disabilities, or other specified circumstances are being granted. All of this careful planning and deliberation has permitted us to restore, on a very limited scale, in-person operations in courts across the state. We now have grand juries hearing presentations in all 62 counties, and we anticipate the return on a limited basis of some jury trials in the early fall. Although most court matters will continue to be conducted virtually, we recognize that for certain types of proceedings and for certain types of cases, in-person operations and appearances are a superior means of ensuring that the courts fulfill their constitutional responsibility of providing justice under the law to all who appear before them. Finally, I want to acknowledge the extraordinary dedication of our judges and employees, court officers, court clerks, court reporters, court managers, legal staff, our remarkable technology staff, and everyone else who over the past 5 months made these achievements possible. New York's courts never closed. And people talk about the courts closing, and we always emphasize the New York courts never closed, not for a single day. And although the courts have certainly not returned to normal operations, legal disputes throughout the state are being addressed, and many are being resolved. That has only been possible because of the incredible hard work, commitment, and ingenuity of our judges and staff. So with that, I'd be happy to answer questions, but I just want to mention one thing that we have been sued in a number of, there are a number of pending lawsuits that have been brought against us, some alleging that we've moved too quickly in the actions that we've taken. Others allege in other lawsuits that we've moved too slowly in the steps we've taken, or that we haven't taken steps that allegedly need to be taken. So I'm here to answer your questions and better explain to you all the things that we've done. But I just want to say that, and this is very important, that I've been named as an individual party in a number of these lawsuits, that I'm not able to answer questions to the extent that they relate directly to issues that have been brought in these lawsuits. But with that caveat, Happy to answer your questions.
Thank you so much, Judge. And I'll start, if it's okay with my co-chairs. You mentioned the fact that OCA's retained an epidemiologist. How do you hire an epidemiologist? Did you use a university or research organization to find one?
We asked around, actually the very capable expert that we did retain was recommended to us by the federal courts in the city. I think initially she was retained by the Southern District of New York, and then I
Okay.
believe
Thank
the district has retained
Thank
her. So that's how we found her.
And have they actually visited court facilities in New York State?
No, the communication with them has been over the phone and by email.
They haven't physically seen any of the layout or configuration of courtrooms.
They've seen layout plans, but
Plans.
have not actually been to the courthouses personally.
Has this epidemiologist, Judge, provided you with a report or written guidance on the reopening of the courts?
No, we haven't received a report at this time.
Are you going to be seeking that? So what are they doing if they're not providing a report?
They're available to answer all of our questions, which they've done. Whether we ask for a report in the end, we might do that, but we haven't asked for a report at this time yet.
So you ask the epidemiologist case-by-case questions, and he or she gives you a response?
General questions and specific questions, yes.
And those are about how you should be reopening, but there's nothing systematic in their in their reporting that is in a document that could be shared with the public?
No, at the moment, there's no document.
Do you foresee that we as the legislature might be provided with what their guidance has been so far, even if it is only on a case-by-case basis? I guess my question is, will we be able to see what they're suggesting to you in order to know that, frankly, their recommendations are being followed?
If you think that would be helpful to you, perhaps that's something that we could ask to be prepared.
Yes, I think my colleagues would and I would appreciate that. While there's still, of course, much that we don't know about this virus, there's a developing consensus among public health experts that prolonged exposure to other people in poorly ventilated indoor settings carry a relatively high risk of exposure. And I think that describes a lot of court facilities. For that same reason, malls and gyms haven't been allowed to reopen unless they're equipped with air filtration systems with a filter minimum efficiency reporting value of 13, what they call a MERV 13 rating. Do you know, Judge, what the percentage of court facilities in New York are equipped with this MERV 13 or higher rating of air filtration systems?
A very high number of them, particularly in New York City, have filtration systems with MERV 13 or higher. Particularly the buildings where we've resumed some in-person operations.
Is that something that could be provided to our respective committees in terms of which air filtration systems meet MERV 13 and which facilities do not?
Sure.
Okay. And in those facilities, do you have any estimate of what the percentage of facilities that have MERV 13 and those that don't?
Well, I don't want to speak off the top of my head, but most in the city, in particular, the buildings where we're resuming in-person operations and I don't want to speak generally about outside New York City, but
Are you resuming or planning to resume any in-person operations without MERV 13 air filtration standards?
well, you realize the some buildings, older buildings that have older HVAC systems are not compatible for the high grade filters. And there are other steps that could be taken in those situations. But it's, if MERV 13 or higher filters could be installed in all the courthouses, they would be, but it's not possible to do that in every single courthouse. But there are other steps that can be taken to account for that, to make up for that.
Okay, and hopefully my colleagues will dig in on those questions as to what steps you're taking in facilities that do not meet these minimum efficiency reporting standards. But my time is up, and I'm going to ask our co-chair, Senator Bailey, for any questions of Judge Marks.
Well,
5 minutes.
thank you, Senator Hoyleman, and thank you, Judge Marks. I appreciate you coming to testify. Social distancing is something that we've been speaking about significantly. And my concern is not just about social distancing measures in the courtrooms, but social distancing measures in places where people are assembling, such as metal detectors and other common areas. Can you explain to me what steps are going to be taken to ensure that individuals can properly social distance in the event, once we start reopening more and once we start having more in-person jury trials? What steps will the court system be taking in order to ensure that we are complying with social distancing?
Well, at the magnetometers, people will not be and are not now and will not be on top of each other the way the lines you might have seen in courthouses pre-pandemic. So that's an obvious step. I mean, I can go through a series of measures that we've taken, but masks are required or mandatory for everyone in the building: judges, court staff, lawyers, litigants, members of the public. PPE is required. There's hand sanitizer that's available. There are face shields available for people who ask for them. They're not mandatory, but if someone requests a face shield, they'll be provided with one. There's signage. There are temperature checks that are being done at the entrance of the buildings for everyone who comes in. And if someone registers a temperature of 100 or more Fahrenheit, they will not be allowed into the building, to go up into the building to the courtroom. There's screening of questions that are asked of everyone who comes into the courthouse, including our employees. There's plexiglass that's been installed in designated courtrooms where that's deemed helpful and appropriate. It's a whole range of protective measures that we've taken in accordance with guidance from our expert and CDC regulations and advice and guidance from other health experts, including state government health experts.
That's helpful to know. So courtrooms, there are varying sizes of courtrooms. Some are rather expansive, some are really small. How are we going to, again, I know it goes along with something what you said, but I guess my main concern is once people are beginning to assemble, what are we going to do inside of these courtrooms? And if individuals are not complying with social distancing suggestions, for lack of a better term, what will take place in the courtrooms? Will court officers get involved? What exactly? Can you walk me through something if folks are not complying, so to speak?
Again, in terms of physical distance between people, which I think is the gist of what you're asking, yes, our court officers have been commissioned to enforce social distancing so that people keep a healthy distance between themselves. These large and voluminous calendar parts of the past are obviously not something we're going to be seeing in the immediate future. Let me emphasize that these in-person proceedings are very, very limited. We're talking about, for example, In felony cases, we've started in recent weeks to call in some of the out felony cases, out meaning people who are not in custody but were released at arraignment or at liberty. Some of these cases have not been called in court in over 5 months and longer. And we are conferencing 10 of these cases a day per court. So 10 cases in the entire court are being calendared, in addition to a lot of virtual conferences that are being held in those cases. So to ensure social distancing and other protections in these 10 cases per court on a daily basis, we are staggering the calling of those cases. So they're not all called in, which is the norm, in pre-COVID. They're not all called in at 9:30 or 2 o'clock in the afternoon and congregating in courtrooms, waiting for their case to be called. Each case is given a designated time slot. So at any given time, there's a minimal number of people in the courtroom. So social distancing, therefore, is not difficult to enforce.
I guess my last question, with my 10 seconds, the buzzer coming up, is if you could explain in detail at some point, even if it's not right now, these court officers that are getting involved in these proceedings, how are they reporting these? How are they reporting these issues? To whom are they reporting these issues to? And what's the transparency level concerning these distancing things? My time is up, and I yield back to Chair Hoyleman.
Thank you, Senator Bailey. I will now turn to Senator Kavanaugh for 5 minutes on the clock. Senator Kavanaugh. And that's a real 5 minutes, Senator Kavanaugh.
A real 5 minutes? Doesn't include my unmuting time? Thank you very much, and thank you, Judge Marks, for being with us today. So I want to begin by speaking a bit about the situation with evictions. Can you just briefly state you currently have a moratorium in place through September 30th? Can you just speak a little bit about the rationale for that aspect of your order?
Well, yeah, I'm happy to do that. Actually, we've had a moratorium in place since the middle of March on evictions, commercial and residential evictions in New York City and counties throughout the rest of the state. And that was followed by an eviction moratorium that the governor issued in an executive order, I think a week or so after that. And the governor has taken steps to continue that. We've issued subsequent administrative orders to conform with the governor's executive orders. The most recent administrative order, and in our orders, we label administrative orders. The governor's orders are obviously executive orders. The latest administrative order we issued, we felt was necessary because it was very unclear, we felt, with respect to both residential and commercial evictions, whether the governor's more general orders several weeks ago were continuing eviction moratorium. So we issued our own subsequent administrative order, which you referred to, that extends a moratorium on actual evictions. The cases themselves, the pre-COVID cases can proceed through adjudication, but an eviction under our administrative order cannot be executed until October 1st, as the order currently reads. The COVID in the cases arising as part of the timing of the pandemic, we've allowed for new cases to be filed, but that they can't proceed under our current administrative order. And the reason for this is we are still very concerned about a mad rush of cases, eviction cases in the courthouses, particularly in New York City, but to some extent outside of the city. Number one, so we're concerned about that. And number two, we're concerned about the ability to manage these cases and effectively and productively adjudicate them, given the sort of the magnitude of the volume of these cases that's anticipated. As I think Senator Hoyleman, or someone, maybe Senator Kavanaugh, you mentioned this before, there are approximately 200,000 pending pre-COVID cases. And we haven't yet seen an avalanche of COVID eviction cases, but many anticipate that will happen. So we've extended our moratorium to October 1st. But let me say this, and this is an opportunity for me to emphasize this with you. It's very difficult for us to continue to do that. And October 1st may be, for us at least, a hard deadline. This obviously implicates, very controversial and hotly contested policy issues. We are obviously the judiciary, not the policy-making branch of government. You are, and the governor has a role in that, obviously, as well. And we urge you to focus on this problem, not rely on us to do that.
And by focus, just my time is, as by focus, you mean potentially pass a piece of legislation or have the governor issue an executive order to clarify the situation after September 30th?
Correct. If that's what you decide to do, in your wisdom, if there's further action that needs to be taken, you should take that action because, frankly, the state can't rely on us indefinitely to address that, very controversial issue.
You appreciate that feedback. On the situation with respect to foreclosures, those are currently, if I'm not mistaken, is effectively a moratorium through September 4th. Is that correct?
I think the governor's executive order extends through September 4th. Our administrative order extends, I believe, to October 15th. Foreclosure cases are proceeding. There new cases can be filed. They can be adjudicated, but our administrative order from a number of weeks back extends a suspension of the actual execution of foreclosures until October 15th for reasons similar to why we've done that with eviction cases.
But, and just to clarify, and I know my time is up, but just the initial settlement conferences and those kinds of aspects, those aspects of those cases will be resuming and they'll be done virtually at this point?
They will be done overwhelmingly virtually. If there's some interest with the parties or the judge to do an in-person proceeding, that's permissible, but overwhelmingly they'll be handled virtually.
Okay, great. Thank you. Thank you for your testimony.
Thank you, Senator Kavanaugh. We'll now turn to Senator O'Mara. Do you have any questions, Senator?
Yes, I do, Chairman. Thank you.
5 minutes.
Thank you, Judge Marks, for being here with us today. I want to talk briefly, if we could, about the virtual appearances in the criminal courts. In particular, 18220 of the criminal procedure law that allows certain counties to have virtual appearances, but it's limited to 27 counties in the state, and they're identified in that section. Each of the 5 counties in New York City are included in that. The Suffolk County is included, but Nassau County is not. Upstate Albany County, Onondaga County, and Erie County are included. Monroe County is not. So there's similarly situated jurisdictions that are included and not included. Only one of the 5 counties within the Senate district I represent is included. I'm working on legislation now to expand that and open it up to all counties to allow these virtual hearings, not hearings, virtual appearances. And I'm just wondering what your thoughts are on that, and any reason. I don't know why some counties were included and some weren't when this was first instituted.
Actually, thank you for the question. We have supported in the past a statewide video court appearance statute. As you said, it's not available in all counties of the state. I think it's roughly about half, a little more than half, are authorized to conduct video court appearances, although under limited constraints. We are conducting video appearances in all counties in the state now during the pandemic, and our authority for doing that is an executive order that the governor issued, which I guess enlarges, if you will, the CPL Section 182 to allow the court system to conduct these proceedings virtually in every county in the state. But the pandemic will come to an end at some point, and the court system would be very supportive of extending that statute statewide.
And another one of the concerns and perhaps limitations of that is that it still allows for a defendant to be able to deny a virtual hearing. And that seems to be a cog in the wheel for hearings and trials are excluded, obviously, from this virtual hearing, but the consent of the defendant kind of can throw things off, particularly in this time of a pandemic. And I'm wondering what the court's thoughts are on removing that consent requirement going forward.
Well, interestingly, but maybe not surprisingly, that hasn't been a problem during the pandemic. Consent has been broadly forthcoming in these cases. I don't know about 100% of the cases, but I haven't heard that the requirement of consent has been a problem during the pandemic. It has limited the effectiveness of the statute in the years pre-pandemic. And I think that's why it's a statute that has had limited effect in application because of the consent requirement.
Do you think removing the consent requirement would make that more useful and a higher utilization of virtual appearances?
It would certainly lead to a higher utilization of video virtual appearances.
Yeah, and I would think that would lead to some significant expense requirements with just the transportation of inmates to and from jails and prisons, particularly when they're more ministerial type appearances going on. It's not going to infringe upon a defendant's right to be at the trial, at the hearing in person. But I'm running out of time. So one last question on the area of evictions. And the language that's out there now going forward with evictions, that the court will determine whether there was a hardship of the tenant due to COVID. Is the court looking for some more direction and clarity on that? Because I can foresee a lot of issues where tenants, many of which, and we've seen it in employment concerns with businesses, that receiving the extra $600 a week, many tenants were receiving more than they actually were earning before the pandemic. And whether that is going to weigh in to the consideration of the courts and eviction determinations on whatever hardship there was or wasn't with if somebody was actually bringing home more money because of the extra $600 a week than not. Do you have any thoughts on that?
Well,
I have to be brief, Judge Marks, because our time is up.
sure. Look, I think courts are going to have to, that'll be a legal determination that courts will have to make. That's a defense that the new statute's created. Statutory clarification is always a good thing. But if the statute is not revised, I think judges will be able to make those determinations fairly effectively, I would predict.
Thank you.
Thank you, Judge.
Thank you, Senator O'Mara. Senator Lanza, do you have any questions?
Yes, thank you, Senator Hoylman.
5 minutes on the clock.
Thank you to my colleagues and Judge Marks. It's always a privilege to see you, even by way of a computer screen. And let me just say, with respect to the matters you're involved with, if you're in need of some pro bono representation, I'd be honored to be your man.
Thank you.
So, listen, Judge, I just have some comments, like things that I want to bring to your attention. I'm sure many of these things, if not all, you are aware of. With the understanding that the complications that the courts are fighting through are imposed by the state and state policy and the virus itself, I share your gratitude for the work being done in the courts by our judges and justices and litigants and everyone involved, the personnel. They are doing a great job under very difficult circumstances. But as George Washington described, the true administration of justice is the firmest pillar of good government. In my estimation, and I know yours, the right for disputes to be resolved in our court system, both civilly and criminally, is an absolute right for our citizens. And it's important. I'm glad to hear, I know it's a difficult decision that you're going to have moving forward, but I'm glad to hear you sort of throwing out a marker for a September 1 deadline, because we cannot delay justice any further. So I want to point out, I visited our courts, I've talked to our judges, I've talked to attorneys, and here are some of the things that are happening that I think we need to resolve. I mean, and this is not you, I'm astounded at the lack of innovation from the Empire State in terms of dealing with this virus. I mean, the answer is, you know, a 20-cent mask in most cases, and, you know, a little alcohol. And with respect to the technology that I know exists, whether it's in our school system, our court system, or at every other level of society not being utilized, is very, very disappointing to me. So here's what I'm hearing. It seems to me that under this current circumstances, in terms of the practices that are being utilized in the courts to deal with this, and again, this is not to criticize, because I understand this is being imposed upon you, that a fair trial, which is really essential in our community, is next to impossible. For instance, people can't understand what's being said in the courtroom because people are speaking through masks. That is the number one complaint I'm hearing from attorneys and judges. They simply can't hear what's being said. Our court officers are being forced to be chaperones, if you will. They're all over the courtrooms. They are told to do this. They are told to monitor social distancing. I understand that's a good policy, but as a result, attorneys cannot have privileged conversations with their clients, and that is unacceptable. And that needs to be dealt with going forward if we're going to move to the next stage, if we're not going to loosen up these restrictions. Evidence, document sharing, it's impossible. And that is essential if we're going to have fair trials for criminal defendants, civil litigants. We've got to do something about that. That is another common complaint that I hear from people. And as a result of some of the questions being asked, if I'm a litigant, if I'm a criminal defendant, a civil litigant, people are being asked if they've had contact with folks from other states. If the answer is yes, then what? Does that mean the litigant does not get a fair trial? The litigant is not allowed to be in the courtroom? These are questions I know you are grappling with, Judge Marks, but I just want to put them out there for you that need to be dealt with. The point is this: in speaking to judges, in speaking to attorneys, in talking to even litigants, in being there myself, observing what's happening, under the present circumstances, people will be barred from justice. People will be unable to have fair trials in the matters. And that's something I know we need to deal with. And so I'd ask if you want to comment on any of that. But the last point I have is Senator O'Mara's point. You know, to me, it's not charitable to help people with someone else's money. And that's what's happening in terms of the eviction issue. And we need to protect renters, yes. But in my community on Staten Island, we have many thousands of homeowners who own two-family homes. They live paycheck to paycheck themselves. And renters who are receiving, thanks to the federal government, as Senator O'Mara indicated, are receiving income through that program, are not paying rent because of the message being spread by politicians across the state. These homeowners want to know, and they've expressed their concern, when they don't go to court, are they going to be treated fairly? Thank you, Judge.
Can I, Senator Hoylman, can I just quickly respond? I mean, those are all real issues that you've raised. I can assure you we are addressing those issues as best we can. I think in large part, those are problems and issues that are being anticipated that haven't actually happened because we really haven't done trials. I mean, we've resumed a couple of criminal trials in the state. We've done a few bench civil trials, but we haven't really resumed conducting trials. So I'm sort of confused that there could be all these questions and problems that you're identifying because trials haven't really resumed yet. But I think what you're saying, you've identified and are anticipating, and the lawyers you've talked to and the judges that you're talking to are anticipating that these will be the problems once the trials resume. And I can assure you that all of those issues are issues that we're seriously thinking about and will address as best we can.
Thank you. Thank you, Judge Marks. We'll now turn to Senator Kevin Thomas. Senator Thomas has 3 minutes on the clock.
Thank you, Chairman, and thank you, Judge Marks, for coming in today. I have a few questions about the safety of our courts. So you stated in your testimony that all visitors and employees of the courts will have a temperature check done at the start of the day when they try to come in. Am I correct?
That's correct.
And what happens if the temperature check shows that they have something over 100?
They will not be permitted into the courthouse.
And are they given repeat temperature checks to get the temperature down if at a certain point at the door, the first temperature check, says, all right, you can't get in. They come back later with a lower temperature check. Will you let them in at that point?
That's the protocol. There'll be a second temperature check done. And if the temperature, registers under that threshold, then they'll be permitted in.
So, I don't know whether you know about an incident that took place in the Bronx where a court employee tried to get around that by sitting in their car with the AC on at full blast. And there was a lot of drama, that was involved there in permitting a court employee to enter a courthouse. And I'm really troubled that, there are ways of skirting the system, when we're trying to keep everyone safe. Now, let's say we open up the doors to litigants. So a litigant has a case and the litigant's temperature check comes back as over 100 and it does not go down. Will they be marked as default on their case for the day?
Absolutely not.
Is that policy now in place where once the courts reopen, that's what's going to happen? Because I haven't seen anything that says so.
That's absolutely the policy. The court officers will ensure that the judge who's handling the case, if we're talking about a litigant, that the litigant is involved with, that the judge will be notified of that, and no one will be penalized for being prohibited from coming into the courthouse and going to the courtroom where they register a temperature of 100 or higher.
What, in a circumstance where you have an order to show cause to vacate a default judgment because, the defendant has a frozen bank account, for example, and the plaintiff's attorney now is the one not allowed in, will that order to show cause be granted? Because the defendant is in and there is like a hardship there with a frozen bank account.
No, absolutely not. No one will be penalized or prejudiced because they're unable to enter the courthouse because of the temperature reading.
Judge, I just want to just end by saying this, I really don't have confidence right now in the courts in basically keeping people safe there, given that there are ways of getting around these temperature checks and having heavy pressure put on court officers when they try to stop certain employees from entering. So I would really like you to just, look into that. All right. Thank you so much.
We will do that.
Thank you, Senator Thomas. Since we have a few minutes left, Judge, and no other senators, I did want to recognize Senator Sepulveda has joined us, and as well, and Senator Ranzenhofer and Senator Kaplan are here too. So welcome. Since no one else has a question raised, I'll ask a question about Judge, on pro se litigants, particularly those in housing court, are they going to be given the opportunity to appear remotely? Because in New Jersey, I think, you know, that has been the case. At least they're headed toward that direction.
Absolutely. I mean, housing court of necessity, we're going to have to continue to rely. I would predict, and you know, circumstances change, and they have changed over the last 5 months, sometimes week to week. But I would predict that we in a court like housing court, with the tremendous volume that it has to deal with, that self-represented litigants that will have to rely, we will have to rely heavily on, continue to rely on virtual court appearances. And if self-represented litigants prefer to participate in the proceeding virtually, they
So
will be.
is that across the board? Across the board, these will be remote appearances?
Well, I can't tell you today, you know, what will happen or not happen with certainty a month and a half from now, because circumstances do change. But I can tell you, I have no doubt that we're going to have to rely heavily, continue to rely heavily on virtual proceedings in a court.
I think we could all fairly guess that a month and a half from now, we're going to be in the same situation, really, until there's a vaccine. I mean, that's seems to be the most consistent public health opinion at this point. So I guess my question is, why would we have anything but virtual court appearances?
Well, we've done some limited in-person trials in housing court starting in Brooklyn. And those are cases where everyone is on board with doing that. The lawyers, the litigants, the judge. Trials, I think for trials, generally speaking, are going to be handled more effectively in person than virtually, which isn't to say that we will not do virtual trials, but I think in housing court, we'll have to see, but there's no question we're going to have to continue a heavy reliance on virtual proceedings, probably including virtual trials in a court like the housing court.
And when we do have these virtual, these streaming trials, what are the technological challenges in allowing the press and public to view these?
We've set up a process by which the press and the public can observe, through our technology platform, can dial in, if you will, can access court proceedings remotely through our technology platform, and that will continue, certainly.
Because again, in New Jersey, virtual court proceedings that would otherwise be open to the public and press are streamed online for public viewing. I don't think that's the case in New York.
Correct? You mean through YouTube? I'm actually not familiar precisely.
Through any platform.
That's something we could look at. Giving the press access, or a member of the public, if they're interested, access to participate remotely, observe a remote court proceeding remotely, is an option that we've made available. But we'll take a look at what New Jersey is doing. We're always interested in what other states are doing.
Thank you. I appreciate that. And then finally, my last few seconds. Do you have a track and trace system set up? In other words, procedures to notify court employees if one of their colleagues or members of the public they've encountered might have tested positive for COVID-19? And are you looking to have rapid COVID-19 tests available for court employees?
Well, rapid testing is critical. I think everyone knows that. We are actually now in discussion. We've been doing the contact tracing ourselves, sort of internally, over the last several months. But we're actually
into this. Is it do you think you should be folding into the state's or the city's wider contact tracing efforts?
Yeah, the answer is yes, and we are in discussions with the executive branch, the governor's office, about being included in their contact tracing program. And we've also have had discussions with the city on that topic as well, to the extent that the city could supplement what the state program can do for us.
Thank you. Thank you, Judge. I'll now turn to Senator Kavanaugh for a few more questions. Chair Kavanaugh.
Thank you, Senator Hoylman, and thank you, Judge Marks. So can you talk a little bit, a lot of what goes on in court, in courthouses when they're open in person are informal processes like, clinics that are available for litigants to seek help, tabling, organizations like Housing Court Answers that provide advice to landlords as well as tenants. Is there any possibility that that kind of activity will be replicated virtually, and what can the courts do to facilitate that?
Well, those resources are invaluable in a court like the Housing Court, where although provision of lawyers is much higher than it used to be, still in a jurisdiction like New York City, roughly half of the tenants still represent themselves in housing court cases. So those resources are invaluable, and to the extent that that can be done virtually, we would be fully supportive of that. And to the extent that an in-courthouse presence is possible, and it may not be fully possible. It probably won't be fully possible, but it might be partially possible. We would be open to that as well, but we would be fully supportive and would very much would need the continued assistance of organizations and resources like that.
So I would urge you to the extent that things are happening in person, obviously to make space available to the extent possible, and to the extent they're happening virtually, just to think about effectively creating virtual space, some ability if somebody is being invited to participate in a virtual court proceeding, those resources are also discernible and ready available in the manner they might be if you walked into the building. Can you
Absolutely.
Sorry, go ahead. Let you respond.
No, I just said absolutely. I agree.
Great. In terms of, can you talk a little bit more about the challenges of non-English speakers and those who don't have good access to broadband or internet-connected devices?
Well, that's actually one of the great challenges of the self-represented participating in virtual proceedings, is that they often don't have a computer, they don't have internet access. It can be impossible. I mean, we've seen this on the criminal side, and certainly that's going to be a problem in housing court as well, and family court. Providing interpreting services in the 150 or so languages that people speak in New York City today is an enormous and extraordinary challenge in normal times. In a pandemic, it's even more challenging. We have been able to conduct virtual proceedings, particularly on the criminal side, in criminal cases, in arraignments and in court conferences in criminal cases, with the assistance, the online virtual assistance of court interpreters. So it can be done, it can work, but I'm not going to suggest that it's easy because, as I said, it's challenging even in normal times.
In most cases, in the criminal situation, people are represented by counsel, right? So
Correct.
it'd be probably the language challenges are compounded if there's not an attorney representing a participant in a civil matter like in the housing courts.
Unfortunately, that's true.
Right. Are there instances you're aware of where courts around the state have strayed from the kind of existing directives that you've issued, and how do you handle kind of clarifying or reinforcing the directives to the extent courts may not be getting the message?
Well, we're relying on our leadership this crisis has required leadership, strong leadership, and from the chief judge who's been an extraordinary leader over the last 5 months in this crisis, on down to our administrative judges and supervising judges, and it's an enormous operation, the state court system, across all 62 counties, with thousands of employees and judges and literally millions of cases. And what we've tried to achieve consistency and uniformity in the way that we've approached the handling of cases over the last 5 months. I believe it's been very successful, and that judges, court staff have bought into the direction that we've tried to provide centrally. But nothing is ever perfect, and when there are deviations, particularly counterproductive and negative deviations from the policies that we've issued, we rely on our local administrative judges, local supervising judges to address that and to correct that.
Okay, I see my time is up, but so again, I'll just take a moment again to thank you for being with us and for all of your leadership during this very, challenging time for the courts and really for all of our institutions. So thank you.
Thank you.
Yes, and that's worth acknowledging that Judge Marks did appear today, even though he's being personally named in lawsuits. So we do appreciate that, Judge. Senator Ranzenhofer has 3 minutes on the clock. Senator? You're muted, Senator.
How's that?
Perfect.
Okay. Good morning, Judge Marks. Thanks for being here today. In my short time, I have a couple of questions. My first question is, very often when you have proceedings, everybody shows up at the same time. They're all scheduled for 9:30, 10 o'clock, or 2 o'clock. What is being done to encourage judges to time their proceedings so people are not on top of each other?
Well, virtual is
In person,
in
not
person.
virtual.
The policy that we've endorsed and are executing is to give cases, to give lawyers and litigants who have a court appearance, to give them a time certain. And so that you don't have these large calendar calls. And we don't have these large calendar calls right now, and we can't possibly have large calendar calls right now. So the limited in-person proceedings, and they are limited, along with the virtual proceedings, with the limited in-person proceedings, the policy is to designate an appearance time. And that's worked well because the number of in-person proceedings has been limited. So as we expand the number of in-person proceedings, that will become more challenging. But during a pandemic, we can't have those high volume cattle call calendars, if you will. It's just in violation of every health protocol, that's been issued during the pandemic, and it's just not acceptable, and it's not going to work during the duration of the pandemic.
Thank you. Now, there was a question earlier about people being tested for COVID. Do you have a rate of percentage of the people that are appearing in court? Have there been any or many people that have tested positive for COVID among the court staffs?
Over the last 5 months, there's been about 200 court employees and judges who have tested positive for COVID. Of course, we require them to report that to us for obvious reasons, but the number is about 200 across the state.
How many from the court system and how many from other sources?
200 from the court system.
How many contracted it from being in court as opposed to being out to dinner and contracting it?
Well, that's a good question, because in the end, nobody knows that for sure. So of the 200, how many became infected from reporting to work, being on the job? It's impossible to say, other than a significant number, because we're not at full staffing, obviously, and a significant number of people who've reported that they tested positive. We also know the last day they were in the courthouse, and if it was 3 weeks before the day or 4 weeks before the day that they tested positive, which is true for a lot of these situations, it's pretty clear that they didn't contract the virus while on the job in the courthouse.
Thank you. Let me just make one last comment. I just want to let you know that in my personal experience, courts are not doing temperature checks, although they've been open. Not all judges are wearing masks in the, say, 6 weeks or 8 weeks that I've seen. But I will tell you that the judges and the law clerks are doing a very good job of moving their calendars by doing Skype, telephone conferences. That part has been working very well.
Well,
Thank you.
Thank you, Senator Grasshopper.
But judges and staff have to wear masks and have to undergo temperature checks. And if I may, I would like to follow up with you on that.
Sure.
Thank you, Judge. Senator Thomas had one a couple of follow-up questions, if that's okay, Judge Marks?
Sure.
Senator Thomas. And I'd like to also recognize that we've been joined by Senator Betty Little.
Hi, Judge. Sorry for round two. Quick question here. I'm hearing a lot of complaints about the courts not being cleaned thoroughly. Do you know, how often courts have a deep cleaning? About regular cleaning in general, because I'm hearing a lot of complaints about the offices and the courtrooms not being cleaned in a regular fashion.
As I think you know, although not everyone may know, we're a state court system, but the courthouses we operate in, at least the trial courthouses, are not state buildings. They are local government buildings. They're county buildings outside the city of New York, and they're New York City owned and maintained buildings within the city of New York. And they're responsible for cleaning the courthouses. But we've been very satisfied with, in general, with the extent of the cleaning that has been done by county agencies or the DCAS agency in New York City. No system is perfect. And, of course, we want to know when there are problems, and cleaning is an important part and one of the important protocols and the steps and the measures that we've taken.
Judge, I get that, but during this type of pandemic that we have, I'm hearing complaints from law clerks that they see dead roaches here and there. It's never cleaned up. There is inadequate cleaning, and there are even deliveries, food deliveries being handled through the courthouses. They're not supposed to be coming in, but they're walking the hall. So these are the kind of things that the court system should have some policy on, even though they're owned or operated by the county or the city. You should have some say in how often they clean the courthouse, because we're going to be letting litigants in, and we don't want to have a cluster come out of that area. So I would just recommend that you look into this as well, please.
I'll look into it, but I can tell you with assurance that the level of cleaning in courthouses throughout the state has risen during the pandemic. If there are individual problems in certain courthouses in certain counties, we can look into that and address that as best we can.
All right,
But
thank you, Judge.
overall, there is more cleaning being done in courthouses than pre-pandemic.
Got it. Thank you.
Thank you, Senator Thomas. If I could just close with one more question for you, Judge Marks. God forbid we have a second wave. I was just wondering, do you or your epidemiologists that you have contracted with, do you have a percentage, like rate of positive cases, much like, say, the governor might have around schools in the state of New York, 5%, then they have to shut if that rate is reached. Have you set a kind of threshold, and have you shared that with your employees?
We haven't set our own independent threshold. Throughout this public health crisis, we've followed the lead of the governor, particularly the state of emergency and the executive orders shutting down operations and the reopening of economies through the phases. We've tried to follow that, if not in lockstep. We've tried to follow that very carefully. And if, as you say, God forbid, if there's a resurgence in New York and we have to scale back again, as we did, we will follow the governor's lead on that.
Okay, thank you. I think it might be worth checking with your epidemiologist as to what that threshold might be, and to give the public, litigants, your thousands of employees some sense of what the chart forward might look. That's just my perspective on how helpful it's been that we've had these thresholds for the public to try to understand closures better.
That's something we can certainly look into.
Well, I think we don't have any further questions for you, Judge, and I do appreciate you taking the number of questions that you did. I wanted to thank all of my colleagues and mostly thank you for your appearance this morning.
Great. Good to see everyone. Thank
Any
you.
closing remarks you'd like to share with us?
No, I mean, just other than this has been an extraordinary challenge for all of us in the court system. I think we've done well. Nothing is ever perfect. I'm repeating myself with that slogan and cliche, but we've worked extraordinarily hard. We're very proud. The Chief Judge and I are very proud of the entire court system, our judges, our employees, we realize that that society can't survive without a functioning court system. That's become very clear as it's ever been during this pandemic, and we'll continue to try to do the best we can. And of course, the support of the legislature and our efforts is always welcome. So thank you.
Thank you very much, Judge.
Thank you, Judge.
So as Judge Marks exits the Zoom, we'll be assembling our next Zoom panel, which consists of 3 individuals. I believe they're here. They're appearing, yes. We have Honorable Alan Beckoff, President of the New York State Family Court Judges Association. We have Honorable Joseph Latouin, President of the New York State Association of City Court Judges, and Honorable Danielle Chania, President of the Housing Court Judges Association. Hello.
Good morning. Am I being heard? Can you hear me?
Yes.
You are. And
Okay, great.
Judge
Thank you. Good morning.
Judge Beckoff,
Yes,
you're up first, and 5 minutes on the clock.
well, I'm the president of the New York State Family Court Judges Association. As you said, we have about 180 judges statewide. The family court never closed. I didn't hear the beginning of Judge Marks's comments, but family court sort of phased out operations in March, meaning we're only dealing with emergency hearings, and we've been phasing back in again. And what's really needed, obviously, is technology to do this and to keep this going. I should point out that the family court was one of the first, and maybe still the only court that has gone virtually digital. That was about 4 or 5 years ago. So all of our records, files, things like that are all digital. So we were able to have almost no interruption in operation because we didn't have paper files, hard files that had to be moved around, transferred. Everybody was just able to access all the records online, and in terms of files, papers, exhibits, things like that. Obviously, investment in technology is vital to keep this going should any kind of interruption happen again. Everything we're doing is obviously by Skype, Skype for Business. We're transitioning to Microsoft Teams shortly, I understand. The clerks and the judges and referees and magistrates pretty much have the equipment they need, but I understand that maybe more of the clerks actually need more of this equipment and licensing of equipment and licensing of VPN and software and all to be able to still work remotely, and they've been able to keep up with that. We have a lot of the clerk support staff is still working remotely from home. judges like me are in the building because they want to, I guess, not have everybody come in at once whenever the court reopens. So I've been doing everything virtually from my chambers or even from my courtroom sometimes. The problem that we've been having a lot is with the public being able to participate in these proceedings. A lot of the public, especially the kind of litigants we deal with, don't have the latest, software in their phone or their computer to be able to join Skype for Business. And a lot of the things we do, especially, for instance, let's say in delinquency hearings, require a personal, when I say personal, and a visual appearance, so we know who they're talking about, especially when you have identification being an issue. And I've had lawyers hold up their clients, hold up their phones showing FaceTime, saying they have their client on FaceTime because their client can't join into the Skype for Business. So I think OCA should look into expanding the ability for the public to not just have to go to one central location or into the courthouse possibly to do anything remotely, but if there was, say, public buildings that are beginning to reopen, libraries or community centers that maybe can have some kind of isolated space, members of the public to be able to have equipment that they can join in their proceedings in a virtual manner. And the other thing I just wanted to say in my limited time here is that it's very important to not only to the public, but to all the court staff, judges, and all the court staff to have transparency about the way the facilities, the courthouse is being made safe. I see that the cleaning staff is working much more diligently than normal to keep the courthouse clean. But I think that everybody, would like to know if, say, the State Department of Health or the local Department of Health would have a publicly available report certifying how the buildings are being cleaned and maintained. So I think that's all I really wanted to say in terms of my remarks. I'm sure if there are any questions, I'd be happy to answer them.
Thank you, Judge. We'll hear from the next panelist, but I forgot to ask the question of whether each of you swear or affirm that the testimony you're about to give is true.
Yes.
Thank you. Now, thank you, Judge. And now we'll hear from Judge Chania. Thank you.
Hi, and to answer your question, yes, the testimony I will give will be true and accurate. So good morning. Thank you to the Senate Standing Committees on the Judiciary, Codes, Housing Construction, and Community Development for organizing this hearing and for your interest in these issues. I am the president of the Housing Court Judges Association. As you know, I submitted written testimony, which is publicly available. Because of comments I have received in response to that testimony, I'm going to depart from my prepared testimony to make sure that my point in appearing here is clear. I have not appeared to advocate for any particular policy or any particular interest group other than my 50 judges. I'm here requesting a robust, coordinated response to the tragedy in housing that is affecting us all. I'm here to present the practical reality of our situation and to tell you that it is unworkable. The pandemic is ongoing and with no end in sight. The economic impacts are only beginning to be felt and will continue for years to come. Yet we, the Housing Court judges, are being asked to conduct business as usual in terms of applying the law and exercising our discretion. Exercising discretion must be based upon a solid foundation in the law and with an understandable set of parameters in which to weigh factors and make decisions. The prior structure has been obliterated. How can we exercise discretion in a post-COVID environment with a pre-COVID structure? What are the parameters for deciding whose tragedy is worse? For instance, a likely scenario we will face is a landlord makes a motion seeking to execute on one of the 14,500 active warrants currently stayed. The tenant responds. They have already agreed to a debt. They have already agreed to be evicted if they don't pay that debt. Now they owe several more months and maybe have no plan for how they're going to pay ongoing rent. The landlord is faced with mounting debt and no clear or documentable way of paying it. Maybe the respondent lost their job, or worse, a relative who used to contribute to the household expenses. How is that tenant to know when the next job will come, or how they will ever make ends meet without their loved one? As a judge, how can I weigh this personal tragedy against an ever-mounting unsecured debt obligation being forced upon the landlord? Without a coordinated plan, how can I assure the landlord that they will ever get their money? On what legal basis do I require a landlord to continue to accept these losses? Whose struggle shall I continue? Whose shall I alleviate at the pain of the other? This is a natural disaster, a global pandemic. The effects are ongoing, far-reaching. It has upended everything. Pre-COVID calculations are no longer applicable. What is the new calculus? We need a structure from which to operate, a solid foundation from which to work. This is not about our personal opinions or sympathies. We need you, the legislature, and the executive to make a plan. We are 50 people. We are facing 14,500 open warrants, 200,000 pre-pandemic cases that have not yet been heard. 1 in 5 tenants have not paid rent for April through June. That could be well over 1 million people. We are currently at a maximum capacity of 10 Skype appearances per day per judge. The math is unassailable. 50 housing court judges cannot solve this problem for New Yorkers. The limitations are real and must be considered. I am not suggesting here that you, the legislature, are not working. Clearly you are. I know bills are pending, and the Tenant Safe Harbor Act was a valiant attempt to stem the tide. I am only saying that 50 housing court judges cannot right this ship. One that creates an equitable resolution to this crisis, one where the pain and the cure are distributed equally. Asking 50 judges to adjudicate this nightmare on a case-by-case basis is not a solution, and we need a solution. Thank you for your time today, and I'm happy to answer any questions. And if you like, with my last 30 seconds, I can touch on some of my issues regarding facilities that are mentioned in my written testimony. Thank you for your attention.
Please do for your next 30 seconds. We'd like to hear
Sure.
that.
So the issues regarding facilities operation, and I do want to note that I recognize the enormous task being put upon OCA and UCS in reopening the facilities, but I feel that there is overall a lack of effective communication. And I also think the use of PPE and protecting certain areas of the courthouse are not being adequately addressed. For instance, there is no plan to clean technical equipment, specifically microphones. We will be asking witnesses to share microphones, and we have no way of maintaining their cleanliness at this time. There's much more I could say, but I will stop there. Thank you so much.
Thank you so much, Judge. Much appreciated and very, very important insight. Next, we'll hear from the Honorable Joseph Ladwin, President of the New York State Association of City Judges. Judge, 5 minutes on the clock.
I swear. Thank you for inviting me. I'm Joe Latwin, full-time judge of the Rice City Court. I'm the president of the New York State Association of City Court Judges, representing over 170 full and part-time judges that sit in our state's 61 city courts outside of the city of New York. Our members sit in cities from Long Island to Plattsburgh, from Buffalo to Albany, from big cities like Rochester to small cities like Sherrill, from suburbs like Mount Vernon to rural areas like Oneonta, and every city in between. We're often the only court most New Yorkers will ever see, and because of our close relationship with the people, we affect the lives of real people. These comments are my own and not the association or that of any particular individual city court judge. Currently, the legislature passes laws and sets the parameters under which we adjudicate cases. We apply those laws in those particular cases. The legislature does not get involved in individual cases. It simply sets the ground rules. It doesn't call the balls and strikes. City courts are in widely diverse cities with different needs and different resources. It makes little sense to impose a uniform mandate on every court where individual circumstances may not warrant it. Mount Vernon is not Rye, the Bronx is not Batavia, Manhattan is not Mechanicville, and Brooklyn is not Binghamton. We have very different types and varying volumes of cases. One size does simply not fit all. You would be wise to do the same concerning the operations of the court. Set the parameters, wear masks, keep distance, take temperatures, ask questions about exposure. Set the ground rules and allow the commanders on the ground to implement the rules so they can operate efficiently under the particular circumstances. You've vested city court judges with the power to deprive people of their liberty and property. We take these great responsibilities seriously. It's incongruous for you to grant judges such great power and then treat them like children and micromanage them, depriving them of the power to efficiently run their courts. Look what happened when Chief Judge DiFiore established standards and goals for the disposition of cases. She set up the rules, and the court stepped up and greatly reduced the time during which cases were pending. New York took the hard steps to flatten the coronavirus curve. By delaying adjudication of certain cases, we are not flattening the curve. Instead, we're damming the river, which once the gates are open or the dam breaks, will flood. All we've done is delay and deny justice. In sum, set the parameters and let us operate within those parameters so we can efficiently manage our caseload. And I'd like to address some of the questions that were unanswered. With respect to having people waiting, the court system has set up a QR reader, so people, when they come to the front door, can log in, and then we can notify them when to come back for their testimony or appearance. And they can either wait outside or wait in their car. We've staggered our calendars. We've kept our cases at least 15 minutes apart, so we have no more than one case going on and the appropriate people for that case there. There are certain cases that absolutely require in-person attendance. In a criminal case where you need fingerprints and they haven't been taken, the defendant has to be there. In drug courts where testing is required, or you need to know if that person has the smell of alcohol on them, you can't do that remotely. In DWI cases where a license has to be surrendered, can't pass the license through the computer. We have to take pleas and impose sentences in person. The other thing that virtual appearances make tough is settlements. We're no longer able to do shuttle diplomacy by having one person stand in one room and another in the other and go back and forth negotiating between them. We can't have the parties go out in the hall and talk to themselves if they're not there. The other thing that this has come up is that by delaying jury trials, many defendants are now asking for jury trials simply to delay the cases. And you're going to create a great backlog. One of the suggestions of the local courts advisory committee of Judge Marks has been to use the practice in New York City and do away with jury trials for B misdemeanors and below. That would limit the amount of jury trials that you're going to have, limit the number of jurors that come to court, and eliminate that delay. Thank you for the opportunity, and I'm happy to answer any questions.
Thank you, Judge. I have a couple of questions in my allotted time. Judge Chania, thank you for that, really powerful assessment of where we are. What are the levels of stress that you and your fellow housing court judges are over, given the lack of clarity around evictions?
Well, right now, I think our stress is mostly around trying to figure out how to operate, but it won't be long before we're being faced with these motions and these decisions. We're still just focusing on essential matters and setting our trial and resolution calendars based on the open cases we had pre-pandemic, but the motions can be filed anytime. They are coming. They're a little bit delayed because we've put in place NYSIF in New York and Brooklyn, which means that cases have to be opened electronically, so there's some delay. The stress that we're feeling is mostly this anticipated stress, this feeling of an impending position that will be put in where the decision is, it just doesn't feel like it can fairly be made under the circumstances. So the stress is mostly anticipated.
In other words, there should be a public policy goal outlined for you as a judge to try to reach.
Well, I would say the public policy goal is out there publicly on every news station. We do not want evictions. We do not want more homeless people. We can't afford to keep putting people in hotels. That's the policy coming. What I'm saying is the court opening and conducting these cases with this unsettled parameters for our discretion puts us, the courts, at loggerheads with the legislature and the executive. How are we supposed to mend this fence? Housing court judges are very good at weighing disparate impacts. We do it all the time. What I'm merely saying is under this new world, the disparate impact is extreme. It's beyond something that we can just create. For instance, normally, if I'm faced with a situation where I'm to use my discretion to determine whether to allow someone to be evicted or have more time to pay their debt, I would ask questions like, are you working? When will you get a job? Are you looking for work? These questions can't even be answered right now. If someone doesn't have a job, how can they assure me they will have a job shortly? We don't even know when there'll be work. So I just feel like our old system, our old way of handling these disparate claims and disparate impacts does not apply in this situation. And what I'm asking for is a legislative and executive and political solution, something that is either a controlled debt reduction where tenants' debts are reduced and landlords' mortgage debts are equally reduced. And banks are told they either have to eat it or that the government will give them money to stem the tide of banks losing money when mortgages aren't paid. My point is this isn't something that can be fixed on the one-off, tenant by tenant, landlord by landlord by 50 people. It's over 1 million cases. It needs to be determined on a grander scale, something more coordinated and something more directed at relieving the pain that everyone is feeling.
And thank you. And we hear you on that. And I know Senator Kavanaugh understands that very well. And that's why he's introduced, along with Senator Meyer, some very bills that go directly to what you're suggesting. One more quick question. What can housing court judges do to try to facilitate negotiations between tenants and landlords, whether they're residential tenants or commercial ones? Under some sort of reasonable payment plan. Is that something you would look to do, or do you need further guidance on that?
Well, for myself, I'll say, first of all, just to be clear, we don't deal with the commercial evictions, we only residential. Right now, when we're settling cases, it is difficult to negotiate. It's a difficult negotiating space, but it honestly depends on the willingness of the parties to accept loss. So the landlords have to be willing to accept the fact that they're not going to get 100%, and the tenants have to accept the fact that no matter how much they're struggling, a home is of value and there has to be some value attached to it. When people don't want to work together, our hands are very much tied right now.
Thank you. Senator Kavanaugh, I imagine you have some questions.
Yes, I do. Thank you. Thank you very much. Thank you to the panel, to all of you for, again, your leadership in your respective spheres and for being with us today. I want to particularly focus on the housing situation. We had testimony before. There are about 200,000 pre-COVID cases. In your experience, can you just give us a sense of how 200,000 cases are likely to break down in terms of their status? And I recognize you probably don't have access to sort of clean data on this, but just if the 200,000 cases, how many of them would be expected to end in an order of eviction if they proceeded in the normal way? How many might be settled? What is that activity likely to look like if it proceeds?
Well, I would say some of that depends on our ability to conduct trials. Trials are generally the stick with which we push for negotiations. So if trials can continue, then negotiations continue. I would say that here's where we are. we are at a point where we've tried to clear our backlog of things that were ongoing. We have 14,500 warrant cases which will be heard. We're dealing with our 2 attorney pending cases. There is a set of cases where the respondents are unrepresented. We have not touched those because we are unclear yet on how we're going to deal with the pro ses. The way it's working is we're going to deal with our open cases and these motions to execute on warrants, then the pro se cases, then the 200,000 open pending cases, then the new cases that will be filed. So I would say the pending, non-payment, and holdover cases will probably start to come on the calendar around the end of the year, and can expect, if we can move up from 10 Skypes a day to something more manageable, maybe 20, I have no idea. Then we're talking about what? Maybe a whole year before we would get through those. And how well we get through them depends on the appetite for settlement. Obviously, going to trial will slow everything down. If people can settle, that will speed things up. Part of settlement is going to be about how's the money going to get paid. And in part, that's going to fall again to you all on where does the funding come from? What's the structure? What are the requirements for people to qualify? Are they going to be the same requirements as pre-COVID? HRA requirements pre-COVID would not help the people post-COVID because non-possessory judgments generally don't qualify for HRA one-shot assistance. And if tenants can't establish that they can pay ongoing rent, they also don't qualify for a rental arrears assistance. So many of the people we're faced may not have that available to them.
Yeah, I saw that in your written turn, so the comment that the Safe Harbor Act, because it protects people from possessory judgments, wouldn't be normally the basis for somebody being found to be facing eviction. Has HRA or the city or the Department of Social Services opined on that issue, to your knowledge?
I'm sure they have, but not to me.
Okay, so that's a question we might want to direct to them, how that's gonna play out and whether they need some further
I
clarification.
could direct you to, we have a citywide supervisor, Jean Schneider. She's probably more involved in the policy negotiation. I'm just here as a judge on the ground.
Okay, well, we appreciate you being here. You raise in your testimony due process concerns about virtual trials. Can you expand on that a bit more?
Sure. So due process, I'll take a pretty easy example is interpretation services. So I have a case that I'm asking to come to trial. The respondent has preconditions that make him at risk. So they've asked that he be accommodated, not have to come in person to the courthouse, which of course I would do, and petitioner's counsel agreed. But then it turns out that he needs a Spanish interpreter. And also the landlord, the tenant's attorney wishes not to come in person because he is to be married soon and would like not to be infected with COVID and not be able to get married, which is also very reasonable. But now I'm faced with a situation where I'm going to have a respondent's attorney remotely in one location, a respondent in another location, a Spanish interpreter. I'm not exactly clear where they will be. I'm assuming they'll be in the courtroom with me. Petitioner's counsel will be in the courtroom with me. Petitioner's witness will be in the courtroom with me. So I have to manage and make sure everyone understands and hears. I'm not exactly 100% on how we're going to show documentation. So, you know, it's a new world and we will try to navigate it.
Okay, I see my time's up. I may have further questions, but I yield my time for now. Thank you.
Sure.
Thank you very much. We're going to move on. I guess we could do another quick round. Judge Beckhoff, I had a quick question because no other senators have questions. So I will ask you, my office has received questions about constituents, how to handle child custody arrangements during the pandemic, particularly as parents might be moving to different parts of the state or the country that are more remote. Has the family court provided guidance for best practices for parents on how to handle child custody in a pandemic?
I personally don't do custody and visitation cases. I don't know how much guidance the judges have been given, at least in New York City. I mean, I sit in Brooklyn. We have been dealing mainly with what I'm calling, for lack of a better term, emergency situations. So I think if there is a typical, custody case that involves a parent relocating, I don't think those cases are being given the same kind of preference unless the parent really, is got to move immediately. We're dealing more with custody and visitation issues and all issues that involve really exigent circumstances that have to be addressed now. So to answer your question, I'm not sure what kind of guidance is being given. All I know is that, again, priority is being given to cases that can't wait.
Okay, well, just to, if you could seek some guidance for our constituents who have questions about this issue, I think that'd be appreciated.
Well, I can get some better answers from my colleagues who do those kinds of cases and send in a submission later on.
And I think it's fair to say that families in court proceedings would almost always consider their cases essential. But I understand.
It's a matter of triage. What we have to do is triage.
Are you concerned at all that there aren't important cases being heard because they don't, meet your triage standards?
I think the cases that are being heard that are given the importance involve, for instance, in child abuse neglect cases, if there's a removal to foster care or an order that would potentially put a parent out of the home. With delinquency cases, the priority is being given to cases involving remand to detention, as opposed to just being released. And for custody and visitation cases and support cases, again, priority is being given to the cases that can't wait, that involve, again, some kind of exigent circumstance that has to be dealt with immediately. The child support cases, again, we had, I don't know how many cases, I can't give you the figures, where child support orders have been in effect suspended, if not literally suspended. We had warrants, open warrants on parents not paying child support. Those warrants have basically been suspended. So I think once court resumes more and more operation, those kinds of cases, especially some of the child support, is going to have to be dealt with, because now obviously you'll have parents who have not had income in the last few months. So once the court reopens or opens more broadly, there's going to be a lot of catch up to get those cases done.
Thank you, Judge. We don't have any other senators with questions, unless Senator Kavanaugh has one quick follow-up. Senator, a brief follow-up for Judge Chania, I assume.
Yeah, I would like to, if I may. Judge, you mentioned in your written testimony this issue of, you say that tenants in the laws we passed must establish a hardship, including some of that's also referenced in some of the executive orders, but that landlords don't have a reciprocal burden to establish urgency or need. And you suggest, I think you're suggesting in your written testimony that means there's little incentive for landlords to negotiate. I think it also may go to the question of whether how the courts would choose to prioritize these cases. Can you elaborate a little bit on that point?
Well, I guess what I would say is there are definitely landlords, perhaps the small landlords who own 2-family houses or 4-family houses, who really depend on their rental income to survive and pay their mortgage. I would say those types of people should rise to the top in terms of how we deal with this. We also know that after the 2008 foreclosure crisis, that many landlords are now corporate and were bought through equity back then when everything was depressed. And now these corporate landlords have the same opportunity as these small landlords to seek their money. So I think in order to better prioritize our time and our efforts, it would be beneficial for landlords to show their need and their urgency.
As a part of the basis for making their case, and also perhaps for prioritizing cases?
Correct.
Okay, that's something I think we can look into legislatively. Just, I asked Judge Marks some of these questions, but just your perspective on kind of the informal aspects of things that go on in housing court, the clinics, the tabling, and all the sort of informal advice that landlords and tenants, especially I think unrepresented tenants, benefit from that. Can you talk about the prospects for incorporating that into the work if cases are going to be virtual?
First of all, something is going crazy. Can you hear that? Is that disruptive to you?
I can hear it, but it's not too bad on our end.
So in terms of the assistance, it has moved virtually, and our help desk, our help center for pro se tenants is still open virtually. So tenants can still call and get help if needed. They can still reach out to Housing Court Answers in a virtual way to try to get the assistance needed. But yes, I would say, and I think anyone would agree with this, teachers, anyone, that we're a social beings and we are used to doing things in a certain kind of way, and this way is not as effective, and this way is not as efficient, and it's difficult. So I would say that there has been much effort to make sure that tenants still have resources to learn the law and to learn their rights.
Great. Okay, well, a lot more to talk about, but given the length of our witness list, and we've taken up a lot of all of your time, I'll just end by saying I appreciate all three of you for joining us today and for all of your insights. So thank you.
Thank you.
Thank you very much.
Thank you, Senator Kavanaugh. We're now going to bring on and thank you, panelists. Thank you, judges.
Thank you.
Everyone. And sorry, Judge Latwin, that we didn't have any questions for you. Your testimony was so comprehensive that we had nothing to ask. Thank you very much. Our next panel, panel 3, if they could assemble, we will be hearing from Kevin Stadelmayer, the Legislative Committee Chair of the New York State Association of Criminal Defense Lawyers, Tina Luengo, the Attorney in Charge, Criminal Defense Practice at the Legal Aid Society, and Sandra Dorley, Monroe County District Attorney and President of the District Attorneys Association of New York. I think everyone is present, and I will ask each of you collectively, do you swear or affirm that the testimony you're about to give is true?
Yes.
Yes.
Thank you. Thank you. And if
Yes.
Mr. Stadelmayer could go first, please.
Thank you, Senator. Good afternoon. My name is Kevin Stadelmayer. I'm the Chief Attorney of the Criminal Defense Unit for the Legal Aid Bureau of Buffalo, and I'm also a board member and the chairperson of the Legislative and Lobbying Committee of the New York State Association of Criminal Defense Lawyers. As an initial matter, I want to thank the standing committees for providing this forum to allow exploration of court reopening during these unprecedented times. The Unified Court System, the Office of Court Administration, and all judges, staff, attorneys, and litigants have a joint responsibility to ensure that due process and court access is maintained while concurrently remaining laser focused on ensuring that those ideals are accomplished in the safest manner possible and with the maintenance of community health at the forefront. As my expertise falls within the criminal defense realm, I'd like to focus on 3 areas where improvement can be made in ensuring access and due process while maintaining safety. Currently, the governor, by executive order and not legislative action, has paused important sections of the criminal procedure law. These include CPL 3030, CPL 245, CPL 17070, among others. Although tolling of CPL 18080 governing time in pretrial custody prior to preliminary hearings and CPL 190 regarding impaneling of grand juries have recently been lifted, there remain serious concerns relevant to the other paused sections. Substantial prejudice has and will continue to result until this executive order is lifted. In total, in general, we respectfully call for the immediate lifting of this order. Specific concerns relevant to these pause provisions are the focus of this testimony. First, the pause of the Criminal Procedure Law 3030 must end immediately. Since March 21st, 2020, the mandates of CPL speedy trial law have been told. This, along with the recent wrong-headed and disappointing rollback of the historic bail reforms implemented in January 2020, have resulted in a great many persons being held needlessly in pretrial custody, awaiting further court action. Although district attorneys have begun impaneling grand juries, the provisions of CPL 3030 have not been restarted. All time in a defendant's criminal case has been told since March 21st. This tolling has de-incentivized prosecution as well as provision of discovery under CPL 245, as there is no external pressure to adjudicate cases. Presently, district attorneys are not bound by the current timing mandates for provision of discovery under CPL 245. Although discovery is being provided where necessary to secure disposition, it is being done for that purpose and that purpose only. Regular statutory mandated provision of discovery is non-existent due to the governor's executive order. Although superior courts have begun limited reopening across the state, prosecutors and judges have been allowed to pick and choose those cases which they felt were ripe for disposition, instead of prudently focusing on those cases upon a time and pretrial detention model. However, given the fact that grand juries have restarted and the superior courts have developed protocols to reopen and hold limited in-person appearances with substantial safety protocols in place, the restarting of 30/30 must occur. To allow further delay in this restart is to deny a multitude of defendants held pretrial the right of due process. Second, although the provisions of CPL 18080 have restarted, mandating felony hearings be held within 120 or 144 hours after arrest, its sister provision, CPL 17070, dealing with unconverted misdemeanor complaints, is not. Again, with far more misdemeanor offenses now being eligible for cash bail, a great number of defendants have been held in jail far longer than they ever would have been in pre-pandemic times. While a mechanism exists to have felonies brought before the court to be handled under the auspices of the preliminary hearing scheme outlined in CPL 18080, no automatic relief is currently available to those clients incarcerated pretrial on unconverted misdemeanor complaints. This inequity must be rectified immediately. CPL 17070 must be restarted to review and adjudicate those defendants held in custody pretrial on unconverted misdemeanor complaints. Finally, the court must seriously consider the impacts of reopening the courts and scheduling non-essential matters in person. The vast majority of criminal appearances by a defendant are uneventful. Many are simply status, scheduling, or case review conferences between the DA, judge, and defense counsel. The defendant's appearances are largely window dressing and are done typically so the judge can test the defendant's level of commitment to their case and their adherence to non-monetary bail conditions. Pre-COVID, there were also a great many compliance type appearances scheduled simply for the purpose of checking a defendant's adherence to post-sentencing mandates such as drug treatment, participating in domestic violence counseling, and the like. Where a defendant was compliant, those appearances were absolutely unnecessary, yet were nevertheless held. Those constitute the majority of those appearances. The combined number of these non-essential proceedings served in pre-pandemic times to overload court dockets and unnecessarily force crowded courtrooms. Given the new order of things, this can no longer be the norm. Accordingly, we are calling on the courts in this body to be mindful of safety and considering whether these non-essential proceedings require the appearance of the defendant. In our view, unless it is for arraignment, hearing, trial, sentencing, or post-sentencing noncompliance, the defendant need not appear. The court should defer to defense counsel and the prosecution in determining whether defendant's appearance is necessary. If the court feels so inclined, the technology is available to allow defendants and counsel in many circumstances to appear virtually for these proceedings. The effect could be dramatically reduced traffic in court, and the resultant social distancing will continue to allow New York State to maintain its extremely low rate of community spread. In short, we appreciate the dilemma the courts face, attempting to balance safety with due process. However, in examining the above issues, it is clear that further work is required. The courts, with proper precautions and practical considerations in mind, can provide further access and due process while at the same time protecting parties from exposure to COVID-19. Thank you for giving me the opportunity to speak today. I greatly appreciate it.
Thank you very much, Mr. Saddlemeyer. We'll next hear from Tina Luongo, the attorney in charge of criminal defense practice at the Legal Aid Society.
Good afternoon, and thank you very much for having this critically important hearing. There is nobody who can deny that COVID-19 has devastated Black, brown, poor communities. And those are the same communities that day in, day out come to our criminal justice system being prosecuted and over-policed. And it is against that backdrop that the Legal Aid Society, the public defenders organizations in New York City, and in fact, throughout this state, have worked since the very day of the announcement that this pandemic was coming to New York City to call upon a proactive, planned, focused, communicated, accountable, and transparent plan to have our clients have their due process while also ensuring the health and safety of not only our clients, but everybody who are stakeholders in our court systems. It is also against that backdrop that we have been disappointed in the lack of a plan, written, transparent, communicated, coordinated by OCA and by the City of New York in terms of the Department of City Administrative Services, DCAS, the people who are to keep our courts clean and to keep our filtration systems up to date and with New York State standards. It is against that backdrop that the public defenders had no choice but to actually mount a litigation. And while that litigation has come to a close based on jurisdiction, the principles are still true, that we must move forward together, recognizing, yes, that there is an unprecedented backlog of criminal matters. And yes, exactly what my colleague Kevin has just said, that the suspension of the executive orders have kept people languishing with their cases pending, both incarcerated clients and those out who are suffering enormous consequences such as suspension of jobs and licenses. And the fact remains that we are, in fact, litigating matters and have since day one. I think Judge Marks testified that 47,000 people have been arraigned in our court systems since the pause. And in fact, it was a pause, but here we are faced with what has been a pivot from actually developing the remote practices that were promised by the court and actually moving to in-person. And while I agree, we all agree as public defenders that our clients deserve the right to litigate their matters and litigate them effectively, what we are seeing in New York City is, in fact, the calendaring of non-essential matters with no notice. Routinely, our attorneys are being told the day before or 2 days before when their client and they are due in court. We are seeing that despite time certain calendaring, cases are called before the lawyer gets there and before the client gets there to report on their time certain because the court wants to move it along. That in fact, while I believe that Judge Marks and OCA believes that they have a thorough accommodation practice and policy, it falls short, and I'll give an example. We have asked for an accommodation for a client with HIV, who is HIV positive and was symptomatic with COVID, and it was denied. And that person had to come to court because they were ordered to do so, and was led into court by the same people screening at the front door. And then, only then when they reached the court and a court officer recognized that that person was not feeling well, had that person leave and the matter was adjourned. That in fact, when lawyers in our office have asked for accommodations because they themselves are facing medical vulnerabilities, the answer to the court is simply, you're excused, but send your colleague. That is not the planning and accountability our court system should have. And I am astonished and shocked that the epidemiologist hired by the court system hasn't toured or produced a report. And that is what is needed to move forward. We will have written testimony with recommendations, but I thank you for your time right now.
Thank you so much, Ms. Luengo. Next, we'll hear from Sandra Dorley, the Monroe County District Attorney and the President of the District Attorneys Association of New York. Thank you, Sandra.
Thank you and good afternoon. And again, my name is Sandra Dorley and I'm the Monroe County District Attorney, and I'm the current President of the District Attorneys Association of the State of New York. And first of all, thank you to Senator Hoylman and Senator Bailey and to all of the senators and staff for your dedication to this enormous task of properly and fully reopening the courts of our state. Since March, our offices have continued to function at the best of our ability in the face of unprecedented challenges. As we try to return to a new normal, further reopening of our courts will require careful planning and collaboration with many of our stakeholders, And most importantly, the public's trust is imperative as we navigate the reopening and the safe implementations of court functions. We are all thankful that the rate of infections are declining in our state. Today, we have so much more knowledge about COVID-19 than we did 5 months ago when the court system was forced to limit many of its functions. Medical experts have helped us understand better how the virus is spread, and we have tools and procedures to help prevent the spread of the virus. But I want to stress that there cannot be a one-size-fits-all approach to opening. As with many other issues in our state, there are stark disparities in the infection rates in different parts of our state. I urge you to look at each unique locality individually and to communicate with local officials, district attorneys, court staff, defense attorneys, and other participants before policies and recommendations can be made on a wholesale basis. That being said, it's imperative that we do all that we can to restore all of the functions as fully as possible, as soon as possible, so that our court system can provide to the people of our state, including those accused of crimes, victims, witnesses, and their families, and all of the state's residents and business and visitors. As the saying goes, the delay of justice is injustice. We really need to open up these courts. When sending out jury summonses, it's important to send to potential jurors detailed questionnaires so that they can return in advance of their appearance date. That procedure will make the selection process more efficient by screening or excusing certain jurors based on questions asked. In difficult times like these, many jurors who have valid reasons for declining service could be excused without appearing in person. For example, jurors may have been excused if they have a virus symptom, or if they've been exposed or are immunocompromised, or if they have genuine employment or childcare issues. In order to ensure that enough jurors appear, those who appear or serve could be incentivized with the benefit of not having to serve for an extended period of time, or perhaps increasing the rate of jury service from $40 a day to perhaps $100 or more. The use of face masks engenders certain issues in the court setting that must also be addressed. To be sure, face mask is one of the most ubiquitous, accessible, and effective tools in fighting COVID-19. But everyone knows, after having conversations where both parties are wearing face masks, they often raise audibility issues. Words, sentences, phrases must be repeated multiple times because of natural mumbling and muffling of sounds caused by the mask. That problem is exacerbated when anyone who is part of a conversation is hearing impaired to any extent. The same way those audibility issues prolong conversations in our everyday conversation and interactions, this will prolong court appearances. Further, the inability to see a witness's facial expression makes it difficult to get a true read about how and what they're saying. As human beings, we need to judge credibility, and we rely on certain facial cues, such as smiles or frowns or other facial indications of emotion. To address these concerns, perhaps masks that are clear and face shields that are clear could be provided to all juries and witnesses in the court system. I can't stress enough how important it is for grand juries and petit juries to resume full-scale operations throughout the entire state. We all understand the difficulty of witnesses appearing in person, especially when they are from high-risk states, and especially where those witnesses are exhibiting symptoms, or when they have been exposed to someone with the virus, or when they merely have concerns of their own personal health. There's clearly a need for courts to allow for more virtual testimony. In the grand jury setting, jurors can still have the opportunity to ask questions and see witnesses, and in a trial jury, the defense would still have the opportunity to confront witnesses. When witnesses testify remotely, safeguards could be put into place to ensure confidentiality of the proceedings. And for example, witnesses could go to a local police department or a district attorney's office to testify from that location. In addition, permission must be allowed to allow virtual testimony on a case-by-case basis so that the process is not abused. Now, counties throughout the state have just begun seating grand juries. Here in Monroe County, we seated a grand jury back in July 13th, and it concluded on August 7th. Our grand jury bureau worked tirelessly to ensure proper social distancing and the safety regulations to protect jurors, witnesses, and staff. This first post-shutdown term, the Commissioner of Jurors sent out 400 summons letters.
You could wrap up, please.
Triple the number. So it's really important that we, again, make sure that we are reaching everyone out there. You know, I really have a lot more to say. And again, you have to understand I'm speaking for 62 elected officials throughout the state. I will sum up now, but I hope that you will ask me specific questions because we are really anxious to get the courts back up and running and get back to our new normal. Thank you so much.
Thank you. Thank you very much. I'm going to ask, I know Senator Bailey may have been briefly in transit because he had an important meeting, but now he's, if he's available to ask the first round of questions. Senator Bailey, are you with us?
Yes, I am, and I'm getting to a location where I'll be able to put my video on. I do apologize to everybody. There was a 96-year-old World War II veteran who had COVID-19, and he beat COVID-19, and we welcomed him home today. So I saw that fit to abbreviate, you know, the meeting just for a moment, just to recognize one of our heroes who served our community well. So I wanted to thank you all for appearing, and I guess the first question that I would have would be to DA Doorley. Once again, thank you for your appearance.
Thank you.
You mentioned something concerning not being able to adequately, I don't want to say adequately do the job based upon a lack of facial cues. Could you go into that a little bit more in depth about that? Because would like for you to expound upon what you meant by that.
Sure. I mean, one of the things that we're asking for is that, you know, we be provided with maybe some kind of clear face masks or some kind of, you know, clear masking situation so that when grand jurors come in and testify, that the grand jury can see the faces of the witnesses, because again, the grand juries at that stage are the judge of the credibility of the witnesses. When we resume jury trials, again, we're all assuming that jurors, witnesses are going to be wearing masks. We would ask that they be provided with the clear plastic mask or face shields so that the juries and the judge could judge the credibility of the witnesses. I mean,
Okay.
if you look at some of the masks that people wear, you know, a lot of their face is covered. You know, we had a situation in our grand jury, and again, I'm speaking only from Monroe County, where we had to have something where we gave witnesses proper instruction on how to wear a face mask because the grand jurors were having a difficult time seeing their face. So I think, you know, for everyone's sake and for our judging of credibility of witnesses, we need something clear so that their faces and their facial expressions can be apparent to all.
Okay. I understand the sentiment. I always remain concerned about the utilization of certain measures in order to assess guilt or innocence, or not guilty or not guilty.
Right.
But I'll come back to you in a second. I wanted to make sure before my time elapsed, I wanted to ask either Tina or Kevin a question about on the defense side. Chair Hoyman, if I could, are we doing one witness at a time, or are we going back and forth? How are we doing this? I apologize.
You can ask as many witnesses simultaneously.
Perfect. So to either Tina or Kevin, again, thank you for coming today. The calendaring of essential versus non-essential matters. How is that happening, and how is it affecting your practice? I guess let's pick Tina.
Sure. Thanks very much, Senator, and congratulations to your constituent for healing. So let me give you an example in the Bronx. And this is all tied and sort of has to be said, because I think it's important to sort of put this all in context, that the courts had been working very hard to pivot to do remote. And when Mayor de Blasio began to blame the courts for being closed, which it never was, it was just remote. What we started to see was the calendaring almost immediately, within a day of in the Bronx, people who are out who have remained at liberty, who have not been in trouble, who had pending matters, and again, suspended, as Kevin said, by operation. There's no discovery, there's no speedy trial. So they're working and they're home and they're out and their case is pending. That's getting calendared simply to check in on the client, to pull them into court, to compel them to come to court, to check on them and keep tabs. And then it's adjourned again. Versus what we really know to be true, which are there are people right now languishing at Rikers Island who should be actually coming to court with to move their cases along, to have their matters heard. Or when we are filing a writ, it is taking that filing of a writ to get somebody released days to get calendared. Again, it's again, what is happening, there's a disconnect between, you know, what I believe in earnest to Judge Marks's testimony, he believes is going on and what is happening on the ground. There's a chasm of difference. And that's an example happening right here in the Bronx.
And one thing I would ask to DA Durley, Madam President Durley, or Kevin, would be, generally speaking, what is the morale of either defenders or DAs or ADAs that are going into court that have to are they concerned about their own health? And that's a rather general question, but I just wanted to ask that for the record. Is there a level of concern about contracting COVID and bringing it back? And do you believe that it has any adverse effect on the ability to practice law in either of your respective capacities?
Well, Senator, I think it would be unreasonable to think that it isn't, and it doesn't have an effect. You know, certainly we talk to our people all the time. Tina and I, you know, we're on the ground also with our people, going to court sometimes with them, and constantly evaluating, you know, what their mindset is. And they have addressed that very concern that, you know, with further reopening, especially if we're talking about non-essential proceedings, having to go to court for something that really isn't all that important, putting your life in jeopardy, you know, even if it's, you know, only for half a day, is a problem for sure. So yes, it's a concern of ours, which is why, you know, we're addressing the non-essential proceedings issue. There really isn't any reason to reopen the courts to those types of proceedings, especially where people are out of custody. So yes, I mean, it's something we think about constantly.
Thank you.
If I may, Mr. Chair, DA Durley, could I get your
yes,
opinion on that, if possible?
Yeah, absolutely. Sure. You know, I could speak for my people. There are some that, you know, do have health issues and they're not appearing in court. Other people are covering their calendars. Yes, everyone is worried about, you know, their own personal health. But in the same light, I think, you know, people, and again, I'm speaking for people of Monroe County, the people that work for me, you know, they really want to get back into court and they want to get things, you know, up and running. They want to get back and do trials and hearings. And again, that's why I stress that we really have to look at this as a region by region thing, because up in Rochester, you know, the rate of infection is much lower than it is in our urban areas and bigger cities. So you've got to look at different regions. There's not a one size fits all.
Thank you. Thank you, Mr. Chair. I'm going to take the video off as I continue my journey on home, but I will be listening and I will come back on for a second round if so allowed.
Thank you. Thank you so much, Co-Chair Bailey.
Bye-bye. Thank you.
I had a couple of questions. I wanted to ask first whether there's concern about these pauses to the criminal procedure law having been done through gubernatorial executive order, running afoul of the Constitution. Is that something you're concerned about, Kevin?
Yes, yes. As a matter of practice, absolutely. You know, as the practical effect of pausing something as essential as 3030 is something that Tina alluded to. We've got a mass amount of people sitting incarcerated with their cases simply paused. And there are mechanisms to allow some of those cases to be adjudicated, but because discovery is paused, because there's absolutely no outward influence on these cases, and there's nothing internal to force the district attorney's office to move on them, they're sitting there languishing. So yes, I mean, due process rights are being violated. Constitutional rights are being violated. And it's unfortunately, the district attorney's offices, because they're not being forced to move, that they're just not. They are moving on some cases. They are taking a look at those cases which are easily disposed of, and there are a good variety of those. But for a lot of high-level or mid-level offenders sitting in custody, there's no relief on the horizon for them until 3030 is unpaused. That would be a
DA Dooley, do you have a?
tremendous step in the right direction to get that section at least moving. Yeah. I'm sorry, Senator.
I was going to ask DA Dooley if she had an opinion on that. So.
Yeah. Again, this has got to be done region by region. Here, the last time the executive order was extended, I said to myself, well, up here in Rochester, my staff is fully compliant with Discovery. They are working around the clock. They're ready to go. We do not need this, a 30-30 pause. However, there are other jurisdictions that do, where they're not getting the discovery from the police. They're not getting their results from laboratories because they are, not up and functioning like they should be. So really, I can't stress enough, it's got to be regional. If you were to say in the 7th Judicial District or Monroe County, what would be the effect of relieving those restrictions? We would be fine. We would be back to business as usual, but I can't say that for my other 61 elected officials. That's why it's very important for you to reach out and speak to them as well.
And I wanted to raise what was in the last panel suggested by Judge Latwin, that a proposal to eliminate the right to a jury trial for those charged with B misdemeanors. Tina, what do you have a reaction to that idea?
Look, our jury process is critically important, right? To sort of take that away for some people and not others, while that feels like it's a right move. Again, we have to look at the totality of the circumstances, and we have to look at like meaningful due process. And I think what's sort of being left out here is all of the things, by the way, and I agree, the executive order has stopped, in essence, in some places. And I agree with DA Dooley that I hear from some of our colleagues upstate that district attorneys are handing over discovery and are trying to move matters. I wish I could say that it's true for all 5 counties here in New York City. It's not, but there's an ability to conference cases right now. It's an ability for district attorneys to talk to witnesses. And if in fact there is no case, to dismiss that case, even while we're waiting for the EO to change. And there's ways in which to have due process that doesn't take away rights, right? Even while we are doing things remotely, and while we are trying to get to a place where our courtrooms are safe for everybody. And so the knee-jerk reaction can't be to take away rights. We must come at this rethinking best practices to ensure due process is still present for people who are charged.
Thank you. I'll note that the Mayor de Blasio and the NYPD Commissioner Shea have suggested that the criminal courts being in limited operation has contributed to an increase in gun violence. Any opinion on that?
Yeah, I have a lot of opinions on it, some of which I've made very public. Look, it's pushing the blame. First and foremost, again, courts never closed. Every public defender, and I'm going to say even DAs, know that. Judges know that. Arraignments continued. Did we have to pivot to remote? Did we have to pivot a Herculean effort, by the way, by everybody, including OCA, to get to remote? Yes. But the courts have been open. This idea that gun violence skyrocketed because, quote, quote, the courts are closed is shifting the blame.
Thank you.
The fact is, at the same time that the NYPD was blaming the court system, we knew that actually arrests had gone down in NYPD. And that's because NYPD is angry. And we saw that before when they were angry years ago and they started to stop making arrests. That's the reality. Not to mention, we are facing a historic, unprecedented health crisis. And so let's get to talking about how to prevent that in real ways, in holistic community-based ways, and stop blaming the court system.
Thank you. Thank you very much. Our our ranking member on the Judiciary Committee, Senator Tom O'Mara, has questions. 5 minutes, Tom.
Thank you, Brad. Thank you all for testifying here today. I want to follow up on some questions I had with Judge Marks earlier, since we're all, temporarily in over half the counties in the state now doing virtual criminal appearances on everything except for hearings and trials. I would, particularly in regards to 18220, like to ask President District Attorney Dorley on the fact that on that section, Monroe County was left out of that. I don't know why. I'm not sure if you know why, but very similarly situated counties to your east and west of Erie and Onondaga have been allowed to do this and will be. First of all, do you know why Monroe was left out of that? And secondly, would you like Monroe to be able to continue that after these pandemic rules?
I do not know why we were left out, and I would love to be included. Virtual testimony and virtual proceedings, have been a godsend to us. So I hope that we can continue after this pandemic and kind of, put it into our daily, court. I mean, there are times when you can handle, basic administrative things virtually. It would save time, it would save money. So please include Monroe.
Well, I'm working on legislation for that right now. And in fact, in about an hour, have a conference call with district attorneys, defense attorneys, magistrates, and justices from our judicial district, which includes Monroe County. So I've been working on that. Particularly, the focus is to Ben County right now because they were excluded. But 4 of the 5 counties I represented were left out of that. I don't know why, and they certainly want to be involved going forward. And they've been successful doing it now. Another factor in that, and I'll open it up to all 3 of you, is there's still a consent requirement on the behalf of a criminal defendant. That defendant can say, no, I want to be there for that appearance, no matter how ministerial it is, and can kind of slow down the works where that is required. Is there any real concerns from the defense bar on these more minor appearances that the defendant should be able to deny that virtual appearance?
So I will tell you that we have made that argument to the courts in New York City that our client needs to consent to coming into an in-person, and it's been summarily denied in every single case. So our clients are actually coming into court and being compelled to come to court despite the executive order talking about a consent requirement. So in New York City, there's no concern that it's causing the delay. That clients, and I want to say again, that does not necessarily mean a client doesn't want to come to court. Our client who was HIV positive and had symptoms wanted to do it remotely, right? That's the difference. There are remote options for people, and we built out a virtual system. And for these sort of non-essential, sort of non-hearing and trial, as you raised, those can be done remote, which then keeps the density of our courts lower for the things that are essential, that you do need to go in for, right? So it's about planning. It's about working with your epidemiologists to come up with whether they're regional, and I do agree, like upstate counties may be very different than New York City, right? So, but it's about planning and bringing stakeholders together to plan this out, and it could be done.
Thank you. Kevin, any differing opinion on that?
No, I mean, in my opinion, is virtually the same as Tina's. In Buffalo, our clients, even though there's a sort of a window dressing consent about something like a felony hearing, a preliminary hearing after you're arrested for a felony, where the client is asked to consent to having the proceeding heard virtually. Whether we're really allowed the choice is really a matter of conjecture. We really aren't. In the event that there's a huge objection to it, perhaps there's something that a conference call gets held, and the client is then asked again whether he or she really wants to appear. So in terms of whether or not they actually have the option to appear personally, I'm not really sure that choice is there. But in terms of exactly what Tina said, by limiting the number of non-essential proceedings, pretrial conferences, further proceedings dates, motion exchange, things of that nature, by eliminating those or holding them virtually, you open up vast quantities of time to do things like preliminary hearings and suppression hearings and trials and sentencings and things of that nature. So we just need to be, at least our opinion would be, you need to be very careful about what types of proceedings you're bringing back in court, what types of risk you're subjecting people to, and balance those things with the need to maintain community health.
Okay, my time's up. I thank you all very much. I don't blame the courts either for the alleged increases in shootings in the cities. However, the court's hands have been tied in a lot of places and inability to set bail on cases. So I do think that has something to add to the issues we're seeing on the streets, particularly in our cities, but we're seeing it statewide. So the bail reform remains a critical issue, I think, in this regard. But thank you, Chairman Hoylman.
Thank you, Senator. In the absence of any further hands being raised, we want to thank the panel for your participation this morning and for your important insight.
Thank you, Senator.
Brad, may I have
Oh,
one
yes,
more?
I'm sorry, Senator. Senator Bailey did have a follow-up.
Because I'm still en route, and so I just wanted to follow up on Senator O'Mara's question. Is there a belief that bail reform has anything to do with what's happening in the courts right now to either Kevin, Tina, or DA Durley?
I personally think it's too early to tell. I think everything has been on pause. I think we need to really collect the data, and this may not be the proper period to look at, but I think it's too early to tell, and perhaps we need to look at this in a year and see.
Thank you. Tina or Kevin?
I certainly can talk from in New York City, when there's an arrest and it's for a violent crime, prosecutors are asking for bail and judges are setting bail and clients are in on bail. And so that's the reality. I do agree that we need to assess the negative consequences of the pivot, the change of the reform, but certainly bail is getting set on the cases by courts when the prosecutors are asking if they're bail eligible offenses.
And in Buffalo and upstate, that's exactly what's happening. Where there's a bail qualified offense, judges are not reluctant to set bail. We have to fight very hard on those qualifying offenses to get a client released or have low bail set. So the idea that low-level offenders are out causing violent crime. Again, I think the statistics need to still come in, but I wouldn't go so far to say that that's a contributing cause.
Thank you. One more question that I would have. I would say this would be the converse for the DAs and DA Durley and Kevin and Tina. So from arrest to first appearance, what's happening in central booking? Are there proper social distancing procedures being taking place? Because while it may not be specifically related to the court itself, it is a major part of the process. Could you walk me through what's happening there and there?
Sure, I can start first, Senator. Again, here in Monroe County, we have a different appearance system than your desk appearance tickets, but people have been given appearance tickets. Those who are brought into the booking in our Monroe County Jail. I know our sheriff here has made sure that they're social distancing. They're cleaning at every moment, and we have been pretty successful in not having the pandemic spread to the inside of our jail. So again, I think this is going to be a region by region, facility by facility issue.
Certainly in New York City, we see the video clippings of police officers not wearing masks in a consistent manner, and we are tracking reports that face masks that are supposed to be given for somebody who's pending, waiting to be arraigned, sometimes run out, or they're sporadically given. Obviously in a holding cell waiting for arraignments on an online arrest, there is no ability to socially distance. We're still very much concerned about that. We continue to raise that with both OCA and the city. And we need to really think about that, certainly for online arrest. And then obviously there are people who are being arrested, brought to a precinct, and then issued desk appearance tickets. And here, that is a concern of everybody, that those people have had their matters also backlogged. But it's still a concern, Senator. And I appreciate you asking about that, because it's part and parcel to the overall way in which we have to holistically think about safety and justice, and not just from the point of the court door, but way before that as well.
And in upstate, in Buffalo specifically, it's difficult to see what goes on off camera. And speaking to our clients who are brought in, many of the concerns that Tina just raised, being held in holding pens, even if you have masks on, it's very difficult to socially distance. We still do have custody arrests. There are a good many of them. These people are held in close confinement. When they're brought in from off camera, it's difficult to see what's off camera, but some of our clients report that not everyone is doing everything that they can do to maintain safety in those types of situations. So yes, it's still a major concern, and will continue to be a concern during the pandemic.
Thank you so much for your indulgence. And Mr. Chair, thank you for your indulgence. And as I travel, and I will be home shortly, so my video will be on quite soon. I just want to say thank you to everybody for testifying today. And
Thank you, Senator. We'll look forward to your next stop on your journey during this hearing. And thank you, panelists, very much. We'll now move to panel 4.
We had Senator Kavanaugh.
Oh, Senator Kavanaugh has a question. I'm so sorry, Senator. I asked you by text, but I didn't get a response.
I think I did respond. We have multimedia going on. Yes.
Sorry. Thank you.
Thank you. Obviously, a lot going on and juggling many things. Just a couple of quick questions. First of all, I always think it's bad when the senators having a hearing like this go back and forth, but I just want to express I'm perplexed by the notion that bail, not holding certain low-level offenders on bail, is contributing to gun violence and other violence. I do a lot of work on gun violence, and we know that there's been an uptick of violent incidents throughout the country. I just didn't want to leave that unresponded to, but I'll obviously have further opportunities to speak with that with Senator O'Mara. I just want to, we've heard a lot about different ways of doing virtual proceedings today so far. And I think that in the criminal court context, there's been more experience with that. I think you've had people appearing remotely in certain circumstances in the past, even before COVID. And we've heard a lot about different platforms today, including, I'm surprised to hear talk of Skype as a means of conducting proceedings. I've been on, Microsoft meetings and Zoom and, other platforms and innumerable sort of official gatherings in the last few months. I'm yet to be invited to a Skype hearing or meeting, but I suppose that could happen. Can you just talk a little bit about what are the basic elements of an ad set up for remote proceedings? What needs to be in place? Do people need to be able to see each other simultaneously? Are some of these platforms better than others in terms of accommodating that?
So, I can address your concerns relevant to the platforms that are currently being used in Buffalo, and I think perhaps even across the state. Arraignments are being held on that Skype platform, which isn't by any stretch of the imagination the best way to do things. It limits the opportunity to provide things like evidentiary materials or accusatory instruments. All of those things need to be sent offline. The client doesn't have a chance to review any of that material, with their attorney prior to an arraignment, for instance. It's extraordinarily difficult to maintain a secure and confidential attorney-client conversation. You have to be, taken offline or put on a headset or brought to another room in order for those things to happen. So Skype is not great. We don't love it. And my understanding is that the courts are going to be moving away from it in the relatively near future toward a Microsoft Teams platform, which will allow the provision of a lot of the things I just talked about. It will allow for clients to see the evidence and to see accusatory instruments and review those things in real time with their attorney. It will also allow things like breakout rooms for counsel to have independent, confidential communications with their client away from the prying ears and eyes of the court staff, district attorneys, and the judges. So, these are important things to consider as we move forward. And, getting away from what we're using now would be a great step in the right direction. Something, and really just one other thing I'd like to mention in terms of court access, for people who require interpreters, it has been extraordinarily difficult on a virtual type platform to have any kind of communication that ends up being confidential with an interpreter, because we're facing, lots of different languages. You might have a Spanish interpreter in-house because that's a ubiquitous language, but something is, non-ubiquitous is like Karen or Burmese, which we have a lot of those individuals in Buffalo. Trying to do that type of interpretation over Skype, you end up having to kick everyone out of the meeting or have everyone, affirm that they're going to mute their Skype meeting in order to have a confidential communication with your client who can't speak English. That's something that we've been working very hard to rectify. But again, with the limitations we're facing in these virtual proceedings, it's almost become impossible. So moving to something that is much easier to deal with would be a desired quantity. And I know that they are moving in that direction.
That's very helpful. Any other thoughts on that?
Yeah, and again, here in Monroe County, we were Skype for Business, and actually before we went up online doing virtual preliminary hearings, and we practiced with the courts. I joined with our local public defender, and we did practice or moot proceedings, and we had it working, and it's been functioning pretty well. But we are moving on to Microsoft Teams. But one thing that we have to think about too is each DA's office, each public defender's office, legal aid, they need money to be able to have this technology up and running. I actually have two people who are hired solely to make sure that all of our online platforms are running smoothly. I'm a larger office, but a lot of the smaller offices around the state don't have the funding to have that type of person on staff. So again, in order to expand our ability to do things virtually, we would really need the funding to make sure that we're all, capable of doing it, whether it be a large urban area or a very small county.
I see my time's up, so unless Ms. Longo, you had anything? Okay.
All the above, including
Okay, great.
the need
All
for
right, so I yield my time again. Thank you very much.
Thank you, Senator Kavanaugh, Co-Chair Kavanaugh. Thank you very much, panelists. Again, it's my second goodbye to you. And really, it's very greatly appreciated your insight today. Thank you.
Thank you very much.
Thank you.
Our next panelist, our group of panelists is panel 4, who are assembling, and I'll read their names. Sonia Shield, President of the Legal Services Staff Association, UAW 2320. Jared Churgillo, President of the Association of Legal Aid Attorneys, UAW Local 2325. Dorlin de Dios, President of the Dominican Bar Association. Philip Hamilton, Board Member of the Metropolitan Black Bar Association. Sergio Villaverde, Member of the Board of Directors of the Puerto Rican Bar Association, and Yang Chen, Executive Director of the Asian American Bar Association of New York. Sonia, if we could begin with you, you'll have 5 minutes.
Good afternoon. Thank you.
Thank you very much.
My name is Sonia Shield. I'm the president of the Legal Services Staff Association. We're a union representing the staff employees at Legal Services NYC and Mobilization for Justice in New York City, providing civil legal services to low-income New Yorkers. I'm also here today on behalf of our national union, the National Organization of Legal Services Workers, Local 2320 of the UAW, which represents employees at legal services organizations, both upstate and downstate. Thank you for the opportunity to testify about COVID-19 and the impact on the court system, low-income litigants, and their representatives. My remarks today focus primarily on what we're observing in housing court. Evictions are a public health crisis. They do violence to communities and families. This is even more so in the midst of a pandemic, when displacing someone from their home through either legal or extra-legal means tears them out of the safest space available to protect against the virus, one's home. We therefore urge you to urge the passage of 3 critical bills: the Rent and Mortgage Cancellation Act of 2020, which would cancel residential rent payments that came due between March 7th and the end of the state of emergency plus 90 days. Second, the Emergency Housing Stability and Displacement Prevention Act, which would extend the universal eviction moratorium for 1 year. And third, the Housing Access Voucher Program, Senator Kavanaugh's bill, state-funded statewide rent supplement program to rehouse New Yorkers experiencing homelessness. In addition, we can anticipate that once the eviction moratorium ends, many newly poor and newly jobless New Yorkers will begin receiving eviction notices. Many will qualify for free legal services from our organizations, and in order to provide that high quality legal services, we will need more funding, and we look to New York State and City to protect its residents by funding legal services providers. We know that communities of color in New York are bearing the brunt of the virus's impact. Although average COVID rates are low across New York, these averages mask significantly higher rates in communities of color. The most effective way to prevent existing inequalities from increasing homelessness in communities of color is to keep cases out of housing court. However, this is the opposite of what New York's housing courts are doing. I urge the state Senate to heed the words of the tenant-led Right to Counsel Coalition, which demands that all eviction proceedings in all venues should be suspended. There's no public health reason to proceed with eviction cases. On the contrary, moving eviction cases creates a public health crisis. As a union, we have significant concerns about both virtual proceedings and in-person proceedings. With regard to virtual proceedings, they raise a number of serious due process and technology concerns. These were addressed by some of the panels before. With regard to in-person proceedings, the Office of Court Administration's decision to begin holding in-person trials in housing court is forcing the poorest and most vulnerable New Yorkers, who are predominantly people of color, along with their advocates, to travel on the buses and subways to antiquated courthouses, putting their lives at risk in order to protect their housing. This is not a choice that anyone should have to make. Our clients are being unnecessarily exposed to the virus and then must return to their communities where they might unwittingly expose others. We're urging the legislature to scrutinize closely which courts are opening quickly and which communities are being most harmed by these reopenings. In addition to the risk of exposure caused by forcing people to travel to the courthouses, the physical court buildings are not yet safe for mass gatherings or prolonged periods of time. The Office of Court Administration has not yet provided full information about the state of their buildings, but what we have learned so far, for example, about the HVAC systems, is troubling. We are urging the legislature to demand documentation and answers from the Office of Court Administration. I know you did some of this morning, but to the extent that it has not already been demanded, it's very important that we have full transparency about the physical conditions of the courthouses, and that OCA work collaboratively with unions, employers, and other stakeholders to ensure safety for everyone who enters the building. For example, the HVAC systems, what are the filters? Have they installed filters sufficient to filter out COVID? Are they installing no-tech touch technology, ultraviolet light? How will they be screening visitors to the courthouses and training court officers? How will they ensure that anyone who is denied entry does not suffer prejudice to their case? I have more remarks in my written remarks, but I see I'm running out of time, so I'll submit that. And thank you again for the opportunity to testify today.
Thank you very much. Our next witness, who just joined us on camera, Jared Trujillo, attorney in charge, president of the Association of Legal Aid Attorneys, UAW Local 2325. Hi, Jared.
Hi, Senator. And thank you so much for inviting us to testify, and also to all the senators here for holding this hearing. So our members are 2,000 lawyers, social workers, paralegals, and other legal workers in New York City, Nassau County, and Orange County. We represent low-income New Yorkers on the worst days of their lives. So that means someone who is at risk of being put into a cage and having their liberty deprived of them. That means immigrants who are at risk of being kicked out of the only country that they've ever called home. That means people that are at risk of being kicked out of their homes, of their apartments during a pandemic. We do this work proudly, we do this work ferociously, and we do this work really for so many low-income Black and Brown New Yorkers throughout New York City and Nassau County and in Orange County. COVID has made us work even harder than we were before. That's because we were helping people that might be disappeared by police during Black Lives Matter protests. That means that we're talking to tenants who are even more afraid of being kicked out of their homes because of the economic conditions created by this pandemic. However, since the outset of the pandemic, we've really felt unsupported by OCA. OCA was incredibly slow to close down in-person appearances because court's always been open, as other panelists have testified to, but they were so slow to close in-person appearances at the beginning of the pandemic that judges died, that legal workers died, that court officers died, that dozens of our members contracted COVID-19 for reasons that were completely avoidable and for reasons that were ultimately traced back to their work in the courts that were so slow to move to virtual hearings. We're incredibly happy that OCA did eventually move on to virtual hearings. However, after the mayor made his comments that that rises in gun violence were tied to the courts not working, despite the fact that courts had heard over 50,000 cases since mid-March, OCA suddenly and abruptly moved to doing in-person appearances. And I really want to emphasize that these in-person appearances were not for essential matters. These in-person appearances were for incredibly non-essential cases. As city officials were painting Black Lives Matter in Manhattan, our clients and our members were hearing that in-person eviction trials were going to start up on July 27th in Brooklyn and everywhere by September 8th. As our clients and members were hearing that gyms were not opening, that indoor dining was not opening, that malls couldn't open, they were hearing that it was okay to open up criminal courts to incarcerate more people into jails that were petri dishes for the pandemic, and to bring people into court for, again, really non-essential appearances. And the non-essential appearances in criminal court are only going to continue. After Labor Day, so many of the courts in New York City are going to be moving to hearing DATs, desk appearance tickets. What are desk appearance tickets? Well, the most common offense charged in New York State, outside of New York City, and the fourth most common in New York City are 511s, driving while on a suspended license, something that the legislature just took a really important step in preventing people from having their licenses suspended for failure to pay tickets. Those are the types of cases that they're bringing back in, cases that should easily be dismissed. We want to work with OCA. We want, our members want to work. Our members want to represent our clients, but we want to do it somewhere safely. I see I only have about a minute left, so I do just want to briefly address Judge Marks's testimony. We appreciate the work that OCA has done, but we need more communication and we need more transparency so that our members know that they're safe. We need not only their epidemiologists to actually step foot in the courts that they expect our members and our clients to risk their lives in, but that we need them to provide us information, and we need them to actually let our own inspectors in there as well. It's incredibly concerning that we heard that some courthouses have MERV beyond MERV filtration systems, but a lot of them don't. Senator Hoylman, in your own district, the Harlem Community Court at 314 West 54th Street, we have no information. There are courts in almost every borough and every single court in Staten Island that doesn't have an adequate filtration system. And even those that are older courthouses, we have no information as to what remedial measures they're taking to make sure that people can breathe. And I see that my time is up. I would also just ask that you read not only the written remarks that I prepared, but also we submitted several different testimonials from our members, and you'll hear about people that feel as if they've brought COVID back into their own homes. You'll hear about 83-year-old tenants who've been in their apartments for decades, who are at risk of eviction, and you'll really see that that the course that we're on right now is wholly inadequate and does not value low-income New Yorkers or the people that serve them. Thank you.
Thank you very much, Jared. Next up is Dorland de Dios, President of the Dominican Bar Association. Thank you.
Good afternoon. I'm Dora Linda Dios, and I'm the president of the Dominican Bar, DBA. DBA is an affinity bar association primarily based in New York. Our mission encompasses to foster the advancement of Latino legal professionals and to advocate for the community at large. As such, I will testify the concerns of our membership. As such, I will testify the concerns of our membership regarding the court's reopening process, and I thank you for the opportunity. Frankly, there are more concerns than positive points to the reopening process of the New York's courts during the COVID-19 pandemic, as many of the panelists have mentioned. It is without question that this global pandemic has disproportionately affected low-income New Yorkers and people of color, the same people who unfortunately will be gravely affected if the reopening process is rushed exclusively in person. Under current social distancing guidelines, as well as attempts to make courts safer for in-person business, we lack sufficient information as to how the Office of Courts Administration, OCA, and the Unified Court System, UCS, proposed to create a safer environment for litigants, attorneys, and court personnel under all practice areas, especially when they include many very different buildings and different types of infrastructure, as was just mentioned. There seems to be a rush to open our courts for in-person proceedings when the time has not been taken to ensure that our older buildings are up to code in combating and preventing the spread of COVID-19. Many older courthouses have insufficient air quality due to the older air circulation systems. Because these courthouses are unable to open their windows to allow better air circulation, it would be dangerous to have litigants, attorneys, and court personnel to be enclosed in rooms with a lack of proper air purification and circulation. Information has not been provided as to how OCA or UCS will attempt to tackle this hurdle. However, it is clear that this is an issue that cannot be remedied immediately and will take time to ensure that the air being filtered inside of these courthouses is safe. We applaud the court's efforts in moving many proceedings to virtual appearances, giving judges, court personnel, and attorneys and litigants an opportunity to safely and efficiently have their cases heard and justice served. Virtual appearances allow attorneys to efficiently handle matters in ways that we are previously unable to do so, especially when this required travel to different courthouses for litigation. That said, as an affinity group, we need to acknowledge that access to technology is a large hurdle for many low-income New Yorkers, as well as our immigrant communities of color who lack the ability to use them to appear and have access, their cases heard. This is less of a problem in cases where we have represented parties, where we've seen many cases able to move forward via televideo conferences. However, litigants who often appear pro se in courts, such as our housing courts, where we see a much larger demographic of low-income New Yorkers and people of color, will have no choice but to physically appear in courts for their cases if they lack the technology to appear virtually. Prior to COVID-19, thousands of litigants each day flooded housing courts, many unrepresented and many who did not speak English and depended on the services of a court interpreter to be heard. When the current eviction moratorium ends on October 1st, housing providers who serve low-income tenants expect an influx of all new eviction proceedings based on losses during the COVID-19 pandemic. The safety of these litigants has to be discussed and a plan has to be set in place. In conclusion, we do believe that our court system must fully reopen, though they must continue to have an open mind in dealing with litigation matters in creative and alternative ways. As we have seen in the past 6 months or so, there has been a massive backlog of civil cases as our civil courts have not been able to hold jury trials. More time is needed to be able to effectively allow alternative methods for litigation, such as the notion of a virtual jury trial, or even installing safety devices like plexiglass to separate the people inside of our courthouses and/or have an option to call versus video conference as an alternative to ensure that's the safety of our citizens upholding their civic duty. If the UCS does decide to fully reopen in person, then at a minimum, they should implement strict social distancing guidelines by making sure that everyone is wearing a mask and have extra masks available for the litigants, perform temperature checks, and before entering the courthouse, and make sure that everyone is 6 feet apart. Thank you for inviting and listening to our testimony on this matter.
Thank you very much, Dorlin. Next, we'll hear from Philip Hamilton, board member of the Metropolitan Black Bar Association. And I think you're muted, Philip.
Can you all hear me now?
Yes.
Sorry about that. Thank you for having me. The Metropolitan Black Bar Association is the largest association of predominantly Black attorneys in the state of New York. Since 1984, the MBBA has faithfully promoted its mission to advance equality in the pursuit of justice and address legal issues affecting all New Yorkers. We take pride in creating a network of over 4,000 supporters and providing a voice for Black legal professionals in the communities we serve. Accordingly, we thank all members of the Senate Standing Committee on the Judiciary, the Senate Standing Committee on Codes, and Senate Standing Committee on Housing, Construction, and Community Development for the invitation to testify on this pressing issue of court reopenings and operations in light of COVID-19. As you know, COVID-19 has had a devastating effect upon our state, especially within the city of New York. Black and Latino people in particular have been disproportionately affected. In New York City, the virus has killed Black and Latino people at twice the rate of their white counterparts. Many have worked on the front lines during the pandemic. They are healthcare workers, childcare providers, and bus drivers that live in Brooklyn, Queens, and the Bronx, boroughs that have been especially hit hard by COVID-19, with tens of thousands testing positive for the virus. Since the peak of the pandemic, municipal action, social distancing measures, and the mandated use of masks have helped bring New York's infection rate down to one of the lowest in the country. Executive orders limiting unnecessary gatherings and non-essential functions around the state have saved countless lives. This progress cannot be lost in a rushed, tunnel vision approach to return to pre-pandemic normalcy. No one entering a courthouse in New York should have to make a decision between prioritizing their legal case or their health. Instead, we must continue to move forward, recognizing that until we have an effective vaccine, COVID-19 remains a deadly threat. It is for this reason that the MBBA strongly urges the courts to prioritize virtual appearances and accommodate telephonic appearances whenever litigants lack the technology to appear virtually. Now, since the beginning of the pandemic, New York State Unified Court System judges and staff have heard over 160,000 essential and emergency matters, the vast majority of which have been heard in the virtual courts, which started up in late March. This is no small feat, and UCS should be commended for its efforts. Many of our members, however, have expressed concern that the virtual parts have been operationally limited across practice areas for the last 5 months. In lieu of investing more time and technology into making sure that every part can handle a virtual docket, some UCS actions seem to rush to return to in-person proceedings, even though many questions remain about how safe that will be. For example, CDC guidelines explicitly recommend ventilation systems that maximize outside airflow in reducing transmission of the virus. However, courtrooms in Bronx Supreme Court, criminal term, do not even have windows that can be opened, let alone publicly available information as to the efficacy of each courtroom's air filtration system. That notwithstanding, in-person appearances are currently being compelled in those very courtrooms, which makes no sense. Until UCS and the Office of Court Administration can confirm with specificity and transparency that their facilities fully adhere to the CDC's guidelines, we urge the courts to prioritize virtual appearances. This is especially true where the appearance concerns a status conference, calendar call, or related matter where the physical appearance of the parties is not truly necessary. We further exhort the court system to accommodate telephonic appearances whenever litigants lack technology to appear virtually. If litigants are unable to appear by telephone, only then and as a last resort should the court schedule in-person appearances. And in those instances, UCS must continue enforcing its protocols mandating social distancing, facial coverings, and temperature checks upon entry of the courthouse. Each courtroom should feature strategically placed plexiglass barriers. And in addition, UCS should ensure that judges conduct in-person appearances in the largest courtrooms, such as the ceremonial courtrooms located at 60 Center Street in Manhattan and 851 Grand Concourse in the Bronx. Ideally, every court part should be able to handle a larger docket of virtual appearances to address the backlog that is currently in the system. The practical implication is that the system desperately needs stenographers and clerks to work virtually because many of them are currently not working at all. especially in New York City's family courts, where our members report that those courts typically have but 2 virtual parts up and running to hear the thousands of child protection and juvenile delinquency matters pending across the city. So many families, particularly in Black and Latino communities, currently have no forum by which to litigate the reunification of their families. Not only is this an urgent due process issue, it is one that strikes at the heart of many Black and Latino families, given the demographic data reported by the Administration for Children's Services. We cannot allow our courthouses to inflict collateral damage upon communities already hit hardest by COVID-19. At the height of New York City's crisis in April, 61% of Hispanic Americans and 44% of Black Americans said they or someone in their household had experienced a job or wage loss due to the coronavirus outbreak, compared with 38% of white adults. This sad reality will inevitably have a disparate impact upon cases brought in housing court, family court, and criminal court. As docket backlogs will inevitably grow, the system must prioritize matters that affect litigants hit hardest by the pandemic, especially those at highest risk for contracting or transmitting the virus. In conclusion, the MBBA does not want to see any further COVID-19 related damage to our community. As Black and Latino New Yorkers bore the brunt of COVID-19's first wave, we have a particular interest in making sure that as court proceedings trend back towards pre-pandemic norms, that policies are in place to sufficiently protect Black and Latino litigants and litigators from further damage. We thank you for taking our testimony in serious consideration, and we hope to continue to be a part of this conversation. Thank you.
Thank you, Philip, very much. Next, we'll hear from Sergio Villaverde, member of the Board of Directors of the Puerto Rican Bar Association. Sergio.
Thank you, Mr. Chairman, and I'd like to start off by thanking the joint committees and all the chairmen and the ranking members for holding this important hearing and taking our testimony on such. As stated, my name is Sergio Villaverde. I'm a member of the Board of Directors of the Puerto Rican Bar Association. I've been a practicing attorney for 23 years. I'm the principal of my own practice. I'm retired from the Coast Guard Reserve at the rank of commander and former New York City police officer, as I said, and member of my local community board. At the behest of the chairman, I will not be reading word for word our testimony. I was here for the beginning of it and did hear the instructions. So my testimony, the testimony of the PRBA is submitted, and we will rest on that record. There are a couple of points that do need to be made, Mr. Chairman. We do support the need for a safe opening of the court system for all the users in the system. That may not be coming for a while. That being said, we are concerned, and we will focus our remarks today on 2 points: the impact to the community in general, as the PRBA is one of the oldest minority bar associations, being in existence since 1957. And our concern has been delivering services to our communities, to our neighborhoods, to veterans, to our members. As has been documented and is in our written testimony, the digital divide between communities of color and other communities is great. This heightens the concern when we're going to virtual courts, when we have communities who need the services of courts, as has been previously stated. But there's that we don't have access to Wi-Fi. There are issues with having other than a telephone for your internet access. These are issues that we feel that must be addressed in general. And many of the solutions, the virtual solutions that come up, are things that we're hopeful that the silver lining to all of this is that they may be long-term. There may be long-term solutions and long-term improvements in efficiency for the court system. As the PRBA, many of our members, as many attorneys of color in general, we are hired by small firms or the principals of our own firm, as am I. And there are particular things that affect small firms as a small business person that don't affect large firms. It's one thing if 5 members in the 500-person firm are sick, or for whatever reason are out sick, that's a problem for that firm. If you are a solo practitioner and you contract COVID or any other sickness that keeps you out, that particularly is 100% of your business. And for small businesses and solo practitioners, small firms and solos, it is an existential crisis if we go to court and we contract COVID, if it is not safe for us to be there. So it is a particular concern because we won't be here. The firm just will not exist. All of the clients that we serve would just not be served because if you've got two attorneys and they're both out sick, that's it. And there will be many in the community who will be left out of representation because not all representation happens through legal services corporations. There's still a large need for the small and solo firms to service our communities. We have submitted some of the proposed solutions, funding community-based organizations that already exist to become technological centers where people can go and use access the court system if they don't have access to Skype or MS Teams at home. The continued innovation of court calendars to allow for solo and small firm practitioners to attend courts and to be in more than one place in one particular morning is also something that OCA really needs to focus on and follow up on. For small firms and solos, as in general small businesses, we do need to incentivize either in some way this is something that the state legislature can do, either through tax incentives or other incentives, is funding technological upgrades to make sure that all the firms are on an equal playing field and can have access to the technology, because this is something that actually will make the court more efficient in the long run. So an investment of that sort is something that's not just COVID. It is something that makes the court more efficient, that requires less people, that requires less travel, that frankly makes access to justice more accessible for all of the communities. Because it's, if you're a regular working person like most of us are, you need to retain counsel. It's one thing for your attorney to take 15 minutes for a court conference, and another thing for that court conference to take 2.5 hours because you've had to drive from Queens to Manhattan. So those type of efficiencies are something that can be long-term and have the potential to be a benefit, not just to the court system, but to the communities it serves. Other than this, I thank the committees for the opportunity to testify, and we will rest on the submissions and any questions that the committee may have. Thank you very much, Mr. Chair.
Thank you, Sergio. We'll now move to Yang Chen, who is the Executive Director of the Asian American Bar Association of New York. Yang.
Thank you, Co-Chair Holman. Good afternoon. My name is Yang Chen. I am the Executive Director of the Asian American Bar Association of New York, also called AABNY for short, a professional membership organization of attorneys that since 1989 has been representing the interests of New York Asian American attorneys, judges, law professors, legal professionals, and law students. We're grateful to the New York State Senate for holding this hearing and including AABNY. The mission of AABNY is to improve the study and practice of law and the fair administration of justice for all by ensuring the meaningful participation of Asian Americans in the legal profession. We currently have more than 1,400 members in the city and state of New York. We are the largest affiliate of the National Asian Pacific American Bar Association, which represents the interests of more than 50,000 Asian Pacific American attorneys and legal professionals across the country. To advance and promote the fair administration of justice for all, the proper, efficient, and safe functioning and operation of our court system is essential. Courts must regularly balance competing interests in pursuit of the fair administration of justice. During COVID-19 times, this balancing applies no less. The health and safety of all litigants, court staff, judges, attorneys, and ordinary citizens interacting with the court system is paramount. At the same time, we acknowledge that certain aspects of the operation of the court system requires in-person proceedings. We support a pragmatic approach to the gradual transition of court proceedings to in-person operations where all responsible measures to mitigate the spread of COVID-19 are in full force and effect. In instances where we have learned that appearances can take place completely virtually, they should continue to take place virtually. Continuing to hold many proceedings virtually will be an important way to limit courthouse traffic. Indeed, where virtual appearances have worked during COVID-19, they should be continued and possibly made permanent via legislation post-COVID-19 as a way to ensure public health and safety without sacrificing efficiency and efficacy in the management and disposition of the court's caseloads. At the same time, we recognize that certain court proceedings require in-person proceedings such as bench and jury trials. The feedback from our leadership supports a pragmatic and gradual reopening of the courts to limited in-person proceedings. The most prevalent issues raised to us from board members and committee chairs who regularly appear or work in the New York courts were the serious and alarming backlog of jury trials and the inability to reach dispositions and plea agreements without calendared in-person appearances before a judge. Without certain proceedings being scheduled in person, the court system may not be able to fairly and properly administer justice. That being said, the implementation, continuation, and vigilance to COVID-19 protocols are absolutely necessary. Temperature checks, requiring face masks or coverings, plexiglass barriers in courtrooms and filing offices, social distancing in the courthouse, limiting the number of people in elevators, availability of PPE and hand sanitizer to all people using the courthouses, and the staggering of court personnel reporting to the courthouse for work should all be continued and strictly adhered to. As a bar association representing the interests of not just the legal community of New York, Asian Americans, Pacific Islanders, and South Asians, but of the broader community that we serve, we wish to share our views about language access in the courts. We spoke with one of our members, Judge Raja Rajeswari, who chairs the advisory committee on the court interpreting for OCA. Judge Rajeswari expressed agreement with Chief Administrative Judge Marks that in the best of times, language access is a challenge in the courts and is an even greater challenge now during COVID. The good news from Judge Rajeswari is that OCA has risen to the challenge and interpreters have adjusted to the new normal of virtual hearings. Interpreters have been able to appear via Skype and can perform their function effectively via remote. However, when the courts have to hold in-person proceedings, such as jury trials or bench trials, we have to be better prepared and better funded. For example, interpreters need not just new equipment, such as headphones, but they should have access to personal headphones that is not shared with other interpreters as a way to avoid contamination and transmission of COVID-19. Interpreters should also be provided with PPE and receive at least the same level of protection that any other participant in the court system receives. Albany urges more funding for the courts to ensure language access, to provide for more and better interpreters, and during COVID-19 times, to provide health and safety protection for them. Albany submits that there can be no fair administration of justice without equal access to the courts. And language access for our Asian American, Pacific Islander, and South Asian communities is a major component of that access. No language access means to us no equal access. And the fair administration of justice would thus be frustrated. In conclusion, Albany supports the OCA and UCS's efforts in its phased reopening of the courts. We commend Justice DiFiore on her leadership in this pandemic, and we support her efforts to gradually reopen the court system to in-person proceedings in a sensible and rational way that balances the needs of all participants in the court system with due regard to health and safety for everyone. We highlight the need for our courts to continue providing language access despite the serious challenges being imposed by our current reality. Thank you.
Thank you very much, Jan. Seeing no hands raised, we're going to move on to our next panel. But I wanted to thank all the panelists for your comments. And, Senator Bailey has a question. Thank you, Senator Bailey.
I apologize. Despite my relative youth, I am technologically inefficient from time to time. Well, most of the time, I apologize. So I want to thank you all for coming up here. I wanted to say that it's more of a thank you. Representation matters. As a formerly practicing attorney, it's great to see people that represent what we look like in the courts. And I know there's not that many of us. And to Sergio's point, you mentioned, and I used to practice in a small firm, have you noticed like a declination? This is for all of us. This is for all of you. Have any of you noticed or complaints to your respective associations about a declination in practitioners of color practicing because of the pandemic?
I have not personally noted that. I do have colleagues anecdotal statistics who have been directly affected because they live in the community and our families are from the community. We are more likely to be affected. So anecdotally, one could say yes, that we have a higher rate because our communities have a higher rate of issues with these things.
So when I was practicing a while ago, e-courts, it used to be really interesting. That the way you would access it was very interesting from device to device. Has that generally cleared up with what we're doing mostly technologically? Is e-courts or online, or these online matters generally available via a number of devices, whether they be iPads, Androids, smart devices, or are there still translation issues with them sometimes?
We certainly have. I certainly have found a lot of translation issues. I had to get on 2 devices for this meeting. So when that happens, and you have jurists, as you know, as an attorney, when you have judges who are frustrated already, and you're not able to get your microphone to work, these are things that we're going to all have to work through. And I think one of the previous suggestions from the Metropolitan Black Bar Association, or one of the other groups who talked in this panel, was, we need to have a very basic backup of the telephone. If I can't be here on video so you can see me, there's still the telephone, and that should be acceptable. And that should be, the word needs to get out on that.
Yeah. And Yang, you mentioned about language access, and it's obviously critical for people of color, because many of us speak different languages, and we often have to utilize the service of translators. And I'm curious to notice that in the limited in-person appearances that there may have been, have there been concerns with translation with the wearing of masks in the court? Because I don't know if the transcripts have been made available since this has been happening, but that's just something I'm curious about. If somebody is speaking a second language and they are wearing a mask, has that been, or is that something that we should be looking out for if it hasn't already been proven?
I spoke with Judge Regiswari, who works on this issue very closely for many years. And my sense is that the translation services have been provided virtually, and that's been working. And so she supports the continued use of that to the extent possible. Now, we have not yet heard about issues with that, with any in-person proceedings, but I think you raise a good point, because, as I said, we need to provide PPE and other protections for interpreters. And obviously, they probably may have to do so through masks or even face shields. And so that is definitely an issue I think is worth investigating, because as Judge Regiswari said to me, there's no substitution for in-person translating. We're living with the online world, the remote version of it, because we have to. But when we transition into in-person, there are many, many considerations, such as the one you just outlined, that we have to study and put into place so that the interpretation can be clear. Because, as Judge Mark said, even in the best of times, language access is an issue. And I think that COVID is helping us to rise to the challenge and think more innovatively and creatively to provide this very, very important access to our communities.
Well, thank you for that. I just want to thank you all for, again, representing your respective organizations. Thank you for the work that you do and being able to assist folks in dispensing justice, and again, representation matters. I appreciate you all for doing what you do. Thank you.
Thank you. Thank you.
Thank you,
Senator Bailey. I just wanted to follow up quickly with Sonia on your HVAC concerns. Could you elaborate on those?
Sure, thank you. It's Jared addressed some of this earlier. The fact that about only 1/3 of New York City courtrooms have MERV filters, that are 13 or 14, and most of the rest have only MERV filters of a rating of 8, and that's a very low efficiency filter that's unlikely to be effective at filtering particles and droplets containing COVID. And so essentially, we're looking at a situation where most of our courthouses are not able to adequately filter COVID from the courthouse environment. That's extremely concerning.
And Jared, are you getting a breakdown of, you mentioned the Midtown Community Court, But are you getting a breakdown of which courthouses do have those filters and do not?
We do. We have in the most recent breakdown that we have from OCA or from DCAS, I'm sorry. It looks like only about, as Sonia just noted, only about a third or so have MERV 13 or 14. We were hoping for something higher, closer to MERV 15. And I'll also note that even those that have MERV 13 or 14, we don't know anything about what protocols OCA is using to make sure that they have the germicidal irradiation that's really needed to make them run efficiently. We don't know anything about the filters on the vacuum cleaners. So much of the reason that we're here and so much of the frustration from my membership is that there hasn't really been meaningful communication. So we don't know what OCA's plans are, and we don't know when the courts will be safe for us and our clients to go back into, because there's just a lack of transparency.
Thank you. I'll now move to Senator Kavanaugh. He had a question.
Great, thank you. First, I echo the sentiments of my colleague, Senator Bailey, about the importance of partner role all of you play, make sure every community feels represented directly in our courts. I worked as representing Chinatown. We've worked with the Asian American Bar Association on language access for recent programs on providing rental assistance and other work. So we honor and respect all of the work all of you do in the courts and in the communities. I want to follow up. There was several of you mentioned evictions, and I think one of you called it a violence. And I think there is an increased awareness that an eviction is a extraordinarily difficult thing for somebody to experience in normal times, and certainly during the pandemic. I just want to, I don't know if you were here earlier, tuning in for the testimony earlier about the availability of cash payments, so-called one-shot payments in the event somebody is facing eviction. But can you speak, any of you speak, this might be for Ms. Shield or one of the other witnesses, but just the importance of having that apparatus available if we're going to proceed with housing cases?
Sure. Yes, it's absolutely important that that apparatus be available and that one shots be made available. We don't know. I mean, with the number of people who are newly jobless, newly poor, the increasing numbers of New Yorkers who will need rental assistance, that is. There are so many people who may be evicted before when they first get the notice from their landlords and are scared and don't even know that they have the possibility of representation and move out in anticipation of a court proceeding being filed, or who are coerced or move out through fear at any point along the process. And so while, yes, I agree, those HRA grants are tremendously important and we need to make sure there's the funding for that. In the middle of a pandemic, nobody should be forced to be going through an eviction proceeding at all. We need to be protecting people's housing at all costs.
So that's an important distinction where you're favoring, and I think at least one of the other witnesses mentioned, there's not only a moratorium on evictions, but a moratorium on proceedings, on people being notified that this is a proceeding that they're subject to and having to respond to that. To the extent, I think you mentioned a couple of specific bills that I appreciate the mention of the housing access voucher program, which we actually introduced in February as a means of having much greater resources available for people who are facing homelessness. There are two approaches to extending the moratorium. There's a bill I think you mentioned, which is Senator Myries, which I'm a co-sponsor of, and many others are. There's also a bill that has been introduced that's a sort of shorter term moratorium that the current version of the bill would extend the moratorium to January 20th, both on proceedings and on evictions themselves. Recognizing that, probably from your perspective, the longer the better. Would it be welcome when the legislature is back in session in the hopefully near future to put in place a moratorium that gets us to January?
We think the gold standard eviction moratorium bill really is Senator Myries' bill, and that's really where we would encourage the legislature to focus.
Right. Okay. And In terms of resources to pay the rent, we have a lot of different routes. Obviously, each of these elements is going to require significant funding given the scope of evictions, potential evictions, and people who are in arrears already, and especially if the federal government doesn't renew the pandemic unemployment assistance, that's going to become increasingly challenging. Do you have an opinion of? I think you mentioned, the cancel the rent bill, which many of my colleagues support. But short of that, and I recognize that that's the gold standard and the thing you're backing. But short of that, are there other mechanisms we can? I mean, even the longest possible eviction moratorium is going to end at some point. Are there other mechanisms that you think we can adopt that would permit us to address this problem in the long term? If that's for anybody on the panel, I don't mean to single out Sheila. Okay, I will. It sounds like hearing none. I will. Again, I appreciate all of the work all of you do, and I will. Yield my time back to the chair. Thank you.
Thank you, Co-Chair Kavanaugh. You've stumped the witnesses.
Yes.
But is there a couple? But thank you very much to all the panelists. Thank you for what you do in our communities across the entire state of New York. We'll bring on our next panelist, panel 5. We'll assemble as panel 4 signs off. Thank you. Panel 5 consists of Patrick Cullen, President of the New York State Supreme Court Officers Association; Steve Stone, President of the 9th Judicial District Court Employees Association; Charles Markert, First Vice President of the Suffolk County Court Employees Association; Glenn D'Amato, President of the New York State Court Clerks Association; and Peter Pichulo, President of the Court Officers Benevolent Association of Nassau County.
Senator, 1 second. We have 2 of the panelists that are not named. You can see at the bottom of their window. Could we just have one of them identify themselves? Your name, sir? We have Steve Stone, Patrick, Peter.
Steve Stone, Patrick. Oh yes, who is 815? I'm so sorry.
Glenn is sideways here.
Glenn, okay.
815 is Charles Market.
That's Charles Market, okay. Thank you, Charles. Oh, that's Charles, that's Charles, not Glenn. Stanley. Then there's another 815.
Come on, look it off like
Just, thank you.
Okay, why don't we start with Patrick Cullen, President of the New York State Supreme Court Officers Association. Patrick?
Good afternoon.
Having a hard time seeing you, Patrick. Can you turn on a light? You got a light around you?
They told me the light was a little too bright.
Maybe you should turn it on anyhow because we can't see you at all. There you go. That's better.
Okay. All right. Good day, chairpersons and senators. It's once again a privilege to address the legislature on behalf of 2,500 active and retired members of our organization. While we all wish this was under different circumstances, the effort to address this crisis and how it affects every corner of our state is encouraging. The severe challenges we currently face and those to come are mountainous and distressing, to say the least. but I want to point out a couple of issues and concerns for our members. And this is important, obviously, as the voice of our overall membership, but also because the success of the unified court system as a whole represents the improved health and safety of our officers. These are following some suggestions and solutions for a couple of areas where the response has lagged. During a great many conferences and inquiries, the unions representing 16,000 court employees were told that a priority for protecting us was the installation of plexiglass throughout our facilities. We've all witnessed similar installations in our neighborhoods and towns, yet many of our facilities are still without this additional level of protection. It's been 4 months since the initial discussion of this safeguard, and even with the most gracious understanding of the current difficulties, we cannot fathom why so many businesses and services are outfitted with the plexiglass while we continue to await it. I ask that this become a priority for you as more and more of your constituents begin to conduct their civic business in our courthouses. I sincerely hope that this body addresses this with court administrators to fast track a safety measure that was introduced in April. It's for everyone's protection and to avoid further tragic circumstances. Another major matter causing worry amongst our members is the level with which cleaning protocols are being followed through. As you may know, the unified court system does not own the buildings housing our courts. This leads us as tenants to be subject to the rules of the landlords. In the case of New York City, these facilities are cleaned by DCAS, and there is massive unease that the cleaning protocols are not being completed as laid out in many memos and communications and documents provided to employees. That's not to say these buildings are not being cleaned at all, but that the real difficulties lie in verifying their completion. Perhaps the enormity of space and a shortage of personnel leads this to become an issue. And without question, public buildings are tough to maintain. However, there must be a much clearer line of communication between landlord and tenant during this period of time that lends itself to peace of mind for all who use the court's facilities. This is crucial issue to be addressed as the increase in foot traffic begins. In a similar way, as you've heard many times today, the installation of HEPA filters with the capability of MERV 13 or higher that are new and up to all proper specifications must be the standard. As with the reopening of schools and businesses, this must be addressed immediately. We cannot afford to begin procedures now, and just like previously mentioned issues, be waiting for action all the while possibly providing a less than ideal environment for the health and safety of our members. As every precautionary measure not taken is inviting illness into our workplaces and homes. One other matter I would like to speak on is the current policy on the notification of ill and or symptomatic individuals. With the return of grand jurors to our courts last week, the memorandum addressing this important step included language, quote, "No notification to other jurors should be made prior to the receipt of a positive test result," unquote. This continues practice that we've opposed since the beginning of the COVID-19 crisis. Everyone in contact with a symptomatic individual should be notified immediately. Most specifically, our officers who may then in turn have had contact with many other officers, judges, and court users throughout a given period of time. This is the main tenet behind the contract tracer program from the governor's executive orders. The simple solution to so many of these types of issues, notification issues, is for the agency to provide its employees access to the rapid result COVID test. It eliminates all the uncertainty of waiting for results, and contact tracing then becomes a secondary protective tool. The increase in court users is bound to present many infection challenges, but by making this level of testing a priority, we can be ahead of the curve instead of finding ourselves trying to flatten it again. Thank you for your time today. Most people understand the complexities of public life that are ahead of us, and it's my sincere hope that some simple changes can put us on a pathway to a realistic return to in-person operations in the safest possible manner for every one of us. Thanks.
Thank you very much. Much appreciated, Project. We'll now hear from Steve Stone, President of the 9th Judicial District Court Employees Association.
It's quite a mouthful, isn't that? Trying to get my association's name out there, Senator. I want to say thank you very much first for inviting us to speak as representatives of our various unions. I have a smaller union of only about 350 members with retirees and around 180 members. Not the largest, not the smallest, but we are in the 9th Judicial District, Westchester County and Putnam and Rockland County to be precise. I can't really add too much to what I've said. Patrick, I think you were quite eloquent. You hit a lot of the topics I was going to do. I have a prepared speech here, which is now shot. Thank you. You've hit a lot of my topics at this moment. The only thing I can really add is the reaffirming the fact that courthouse facilities are being kept to a lesser standard than what we will have for public malls and health clubs. MERV 13, MERV 14, whatever the filter factor will be that will actually filter out viruses is needed in our facilities. From previous panelists, it was mentioned before that there was that all of our cleaning services are being done by third parties, by the county. State runs the building and the counties or the city is required to clean it. That third party is a recipe for disaster. We don't control those employees. We don't have the ability to interface, call up somebody and say, courtroom 3 is free, get in there and clean it. Most of our cleaning services do happen, at least in the 9th Judicial District, in the evening, where we have a private company that comes in and does the majority of cleaning. What their filter bags are in their vacuums, they're not MERV 13, I can guarantee you. Those issues need to be addressed. And I think maybe the state needs to actually re-examine this leasing properties from territories. We should control it. We should have the cleaning staff. We should be able to get them in there during the day, particularly during this pandemic, to make sure that cleaning is occurring when we need it to be occurring. Without a doubt, there are other issues that have come up. Previously, OCA issued a memo requiring court staff to reuse PPE. As much as that seems unwise, if you're going to go that route, then all of the court facilities should have UV sanitation stations or some other method to clean this reused PPE. Otherwise, we are just taking a chance on reinfecting ourselves because you might not have gotten it, but taking off this and putting it back on does expose you to the ability of, does expose you to the chance of picking up, the COVID. Pretty much that's hit everything that I've said at this point. Everybody else has given us some wonderful synopsis of what's going wrong, but I think we need to address the cleaning staff not being under direct control of the court. That I think is a situation where failure can occur because we don't control those employees. They are a separate contract. They're contracted to do certain things, and these contracts have to terminate first. And I don't think we've taken those steps to redraft those contracts. All right. Well, thank you very much for allowing me to testify, and I appreciate the time on behalf of the 9th Judicial District Court Employees Association.
Thank you so much. Thank you so much, Steve. Next is Charles Markert, First Vice President of the Suffolk County Court Employees Association.
Good afternoon, and thank you for the opportunity. I represent 102 different titles in the courts of Suffolk County. We're a little bit ahead of everybody else because as of July 10th, when we went to phase 4, 2 of our buildings opened up at 100%. And that being said, we have a problem with the protocol, COVID protocol screening set forth by the Office of Court Administration, which says any and all non-system personnel should be screened. District Attorney's Office, Probation Office, some police agencies are bypassing the screening process through other entrances that are not manned by uniformed court officers to screen persons coming into our facility. By that, district attorneys and probation then go into our court facility, go into the courtrooms, and handle cases while not being screened. It's a big problem. We addressed it with the local jurisdiction approximately 2 weeks ago. We haven't got a response back from them yet. As far as cleaning goes, they are cleaning, but the problem is they're not using disposable rags. They go from one door, window, table, chair, use the rag, and go to another courtroom and use the same rag. They go to 6 or 7 courtrooms using the same cleaning rag. So if there's anything there, they're just spreading whatever's there. We've also had employees call us and say they were asked to clean the courtrooms during and after different hearings because there's no personnel to clean during a break or when the next hearing occurs. Huge problem. Social distancing is tough, especially in the family court. We observed 50 people congregating in one hallway. In the district court this morning, there was over 300 plus screened coming into the courthouse without the employees. As far as that QR reader that Judge Latwin was talking about, we never seen one, never heard about it, never observed it. So that's a huge problem. We have a problem with locker room space for our employees, especially the offices. They cannot come in and properly prepare themselves for their daily assignments because the locker rooms are so small. In a 6x6 area, there's approximately 12 to 18 lockers. So basically you're shoulder to shoulder changing to get ready for your daily assignment. Same situation when you come back for lunch, same situation when you are done for the day from your daily assignments. We have addressed this with local jurisdiction, and again, we got no response. What else? We've also had issues with arrestees coming into the facility. We had a juvenile come in with active COVID who was arrested on a robbery. They brought him into the facility because there was no direction on how to handle that arrest. He was arraigned and then removed to a medical facility. We've had employees come in, active COVID, and spread it to 6 other employees because they were told they could come in because the signs were not there, all the signs. So we've had issues as far as COVID screening, cleaning, social distancing, and even as of probably an hour ago, we got a phone call for the second time. One of us court facilities was closed to mold contamination. It was allegedly cleaned last week. It was given the okay to open. We got a call at approximately an hour ago. Mold is back throughout the building, and they shut it down until further notice. And the other issue that I would like to bring up and be checked about is some of these court facilities, the plumbing has been stagnant for months. Are they going to even check for any type of Legionnaire's virus in the water supplies? That's very contagious and airborne. So on that note, communication between OCA and us is tough. They've extended their effort as far as COVID screening and cleaning, but it's just not enough right now. And what's going on, even though the state is at its all-time low, people and employees are scared to come into the court facilities because of that. And that's all I really have to testify to at this point in time.
Thank you. Thank you so much, Charles. Much appreciated. Next is Glenn D'Amato, President of the New York State Court Clerks Association.
Good afternoon, Mr. Chairman, participants, and people watching remotely. Thank you for letting me testify today. First of all, I'd like to thank all the members of the court system, and including the members of my union who have done a terrific job keeping the courts working throughout this entire pandemic. My clerks, especially in the arraignment parts, have worked long, toiling hours to make sure everybody's not denied their constitutional rights. I think that's very important. Another thing I'd like to address is the cleaning of the courthouse in the city of New York. Unfortunately, the cleaning has not been up to the standards I think are necessary to prevent the spread of disease. One problem I noticed, logs are being filled out early in the morning for the day's cleaning before the cleaning is actually completed, which I have a problem with. I don't like a 15-minute session being logged in when they have no idea how long it's going to take them. We need to monitor the cleaning accurately and make sure that everything's cleaned as it's laid out, as the jobs are laid out in the morning, not filled out in the morning and submitted before the cleaning's actually done. I have to laud the courts for allowing a lot of the clerks to work remotely. I think we've been very productive, especially the civil courts. I think that should continue with clerks working from home and remotely to try and keep the courts moving. without endangering themselves or the litigants or anybody that, visits the courthouse on a daily basis. I wish we had taken better steps to prevent the spread of COVID early on. Unfortunately, nothing we do about that now. I'm very sad to see that 3 judges have passed away, a court clerk, several court officers. I wish we had done a little bit more, and I think we need to be a little more diligent. God forbid there's a second wave of this in the future. I also think we need to be a little more controlling about who comes into the courthouses. And, children should not be permitted in the courthouse, in my opinion. That's children, unless it's absolutely necessary. I see a lot of children come into the courthouses, absolutely unnecessary at this time. I also think we need to streamline the arraignments a little bit more. Unfortunately, some of the participants are going to have to show up, including but not limited to the attorneys representing the defendants. They're going to have to show up in court. It's very difficult to access them remotely. The time constraints are not good. They're not working out well. It's very difficult to coordinate an arraignment with this remote system. I know it was necessary to begin. We're going to have to step it up. And some of the people, the litigants, they're going to have to show up. Even if you don't bring the inmates in, the participants are going to have to show up in court. We need to streamline the arraignments a little bit better than we've been doing now. But I do say we've done a great job, and the courts again have not closed for 1 minute during the pandemic, which I applaud. Everybody for streamlining. I wish communications would be a little better between my particular union, the Office of Court Administration. I've made myself available 24 hours a day, 7 days a week during this pandemic. I really wish the people in charge would do so. Unfortunately, I've had to call on my attorneys to maintain lines of communication with the Office of Court Administration. I don't think that should be necessary. The return of an email or a phone call would be much appreciated in these current times. And we really need to do everything we can to prevent a second wave from happening. And especially, in the courts where a lot of people visit, it's imperative we do everything to keep the cleaning up and keep the safety up. That's about all I have to say. A lot of my stuff was covered by the previous speakers. Thank you for letting me testify. I hope everyone have a pleasant day.
Thank you, Glenn. Much appreciated. And your words about preventing a second wave are really taken to heart. Next, Peter Paciullo, President of the Court Officers Benevolent Association of Nassau County.
Well, thank you. And good afternoon, Senator and all the ranking members. And thank you for inviting us to speak on behalf of our membership. We currently represent 93 titles for non-judicial employees of the Unified Court System. Our courthouses were closed to the public except for emergency and essential cases on March 17th. All the courthouses except for one were closed, and Nassau County entered a phase 1 reopening on May 29th, at which time the buildings were reopened. OCA and the Unified Court System did not properly prepare for the reopening. Everything was done as a last-minute basis, even though they had 2.5 months to prepare. Our walkthroughs were a what will be and not what should be or should be built. There was nothing completed, and it was, this is how we're going to do things, and this is what we will be building. Initially, we had shortages of hand sanitizers. Sanitizing wipes is still basically non-existent, and PPE. The way they're distributing the PPE, I do not only represent court officers, although I am one myself. The other job titles have to go down to the public safety desk and request the PPE. And our majority of our unions, that is the complaint, they feel uncomfortable doing so. And we've been trying to work with local, but they're told it comes from up top that each department cannot control their own PPE. Plexiglass was not fully installed when the buildings were reopened, and it is basically just non-existent in courtrooms and in the office areas behind where most of our membership work. And that is also a large concern. And we did bring this question up with the last time all the unions met with OCA, and they said, there will be no more plexiglass for the back office. We have shields for them. They will have to request shields. And to wear a shield all day when you're working at a desk with other people, I'm sure is very uncomfortable. And I'm grateful I do not have to do such a thing. when it comes to very little has been done on social distancing markers, though they are visible when you walk in. If you use a public bathroom, they have yet to address public bathrooms. They are not ready to reopen fully to the public. The bathrooms have yet to even been looked at. They still look like everything's fine. On May 12th, there was a list of concerns that the union sent to OCA. And in that list of concerns, we did write that we look eager to speaking with you. And they never called us back, and they never met with us again. And when it comes to Beaver Street, they're just off the grid. They're just not readily available. Days go by before emails are answered, and phone calls, I can't even tell you that there's no one answering back on the phones. It took 3 weeks after phase 1 reopening to receive guidance from OCA on the Families First Coronavirus Response Act. As Nassau and Suffolk opened first, they had no guidance for local administration and human resources to instruct our membership if they could not return to work, what they were to do. I think that is a main concern. Everyone has touched base on HVAC. In Nassau County, like anyone else, they're controlled by Nassau County. We have requested numerous times to find out what is being done for the HVAC systems, what kind of filters are they using, and we have yet to receive that, other than that they sanitize the registers on a weekly basis, and that filters will be changed within the 90-day period. And the other large concern we have out here is our family court. It is, even though we will have a new building in 2 years, right now, the building they are using cannot have public in there. I was there yesterday. I reach across the hallway, my hands touch the walls. So 6 feet is not able to happen in family court out here in Nassau County. All litigants are told to wait outside regardless of the weather. Our members care about the litigants they serve. They call us all the time, and we have discussed maybe tents or something to put people in, and that's not happening. And when it comes to a case in the courtroom in family court, they have this list of, 10 people can be in there at once. That's just, it's like being in a closet, and it shouldn't be going on. They are not ready to open fully. With that, I yield, and thank you for this opportunity. I really appreciate it.
Thank you very much, Peter, and thanks to all the witnesses today. I will start with Senator Savino, who has had her hand up. Senator Savino.
Thank you, Senator Hoylman, and I want to thank all of the co-chairs of the committee. And I just want to briefly address a couple of points with the various unions that have testified. I want to thank all of you guys for everything you've done to keep the court system operating. The administration of the people's justice is critical. It's interesting to me that if you go back to where the pandemic appeared to start in New York State, it started with an attorney who was practicing in Kings County in the Supreme Court there, and then went home, and it became a cluster site in Rockland County. Does anybody remember that? And yeah. So what I'm hearing today, though, from those of you who are workers in the court system, there seems to be a lack of communication between OCA and the bargaining units, the workers who work there every day, as to how we're making sure the courts are clean and safe, which seems to be somewhat different than what we're seeing with the MTA and its workforce. Every night, the MTA shuts down the subway system for a thorough cleaning and a sanitizing of every subway car and every subway station, because it's deemed that the subway system is essential to the city's economy. And so why aren't we not seeing the same type of approach to making sure that the courts are as clean as they possibly can be, so that with what limited hearings we're holding, that we're making sure that the courts are clean and safe, because the administration of the people's justice, whether it's in civil, criminal, family, housing court, can go on with the least amount of risk. Again, recognizing that this pandemic really seemed to start in a courthouse in Kings County. Has there been any discussion with you guys about making sure that your members are kept safe, the courts are clean, that there's time set aside, and that we all feel secure about the way the courts are maintaining the cleanliness and the sanitization of the process of these buildings. Any one of you can answer.
Senator, first of all, good to see you. Second of all, I think that this is one of the major topics that has been addressed in the few group discussions that we have had, which really have not resulted in, changes, more, listening sessions. The real issue becomes, I think, twofold. The disconnect between a state agency working in a city-owned building or a county-owned building causes, there's just no communication at that level. That certainly isn't going to lend itself to any kind of trickle-down communication to the rank and file people, on the front lines of this thing. So that's been a problem. At the same time, I think that the localities are also having, they employ people, and they're also having problems with their employees' safety and health. And so there's been obviously a lack of personnel available to do the cleanings, so I think if you combine those two things, that's at least a starting point where we could point a finger and say, this is a serious concern on the health and safety of everybody who uses the court, every New Yorker.
I run out of time, but I would be interested to hear if anybody else has had it.
Yeah, right.
And finally,
No.
if you guys, how many of your
Senator,
members have been affected?
Yes.
I'm sorry, Fred.
No, I was going to say continue on, because I think we want to know what has been the extent of communication, Senator Savino, that you raised. So, so please continue.
Right. So if the rest of you could talk about your experiences.
We in the 9th JD have a fairly good communication level with our management. They push down many memos. There is meetings. The supervisors are always available, and there is the ability to communicate. The problem is, as Patrick said, and I said earlier, with the third-party vendors controlling the cleaning, they are not in control. And we can set lofty goals, and we can set magnificent protocols. But if you do not have the control of those people and a mechanism to deal with them directly, then it's moot. We can make all the plans we want, but we still need to have control of the cleaning folk. And as I stated earlier, in the 9th JD, the majority of cleaning happens at night. We're not really sure what their cleaning protocols are. I mean, they've talked to us about it, but when you sit and watch them and stay late and observe the cleaning, you'll see the same dirty rag wipe the same door, all the door handles down the hallway. Mm-hmm. You won't see swapping out with paper towels. You won't see individual resprayings. They'll go with what's on the rag. Now, is that a problem? Yeah, I could see that as being a problem. Right. I also see that we still have the same issue, and I'm going to reiterate it again. If we do not have control of those employees, if they're not state workers, if they're not brought in during the day to do the cleaning while the people are there, we're not keeping the public safe. We're not keeping ourselves safe. Mm-hmm. And that's just a flat reality. Are we ready to come back to operations? I don't really think so. Not in this case. Could we get to that point rapidly? Sure, but we would need the help of you senators to actually push through some new protocols that we in the state could adhere to. We are mired down in contracts and bidding processes and things like that. But I believe the Senate could really push this through for us if it's possible. And that's what I'm asking personally.
Thank you, Steve.
Thank you. Thank you. And if I could just follow up again with what Senator Savino began about comparing your work, your essential work, to work in the MTA. MTA employees, as I understand it, are able to get antibody tests and I think COVID tests. Do you have access to either of those?
They gave out a memo back in May. OCA did. They sent it to everybody's court email, but everybody was on excused leave, so nobody was aware that they were eligible or capable of getting any type of antibody or COVID testing at that point in time. So what the union did is we brought in an independent medical lab through AccuHealth and went to all our facilities, and people signed up to have the COVID test and the antibody test.
So you're providing it through your independent source. Are
Yeah.
other unions aware of your ability to get those tests?
Our union is also providing the antibody test, but during even the very height of New York's struggle with this crisis, we found a real roadblock towards getting actual COVID tests for members who were informed that they had contact with somebody who was either symptomatic or had a positive test. There still was no mechanism, and there's, I believe, still to this day, no mechanism for state employees in that situation to have been provided a location or a space to be tested, which I thought was vital, but they were only at that point strictly testing folks who were sick, not even on the fact that they had contact. So yeah, that was problematic. And, obviously that started to loosen up when urgent cares and places like that started to provide tests. But during the height of this, it was certainly a problem for a lot of our members.
Senator, can I backtrack one thing on like sanitizing and things like that real quickly?
Sure.
So since there's no sanitizing rags and things like this nature, we're told, tell your members to put some hand sanitizer on like a paper towel and wipe down like if you're at the civil count or civil office on your own. What happens when we're going to open up full time and we're going to have attorneys and litigants in at the table, defense tables, they do their one case, they take their plea. Who's cleaning that table? You go to a restaurant, you can't just sit back down at the table. I mean, there's no plan for reopening to regular court operations. And it looks like they're aiming for the first week in September or the second week in September. There's no plan for that. And that's a major concern. I mean, that's a major spread concern that we have. And, there's been no communication on since our last meeting, which basically Pat Cohen's absolutely correct. It's a listening session and nothing seems to get accomplished. We've been doing it, as often as we can, maybe 4 meetings. Someone could correct me, but to be quite honest, I get nothing out of the 4 meetings. So that's
The only
all.
thing I'll jump on, and what Pete was talking about, the hand sanitizer they do supply is on the list that you're not supposed to be using now. It's not one of the approved sanitizers, and there's a problem with it. OCA supplies.
It's not a hand sanitizer that's approved for use.
It's got chemicals in it that that are I don't know if it's unhealthy for you, but it's on that list that the state came out that you're not supposed to be using. It's not a authorized hand sanitizer at this point in time.
And that's the standard issued hand sanitizer across the court system?
One of them they issue, yes.
There has also been some issues with sanitizer being delivered to courthouses that has expired as well. Another issue that happened in the 9th Judicial District. They have made aims to get us fresh. And I believe there's a big gallon jugs that they brought in, but we still have batches which are expired. 90% stuff that is authorized. That's another issue that we do have.
Thank you. My time is up. We'll move to Senator Co-Chair Bailey.
Thank you, Mr. Chair. I just wanted to thank you all for doing what you do during this such trying times. And I'll ask you a similar question that I asked to the DAs and the Defender Association. I just want to get it for the record because it's rather rhetorical in nature. How is this affecting the morale of your employees in the desire for them to come to work and do the job that they love to do, especially when you're talking about arraignments and folks who haven't really experienced any diminution in duties? Could you just speak about that for the record a little bit for me?
I mean, some of my employees that work, there's a fear now. There's a unsettling feeling that they're not being told the truth, that they're just being told just to get back to work. They're worried about a safe environment. And now when you go around and talk to your employees, all you hear is, I got 2 years left. I got 6 months left. I can't wait to get out of here. 90 days, I'm out of here. Everybody's looking to jump ship now because of the lack of communication and the feeling of uneasiness and the unsafe environment that they're being forced to work in.
Yeah, Senator, when we started to reopen and nothing was built, you could imagine the anxiety these people were having, and the phones ringing off the hook. And then with social media, those that weren't at work didn't know what to expect, and they really came unhinged, so to speak. But like court reporters, court clerks, when there's no plexi being built and they see that we're gearing up to go back to normal operations, they want to know, what's OCA doing? What's their plan? How come no plastic has been put into these courtrooms? And being told, well, we ordered face shields for every member, and that's what you're going to do. I understand, why they are acting the way they are. And Charlie's absolutely right. I've had 35 retire since March, and I represent all the titles. So if there were to be a buyout, we'd lose 1/3 the workforce. I'm in estimation, I'm probably underestimating. People are just waiting to leave. They're in fear for their health.
Senator Bailey, I echo my colleagues' take on the fear of going to work, and I think that that's probably pervasive throughout society at this point. But I would point out something that hasn't been spoken about much during this entire hearing. And I think that some of that fear is coming from the fact that schools in some fashion are going to reopen. And obviously, our employees of every facet of society are parents, and parents first. And the concern of school scheduling, whether it's part-time, full-time, how that's going to work while still trying to maintain, your employment status and those types of things is certainly weighing on the morale and the outlook going forward for a lot of our members.
Can pretty much mirror what everybody else has said with my membership. I have a mixed bag. I have a core of some people that are just raring to get back to work, damn the torpedoes. They're not afraid of the COVID at this point. They figure they've been exposed and they've handled it. And then I'd say the vast majority are nervous. And while we've been at a no public phase, being working and with reduced shifts, people have come back, but they're still very squirrely. They're still nervous. They're still very worried. And they are now facing full reopening. The public is coming without the proper cleaning between set cases. You could ask court employees to wipe down tables, but that's going to make them even more nervous. So again, infrastructure is not there for complete opening of the courts for the public. Absolutely, we're not. Are we ready for jury trials? I don't think there's a safe way to keep our jurors safe either. We can spread them out as much as possible, but we are going to be crawling. We need some other answers.
I wanted to think, oh, wait, I'm sorry. I just want to ask one more question concerning social distancing. I asked this to Judge Marks earlier, and there's a concern, obviously, about once people start to populate these courtrooms, are they going to be adhering to social distancing requirements or recommendations? And Judge Marks mentioned that court officers were going to be utilized in the enforcement of social distancing. So has that been explained how exactly the officers are supposed to do that? What guidelines, what metrics are to do so, or is it just a blanket, hey, kind of figure it out? Because that seems to be the general message, that the messaging is nebulous.
I think basically what we definitely have markings on the floors and things like that, but really, if we're looking outward at the amount of people that populate our courthouses on an everyday basis.
But what happens with that once you tape off? We tape off rows in the courtrooms.
And it's courtrooms are tiny. We're talking about maybe fitting 30 people in there, and that's with attorneys. So it's going to be a real challenge on just keeping people distant.
Yep. I mean, what Pat was talking about is very true. What we do, we tape off rows, every other row. And our courtrooms are very small too. I think on a good day, if they hold 40 people, it's a lot. But what happens then, people congregate out in the halls and you lose your social distancing in the halls. And then, people get upset because they get there at 9:30, 10 o'clock, and they're still there at 1 and 2 o'clock in the afternoon, waiting for their case to be called. So that's an issue. That's a big issue.
Well, let me say thank you very much. And Mr. Chair, I yield back to you, and I'm very appreciative of the time that you've taken out to speak with us today.
Thank you. Thank you all to the witnesses for your testimony and for your work on keeping the courts operating and hopefully reopening them fully soon. Much appreciated. Thank you.
Thank you.
Our next panel is panel 6, and if they could assemble. We have on this panel Lara Kasper-Bakarev. She's the Program Director, Attorney at Law at the Legal Services of the Hudson Valley. We have Louis Ormichia, Staff Attorney at Empire Justice Center. Sydney Cherubim, the Director of Legal Services at the Brooklyn Bar Association Volunteer Lawyers Project. Beth Goldman, President and Attorney in Charge at the New York Legal Assistance Group. And Caroline Coffey, the Director of Litigation for Economic Justice. Each witness will have 5 minutes, and we will begin with Lara.
Good afternoon. I am the Program Director at Legal Services of the Hudson Valley. LSHV provides free, high-quality counsel in civil matters where basic human needs are at stake for low-income individuals and families who cannot afford an attorney. In 2019, we handled 14,653 cases for 33,523 clients. 47% of those cases concerned eviction and foreclosure prevention. Over 535,000 individuals are eligible for our services in our 7 counties. We operate a lean and efficient program so that we can provide critical legal services to as many Hudson Valley residents as possible. But the fact remains that we are and have always been underfunded. It is axiomatic that the right to counsel, where you and your family may lose the roof over your head and the ability to put food on your table, is essential. Now, at a time when going to court can result in an infection with COVID-19, having an attorney to represent and appear virtually for you can be a matter of preserving your health and life. I wish to remind you that outside of New York City, in our 7 counties, there is no right to counsel. We must, at the very least, maintain, if not increase, funding for civil legal services. As housing courts reopen in our catchment area, we are seeing divergent approaches in how local courts are implementing the court system's administrative orders. Some new local best practices have emerged that are consistent with these orders and safeguard public health. Our busiest court, Yonkers City Court, is now staggering return dates on new filings. For example, 3 cases returnable every 15 minutes. In this way, large numbers of tenants are not all appearing at 9 o'clock in the morning. In justice courts, where proceedings are commenced by service of a notice of petition, as opposed to filing of a notice of petition in city courts, we encourage the court system to ascertain what directives are required to ensure staggered return dates, thereby ensuring that adequate physical distancing is possible. Housing courts continue to hold virtual conferences in 2 attorney cases, and this should continue as it is critical in minimizing the number of people entering our courthouses. I do wish to point out that with regards to tenants, we are not seeing them provided notice and afforded the opportunity to appear virtually. Rather, they are being noticed to appear in person. In any case, many tenants would be unable to participate virtually due to the digital divide and due to not having access to technology. In 3 of our highest volume city courts, we have observed local practices that are inconsistent with the court system's administrative orders. Continuation of these practices is misguided given the significant backlog of cases. Let me explain. under AO 12720, which was effective June 20th through August 12th, all eviction cases were suspended, excepting those in which a tenant was represented. Under the current administrative order, AO 160A20, effective August 13th, eviction cases filed after March 16th are suspended, excepting those in which a tenant is represented. Nevertheless, inconsistent with these administrative orders, notices of petition with return dates have been filed and served on tenants in cases which are supposed to be suspended. In these cases, courts are unnecessarily holding appearances with pro se tenants and landlords attorneys at that in-person appearances. This practice unnecessarily brings additional people into court and provides landlords attorneys an opportunity to put undue pressure on tenants, most of whom are unrepresented. Tenants who may not be aware of their rights and the current suspension of proceedings are more likely to enter into ill-advised agreements with their landlords without speaking to an attorney. Additionally, we are aware that some judges have entered judgments, including default judgments, against pro se tenants in July and August that violate the administrative orders of the court system and the 9th Judicial District's administrative orders and Executive Order 202.55. Thank you.
Thank you, Lara. Now if we could hear from Louis.
Hello, I'm Louis Armecha, an attorney with Empire Justice Center, a nonprofit statewide public interest law firm. Our mission is to make the law work for all New Yorkers, especially for those who need it the most. We've heard much today about the impact of the pandemic on the courts. I help people in court who are at risk of foreclosure in Rochester and Monroe County. Together with the Housing Council and other housing counseling agencies, we guide homeowners through foreclosure settlement conferences and foreclosure litigation so they can keep their homes. We're integrated with the courts and part of a well-known broad network of housing counseling and legal services programs statewide, funded through the New York State office of the AG's Homeowner Protection Program, known as HOP. Empire Justice Center is the administrator for HOP outside New York City and the direct service provider for HOP in Monroe County. I work in the direct services area. We thank the members of the legislature for your hard work keeping families safe in their homes during the pandemic. We also deeply appreciate that courts in Rochester have sought input from Empire Justice Center and others in creating new procedures to hear cases again, in many cases remotely. But there's concern that the current system opens the door for unequal justice for some. I want to highlight 3 current themes I see and provide recommendations. First, the lack of technology for some makes legal counsel critical. While courts have reopened, many matters are being held remotely. Instead of being in the courtroom to represent clients, I log in on my computer at home and wait for my cases to be called. Similar to Zoom, people forget to press mute, there are connectivity issues, many cases are disposed of in minutes, and it helps to follow along on the docket. One can easily miss important details if they're not prepared. For many low-income communities without strong internet connections or video-friendly devices, this creates new barriers that are greatest in situations where there's also a deficit in legal representation. We're starting to see an uptick in calls from homeowners with new potential cases, in contrast to earlier in the pandemic, where many calls were about new questions in existing cases. Now it's more critical than ever for homeowners to have access to counsel, such as attorneys provided through the HOP network. Second, there must be devoted resources for language access as the courts reopen. Millions of New Yorkers are in limited or non-English proficiency and deaf or hard of hearing communities, or they have other communication barriers. Many are often at a severe disadvantage for virtual court appearances. They also face greater challenges in obtaining information about mortgage relief that may be available. For example, borrowers with limited English proficiency are likely to face long hold times if they try to speak with their mortgage servicer by phone with interpretation. Many servicer websites contain no information on COVID-19 mortgage relief options except in English, and they don't provide links to available translated agency websites. All New Yorkers should have full access and meaningful inclusion in all court services and available mortgage relief options in their preferred language and mode of communication. Third, in-person resources for low-income homeowners disappeared with virtual hearings. In Monroe County, homeowners in foreclosure attend an informational clinic before the first court date. They hear from an attorney and a housing counselor about the foreclosure process and available resources. In court, papers may be handed from one party to another. Often the court may ask me to step into the hall and talk with the homeowner to explain some complex issue. Face-to-face interactions help build trust and help establish the attorney-client relationship. Much of this, sadly, is lost in virtual courtrooms. Therefore, I make 3 recommendations. First, in Rochester and Monroe County, extend the moratorium on foreclosures and evictions for low-income homeowners as long as the pandemic continues. Recognizing that the need for the moratorium might not be the same in all parts of the state, if some foreclosures do proceed, it's critical that low-income homeowners have HOP Network or other housing counselors and attorneys to help navigate complex legal issues in what is often a digital setting. 2, commit resources to language access for people in communication challenged communities. For example, in addition to existing requirements, lenders should be required to include more information about late or missed payments and notices of default in languages other than English. And 3, inform homeowners about their rights in foreclosure proceedings. Some examples of this would include collaborations between the courts and advocates in creating webinars and recorded presentations about homeowner rights. These efforts cannot ultimately replace in-person interactions, but they may be a very good temporary fix where virtual hearings continue. Thank you very much for your time.
Thank you. Next, we shall hear from Sydney Cherubin, Director of Legal Services at the Brooklyn Bar Association Volunteer Lawyers Project.
Good afternoon. Thank you to the New York State Committees on the Judiciary, Codes, and Housing Construction and Community Development for holding this hearing to examine the reopening and operation of the New York courts during this COVID-19 pandemic. The Brooklyn Bar Association Volunteer Lawyers Project, the VLP, commends the Senate for seeking testimony on this important topic. My name is Sydney Cherubin. I am the Director of the VLP, Director of Legal Services. Since 1990, the VLP has harnessed the powerful pro bono commitment of the private bar to provide critical civil legal services and equal access to justice to thousands of Brooklyn residents. The mission of the VLP is to ensure that the legal system is accessible to those who, because of special needs or the overwhelming burdens of poverty, would not otherwise have their rights protected or their voices heard. The VLP provides direct civil legal services, education, and outreach to low-income Brooklyn residents, assisting them to overcome legal challenges to their health and security, including family breakdowns, threatened homelessness, devastating debt, immigration security, and ongoing predatory practices that overwhelmingly target the poor, the elderly, and persons with disabilities. By arming clients with the legal information and representation, the VLP levels the playing field and ensures success in court, stabilizing lives for adults and children, and strengthening the community. In addition to providing direct representation and pro se assistance, the VLP staffs and supervises several courthouse and community clinics that provide immediate and brief legal services and limited scope representation to assist unrepresented litigants as they struggle to navigate their way through the judicial process. The VLP's program dramatically reduces the problems courts face in handling overburdened dockets flooded with pro se litigants. Today, I'm here to speak on behalf of unrepresented consumer debt litigants, the Civil Legal Advice and Resource Office, CLARO, and the Consumer Debt Volunteer Lawyer for the Day programs. Over 100,000 consumer credit lawsuits are filed in New York State courts every year. The VLP, in partnership with Brooklyn Law School, created the first CLARO program in the state. CLARO is now a citywide project. CLARO was created to assist the courts in handling overburdened dockets with their ever-increasing number of unrepresented litigants. The CLARO Clinic in Kings County is staffed every week on Thursday from 2:30 to 4:30 and 6 to 8. Volunteers meet with unrepresented litigants to ensure that they have the tools to go into court to defend themselves against aggressive and sometimes abusive tactics of creditors. In 2019, we saw 1,721 pro se litigants at Claro. Up until March of this year, we had 508 visitors. In 2009, what we saw as a natural progression, the Consumer Debt Volunteer Lawyer for the Day, VLFD, was created. In this program, a consumer attorney is present 4 days a week in the Kings County Civil Court, working with volunteer attorneys, graduates, law students to provide limited scope representations to pro se litigants and consumer debt actions. In 2019, we assisted in 1,510 cases, and up through March 12th of this year, 341 cases. Prior to the pandemic, consumer debt cases presented a true crisis in New York City, seeing numbers increase over the numbers in 2008. And while we anticipate a dramatic shift in the numbers, a surge in the numbers, the people who are affected by this are especially are people from especially low income communities and communities of color. As it has become increasingly clear, these are the communities that have been disproportionately affected by the pandemic. Over the last few months, while consumer debt collection efforts have come to a standstill, the anxiety that our clients feel have not. Should I go to the courthouse? Will I have a default judgment? Will my case be dismissed? These are questions that stem from the unknown, and it's very confusing for unrepresented litigants, and it's also confusing for legal advocates and attorneys. This week alone, we spoke to 12 litigants who had not received notification that the case had been postponed. We spoke to a client, an elderly client who had had surgery and went into court because she had not been notified that her matter would be adjourned. She was at high risk for the COVID virus. I think it's important that we notice that the court has to avoid having people take the risk of going into court. And they can do this by providing clear information regarding the court procedures. The court also needs to recognize the digital divide and not take for granted that email, internet, and Wi-Fi is readily available to all. It's also important for the court to keep in mind that access to justice is very important, and many people are suffering. So I'm asking that the courts make a commitment to improve messaging and communication to litigants and legal advocates, develop policies and procedures and access to technology for unrepresented litigants, and to ensure that access to justice remains a priority. Thank you for your time and your consideration.
Thank you very much, Sydney. Next, we'll hear from Beth Goldman, President and Attorney in Charge at New York Legal Assistance Group.
Thank you. Chairs Hoylman, Bailey, and Kavanaugh, good afternoon, and thank you for holding this hearing and for inviting me to speak about the reopening of the courts during COVID. My name is Beth Goldman, and I'm the President and Attorney in Charge of the New York Legal Assistance Group. We are a civil legal services provider in New York City, and our lawyers appear in courts across New York City, Nassau County, and Suffolk County on behalf of renters facing eviction in housing court, people with homes being foreclosed upon in Supreme Court, domestic violence survivors in family and Supreme Courts, and consumers in civil court, and the list goes on. But I say that because we're in all the courts, and I think we see what's going on. I've submitted written testimony, and I won't read it, and you've heard from a lot of people. So I want to just focus in on a couple of issues, many of which you've heard about, but I want to focus in. First, the priority here has to be that we do not force anybody to go into court. And I know you've heard a lot of people say that, but let's keep in mind that the pandemic has disproportionately impacted low-income people of color, and those are our clients. And in considering court reopening, it is critical that they and us not be mandated to come. we need to minimize in-person proceedings. Now, I think we've heard a number of officials from OCA say that that's what is happening. But the other thing you've been hearing is people showing up because there isn't clarity. You just heard in the last testimony, and that is true. But we're also seeing that there is discretion given to court personnel about who comes and who doesn't. And so what happens is there isn't clear direction from on high to judges about what they have to do. It is left to them. So for instance, I think you heard it from Tina Longo on the criminal side, we've had it on the civil side, where a judge insists that parties show up for a conference on a foreclosure case in Nassau County that takes 5 minutes, but the client and the lawyer have to come. And in the old days when that happened, that was very annoying. But now when that happens, that is unnecessarily risky. And so I think what we're seeing is a need for clear direction from on high about this. But then the next step is there are still going to be some proceedings that have to go forward in court. And what you've heard today, and what I want to reiterate, is that OCA has not yet done what it needs to do. It has not put into place plans that we then have access to so we can see what is going on when it comes to the ventilation systems, when it comes to traffic flow and social distancing, when it comes to density limits, when it comes to strict enforcement of personal protective equipment. We don't have a report from the epidemiologist, as you heard. So given that the courts are not yet clearly set up to do this, we need to make sure that in-person proceedings are kept at a minimum. I want to turn for a minute to virtual proceedings. We've been talking a lot about it, and it's a new world. And you've heard from a lot of people about the digital divide, and that's absolutely right. The Office of Justice Initiatives issued a report, that's an OCA recommending that judicial districts convene local interdisciplinary stakeholder work groups to draft protocols to enhance access for unrepresented court users in certain areas. I don't believe that that's happened yet. And there are so many questions that need to be dealt with when it comes to virtual hearings. Just to identify a couple, how does the platform provide for confidential consultation between lawyer and client? How will attorneys approach the bench to address the judge without being heard by others? How will courts ensure language access, which you've heard about? What's the impact of technology on credibility determinations? What happens when somebody has a low quality internet connection that makes the litigant sound less truthful? What are the due process implications of having the attorneys separated from their client? I could go on. So OCA needs to deal with this and needs to get the stakeholders together to address these issues. We have a lot of smart people, a lot of smart lawyers who are very experienced. I think we can work together to come up with that. The last thing I want to hit, and there are a million other things, is about the housing court. We can talk about all the different procedural things we need to do, but in the end, we can extend the eviction moratorium, which is essential, but there needs to be money in the system to pay for this. And there need to be adjustments to various programs to allow people to get funding to pay the rent so that they can stay in their homes. And that is the next frontier. We know there isn't a lot of money right now in the system, but until we find some, we can come up with lots of solutions, but they're not going to work. So thank you very, very much. Appreciate the opportunity.
Thank you, Beth. Next, Carolyn Coffey, Director of Litigation for Economic Justice.
Thank you, senators and your staff, for inviting me here today to testify. I'm Carolyn Coffey, Director of Litigation. The missing part there is that I'm at Mobilization for Justice, which is a civil legal services office in New York City, and we serve over 10,000 clients and their families each year. I directly supervise our Consumer Rights Project, and we help low-income New Yorkers on a range of consumer problems. I'm also a consumer expert at the Claro Clinic that Mr. Trubin previously described. So I echo, as a legal services attorney, what all of my co-panelists have said today, but I'd really like to focus specifically on debt collection cases and the court's response in the wake of the COVID crisis. These cases and these litigants are often overlooked. They are not something that we've heard too much about today. But to put things in perspective, over 1 million debt collection cases were brought in New York City Civil Court alone over the past 10 years. And really important to note, 96% of the litigants sued are pro se, so they do not have attorneys. These cases are often brought by third-party debt buyers, and they're notorious for being filed en masse and with very little scrutiny and very little oversight by the attorneys who bring them. They're kind of rife with problems. That's not what I'm going to talk about today, but it's important to know that a lot of these cases end up as default judgments, and those judgments have really devastating consequences on low and moderate income New Yorkers and their families. So it's well established that debt and debt collection cases disproportionately affect communities of color. And we all know, and others have testified today, that the coronavirus and the crisis is disproportionately impacting those same communities of color. So I can't emphasize enough that the COVID crisis is going to have long-lasting economic effects on communities of color. These communities are going to be and have been unfairly impacted by the inevitable onslaught of collection cases that's coming. In terms of the court's response, I really appreciate Judge Marks's remarks earlier and the immense challenges that the court is facing in managing this pandemic. But I have to say that the court's response when it comes to debt collection cases has really been lacking, and pro se litigants really seem to be a bit of an afterthought. The various administrative orders and measures being contemplated really don't take into account or consider the fact that low-income New Yorkers, can't afford attorneys, and those are the same people for whom coronavirus is a really serious threat. These are litigants who were ill-prepared to navigate the court system before the pandemic, and certainly without the resources from our offices in the courthouses are even more disadvantaged. There's also been very little communications by the court, as noted by others, with litigants and with advocates, and very little outreach to advocates to try and get their input and perspective, to provide the perspective of pro se consumers. Every legal services attorney I know has expressed incredible frustration just trying to reach court personnel on the phone. We're unable to get consistent information to share with our clients and with each other. And there's really also a lack of procedures and protocols in place. I can't sit here today and testify how a pro se litigant in a debt collection case should file an answer or even obtain their court file. It's unclear to me. In our testimony, we include several recommendations, and I just want to point out a few of them right now. I think it's really important that the court limit the court proceedings to only essential cases. There should be no rush to resume debt collection cases. When they do resume, there should be safety benchmarks in place and procedures and protocols and adequate notice, and all of that should be taken care of before opening up the court rooms to debt collection cases. No default judgments should be entered in consumer debt cases until well after the COVID crisis is over. Also, COVID should not be used as an excuse to implement alternative dispute resolution in debt collection cases. And there are a couple of legislative initiatives that would also address some of the issues that I've raised today, mostly sponsored by Senator Thomas. So thank you for your time.
Thank you so much, Carolyn. And speaking of Senator Thomas, I believe he has a question. So I'm going to throw it to him, and then we'll hear from Senator Bailey.
Hi, everyone. Some of you might know me already, so I don't want to re-identify myself. But thank you so much for being here and for your testimony. I've heard a lot of complaints from my former colleagues about what was going on in court, especially when it comes to order to show causes to vacate default judgments. Can Sydney or Carolyn or Beth talk to me about their frustrations in trying to vacate default judgments in court during this time period?
I mean, I can give you an example of one client we helped. We're helping someone with pro se paper. She's a Latina woman from the Bronx, and she found out in the pandemic that there was a medical debt judgment entered against her, and we helped her prepare papers to go, which she had to file in person to try and vacate that default judgment. And she was turned away at the courthouse and told that she actually had to call a phone number and schedule an appointment with the clerk, which isn't true and was inconsistent with other information that we had been given and had conveyed to other litigants. So when I say there's like a lack of communication and inconsistency, it's incredibly frustrating. And this is just someone who we happen to know about. I just don't know what's happening to pro se litigants who don't have legal services attorneys to even ask their questions to.
So when you do see judgments and enforcement of those judgments by, the plaintiff's attorneys when they freeze someone's bank account or go after their paychecks, like what exactly happens next? I mean, usually before pre-COVID, that order to show cause would go through. Is that what all of you are doing now? Are you guys filing order to show causes? Like what's going on?
We are attempting to file orders to show cause. We recently had one successful filing where the client was able to obtain a date and has to appear virtually next week. And so we've taken every step possible. So we've used the EDDS system to file, and sometimes it's been rejected and the client is told that they have to bring it in to court. So in order to cover our bases, we will use any manner possible to file the order to show cause, starting with the EDDS system. And then if that's not successful, we're advising the client to go into court if they feel comfortable going out. And so, and for them, they don't really have a choice because their wages are about to be garnished or their bank account has been restrained. So they have no choice but to go out, whether they're comfortable or not, to get that motion filed.
Would you say it would be accurate that there's a huge hardship on pro se litigants right now, especially with trying to vacate default judgment, because there's no clear policy and whatever policy is out there is actually hurting them than actually helping them?
Absolutely. There's no policy in place. There are also no resources available in the courthouse. In March, you could say, go upstairs and see the people at Claro, and we could assist. These resources are not available. People are not being directed to those resources. And I think that's something that should be in place. If someone calls the help center, there should be a list of places that they should be referred to where we could potentially assist them. So lack of resources, and then lack of information, as well as lack of resources to organizations like ours.
Thank you, Sydney. Thank you, Carolyn. Thank you, Beth. Thanks to the rest of the panel.
Thank you, Senator Thomas. Now we'll hear from Senator Bailey. 5 minutes.
All right, thank you very much, Mr. Chair. I appreciate that. I am juggling a couple of different things here, so I apologize. So, Lara,
where are you, Senator Bailey? That's my first question.
Where in the world is Senator Bailey? I am. This is the Carmen San Diego. I am at the kitchen table. As you can see, the artwork in the background by my daughters, and hopefully this doesn't count against my time clock, so I'm gonna stop. So, Lara, you referenced the same thing that Senator Thomas was talking about, the default judgments. Can you talk about, I guess, your experience dealing with these default judgments that are clearly in violation of these orders?
Yes, in all 4 of these cases, these were cases filed after March 16th. So these were cases that were supposed to be suspended. And in fact, the cases should have not even been noticed for a court appearance. But apparently there was a petition, filed with a court date, and the court then held court without the tenant, without the pro se tenant, and entered default judgments in those 4 cases. We were able to engage one of those litigants and were successful in vacating by doing an order to show cause one of those defaults. We applied as a friend of the court for the judge to vacate the other 3 defaults, and the judge refused our request.
Again, like at the very least, that's troubling. A 25% success clip on default judgments that shouldn't be happening during a pandemic, during the likes of which we've never seen. I just want to make sure that that was stated again for the record, so that we can see how egregious that actually is. From my understanding, there's a COVID-19 recovery task force. Again, it's been spoken about. New York State court system. It is a housing working group, and they have made recommendations. What, I guess, Lara or anybody, what are your thoughts about the recommendations that have been made, and what can we continue to do to ensure that we keep people safe and at home?
Right, so I can speak to that. The recommendations of the report are sound and really apply statewide. Number 1, the right to counsel being essential. Number 2, with regards to increasing the partnership between private attorneys and legal services organizations to increase pro bono volunteerism. And with regards to that, it was noted in the report that legal services organizations would need more funding, more infrastructure to be able to support such increased volunteerism.
Okay. Anybody else on that point before my final question? Or?
I was actually on the housing working group of that panel, so I'm very proud of our work, and I think we've made some very, very important recommendations that can work. We are still trying to build out this pro bono piece because it's going to be essential. But one of the things that we made a point of saying in the report was the point I made earlier. So I'm sorry to be banging on that soapbox, but we can have lots of pro bono attorneys, but we're still in the end going to need some sources of funding. And I think there are programs that could be expanded. The requirements for those programs could be loosened so that we can have access. I know the legislature has set up this $100 million pot. We're going to have to get to a place where we have more than that. But thank you for the plug for the.
I would say continue to knock on the drum, and I think that this speaks to the adage of a closed mouth doesn't get fed. So that's by all means, you should be continuing to sound that alarm, because we're dealing with housing, and we're dealing with survival, and we're dealing with people's access to a place to live. So by all means, do not be shy about continuing to sound the alarm. I guess the last question would be for Legal Services of Hudson Valley and anybody else. The right to counsel, critically important. Have any of you participated in any pilot right to counsel programs? And if you have, can you explain? And how can we be expanding on trying to ensure that folks receive adequate counsel, especially in days and times like this?
Yes, so Legal Services of the Hudson Valley in 2019 was allocated $200,000 by Westchester County to fund the Yonkers Enhanced Access to Counsel in Housing Cases program. So this is not right to counsel in that every tenant who arguably, was entitled to counsel because they were low income, they weren't going to get an attorney, but it was a limited pilot. We represented 150 clients from households at or below 200% of the federal poverty guidelines. And during this one-year contract, we prevailed in all of the 89 cases that came to close. So we prevented homelessness in the 89 cases that were litigated and finished. So we're very proud of that. And I think that is in line with the national statistics that show that when a tenant has an attorney, they are much more likely to be successful. I believe the percentage is 77%.
I just wanted to thank you. I know my time is up, Mr. Chair. I just wanted to say thank you for the work that you're doing in Hudson Valley. I am a Bronx boy through and through, but I represent the great city of Mount Vernon in Lower Westchester County. And it's actually quite literally the street that I live on actually turns into Kingsbridge Road into Mount Vernon to show you how close I live to Westchester County. So it's critically important that our brothers and sisters in Westchester County be looked at, especially in Mount Vernon, where we're facing a significant housing crisis. And I just want to make sure that I thanked you and the work that everybody in Legal Services Hudson Valley is doing, the work that you're all doing across the state. It's God's work, and I am truly appreciative of the work that you're all doing. With that, Mr. Chair, I yield my time back to you.
Thank you. Thank you so much, Senator Bailey. I wanted just to note that there is legislation that would create a moratorium on debt collection and the accumulation of interest on money judgments and the entry of debt related to default judgments during the COVID state of emergency. That's S8441A. It's actually legislation that I introduced, which is where I know about it. It's interesting as we discuss the fact that the need for a right to counsel bill or additional funding for your vital legal services, that the pandemic has impacted the demand on your services. Very briefly, could each of you give me a sense as to what proportional increase has occurred since March for the demand for your services? And then we'll go to Senator Kavanaugh because we want to keep the hearing moving.
I think with people being at home, they have more time to think about things and address issues that they are facing. And for a little while, I think we weren't getting as many calls with regards to consumer debt matters. But once the courts sort of reopened and collectors and creditors were given free rein to start collection efforts, we then started to get an increased number of calls, people who were receiving notices that their wages were going to be garnished or that their bank accounts had been frozen. And the challenges we face are some of the technological challenges and not being able to have people fax over documents or trying to talk people through taking a photo and texting it to someone. And so
are you seeing scores more cases or hundreds?
We have, since the courts have allowed new filings, I believe there have been in civil court, and I have the numbers up on my screen if I can pull it up. So in civil courts, since they've allowed filings, since June 29th, there have been 384 filings in the civil courts. What we've also noticed is that these debt collectors were also availing themselves to the Supreme Court, where there have been 161 new filings in the Supreme Court. The concerns that we have with the filings in the Supreme Court is that although it's the court of original jurisdiction and any case could be filed there, we're seeing cases being filed there for $3,000. The problem with that is we have people being sued on consumer credit matters. They're being sued in Supreme Court where there are filing fees for filing an answer and for filing a motion. They don't have the money to do that. Yes, there are fee waivers available, but the procedures to obtain a fee waiver is not easy. And so it's just another procedural hurdle. So the filings have gone up since June 29th, and those numbers are up to date as of June 30th. So the numbers have gone up, and thus our call volume has gone up as well, and the need continues to grow.
Oh, sorry, Carolyn. I'll just do a quick, I think what we've seen is there are areas that are quiet and there are areas that are noisy. We started a hotline specifically for, in COVID era, and we got calls on things like unemployment insurance, which is something we never used to get calls on, right? Hundreds of calls on that, many more calls than in the employment world. We also health insurance issues, but then fewer calls in the domestic violence world, which was what we predicted would happen. And what we are mostly concerned about is what's going to hit. We expect the onslaught to sort of start to hit. I think we thought August, because of eviction moratoriums and other moratoriums, it's gotten kicked out a little later, but we expect an onslaught of cases coming to us in the next few months. So we're we're working with what we've got now, but gearing up for the big push.
Yeah, and this is for Mobilization for Justice, I would echo what Beth said, that we have also seen sort of changes in the kinds of problems that people have, particularly around the economic stimulus payments. Certainly, as Sydney has identified, we are seeing more calls now that cases are being filed and judgments are being enforced. So we are very concerned about the onslaught and really see debt collection and bankruptcies increasing, probably very staggering in the near future.
Thank you very much. I'm going to turn it over to Senator Kavanaugh. I do want to mention that Senator Thomas wanted to know about court files and access to them, and whether you were having access. You could answer that in part of Senator Kavanaugh's questions, I guess. Thank you, Senator Kavanaugh.
Thank you for yielding my time to.
It was to Senator.
I get it. That was very deft. Okay, thank you very much. I'll try to be brief. I'm just going to say, the comments about the need for HOP funding, and particularly for the homeowner protection program, particularly to make that permanent. That's been a fight each of the last couple of years. I would just note that that's a program that came out of another very serious crisis of homeownership and foreclosure. And I think, sadly, we are back in the moment of a major crisis on that. So hopefully there'll be less resistance to coming up with a long-term solution for that next year. But thank you, all of you who have been involved in that fight the last couple of years, and also who have been using those funds to make sure homeowners have the resources and the information they need to protect their rights. Just to follow up, are there other legislative changes with respect to foreclosures that would be helpful for us to enact, given the emergency that we're in? Okay, I'll keep moving. I think a couple of you mentioned. Well, first of all, let me just say, Jamal Bailey raised this question in response to Lara Kasper-Bekaroff's testimony that it's very disturbing to hear that there were at least 4 cases that seem to have been to proceed in violation of the existing standards from the Office of Court Administration. If anybody here I asked Judge Marks what happens when a local court exceeds the authority or doesn't follow the terms of an existing order, and he said that they work with local judges and local leadership in the court system to address that. I think to the extent anybody is familiar with any other circumstances, I think we'll follow up on that one. But if there are other circumstances where that's going on, I think we would like to, for anybody here on this panel or anybody listening, I think the committees would be interested in hearing about those instances so we can see if we can get them addressed in a more, sort of global way. Ms. Goldman, you mentioned, I think in your written testimony as well as in your oral testimony about the need for rent relief, for funding for that. And, we put $100 million out there, which in a normal world, a brand new $100 million program is a big thing. But we're very, very aware that it's not sufficient to the need here now. And of course, a lot of us are looking for $100 billion from the Congress nationally, of which New York might get 10 billion, which is about 100 times as much as 100 million. But just can you talk a little bit more about the role of cash relief and getting that in place and how that might affect the work you need to do in the courts?
Sure. And I do know there's going to be a housing panel after me where you have even greater experts than I on the subject. But what we do know is that there are limitations on what cash relief programs can do based on, for instance, whether somebody has a job or not, based on what's come before. And so one of the things we think has to happen is that we have to change some of the rules for when the one-shot deals, for instance, or FEPs can be applied. There are income rules. There are other rules. And so we need to find ways around that, I think, my sense of HRA in New York City, very much willing to work with us, but they need to have rules that allow them to do that. So, we would happily share with you some ideas that we have as a community in the housing world of some of the programs we think could be adjusted that would make a big difference.
We'd be greatly interested in that. In addition, have you had a chance to look at this Senate Bill 8140? It's the COVID Emergency Rent Assistance Program. It's carried by Assemblymember Simbrowitz in the House. It's a bill we've introduced in March, and we've been modifying to try to be prepared to spend a great deal of federal money if it materializes. And it is intended to be a different approach that doesn't have these provisions about demonstrating that you have a long-term ability, like a different approach than the one shot. So if you have feedback on that, we'd also be very interested in hearing that. And I forget what Senator Hoylman's question was, but if anybody wants to use my 18 seconds to address it, that would be great. All right. Or
I think the question.
Sorry, go ahead.
No, go ahead. I was going to say the question was about court files, and I don't know if your experience is any different, but we have extreme frustration with getting court files or getting an answer as to how to get a court file, and it's impossible to get an archived court file.
And I wanted to chime in just to say thank you again for the attention to the HOP funding that was mentioned a short while ago. I'll reiterate, the three recommendations that I had. I think will help to address what we also see as a deluge coming ahead with additional court filings and court matters. The types of questions we were getting early on in the pandemic related more to ongoing cases, which had already started, but in recent weeks, we've started to see an uptick in more and more calls from people who are getting court notices now for the hearings that are starting up again. Also, I've had others in my office mention I work mainly with direct services and foreclosure prevention, but others at our Rochester office for Empire Justice Center work on unemployment matters. And at 1 week, some weeks they were getting 300 calls a week. Their limit was to take about 150 calls and ask the others to please call back because there was such a deluge of calls. And that continues to some extent. And also, we're concerned about car repossessions coming up. That's another matter that we see.
Thank you so much. Thank you to all of our panelists. Sorry, Carolyn, that I didn't mention Mobilization for Justice. That was not somehow I spaced.
That's in my district, Senator Hoylman.
I know, but it wasn't on the list of witnesses. But thanks everyone, and we're now going to. These panelists will depart with our gratitude, and now we will have our penultimate panel, and that means next to the last, Senator Kavanaugh.
That's a little. I took 3 years of Latin, so I'm familiar.
Yes.
Thank you.
Your good education has come to some use. Panel 7, which is be composed of Amy Gathings, supervising attorney at the foreclosure at Western, supervising attorney at foreclosure at Western New York Law Center. Jacob Inwald, director of foreclosure prevention at Legal Services NYC. David Crossman, staff attorney at the Legal Aid Society of Northeastern New York. Adrian Holder, attorney in charge, civil practice at the Legal Aid Society. And let's start with Amy. 5 minutes, please.
Thank you. Good afternoon, and thank you so much for having me today. My name is Amy Gathings. I'm the supervising attorney of the foreclosure unit at the Western New York Law Center, which is a nonprofit organization that provides free legal representation in the areas of mortgage and tax foreclosure, as well as consumer debt. The coronavirus pandemic has highlighted the institutional inequities in our society relating to access to justice. Free legal service agencies are facing funding limitations, while at the same time, the need for these services is at an all-time high. The lack of a civil right to counsel means that many litigants will have to go unrepresented in cases that impact their basic human needs, such as housing, food, etc. The court system faces a significant challenge in balancing the rights of litigants with health and safety concerns. But we feel that providing access is crucial, as the courts are responsible for determining issues that are essential to people's ability to survive from day to day and keep their families healthy and safe, including the ability to maintain stable housing. One of the greatest tools to ensure housing stability that we have in New York today is the state-funded HOP program, which has been already discussed in the previous panel. Continued and permanent funding of this program is absolutely essential to preventing the devastating impacts of foreclosures on families and neighborhoods, especially during these very difficult economic times. The foreclosure moratorium imposed by New York State has been very helpful for our foreclosure clients. We support a continued moratorium of the entire foreclosure process with one exception. CPLR 3408 mandatory settlement conferences are invaluable to homeowners' abilities to resolve the foreclosure and avoid losing their homes. As such, these conferences must be allowed to continue in a virtual manner, even while the remainder of the foreclosure process is put on hold. Without these conferences, there is often no recourse if a foreclosing entity fails to follow state and federal laws and regulations that govern mortgage servicer behavior, and no way to address lack of responsiveness to requests for mortgage assistance or forbearance plans, imposition of excessive fees, and other abusive practices that we see in a constant basis in our practice. Furthermore, the initial conference is where most of our clients are connected to our services. Pre-pandemic, our office was available at every initial settlement conference session to provide an informational presentation and conduct intakes. Virtual conferences and our telephone conferences can be utilized to ensure that foreclosure defendants are able to participate safely in their initial settlement conferences. A virtual meeting facilitated by the courts between legal services providers and homeowners prior to the first conference would be very valuable to replace the informational sessions and intake meetings that were conducted in person prior to the onset of the pandemic. Vital to ensuring that homeowners can participate in conferencing is the sending of clearly and simply written notices that are sent out well in advance that allow homeowners enough time to make appropriate arrangements and ensure that they have the appropriate technology to be able to participate. These notices must also include the contact information for legal services providers. Courts should provide multiple options to homeowners for making appearances in these conferences, including video conferencing, telephone conferencing, and also providing a desk within the courthouse that might contain a computer for those who don't have telephone service or internet service, which occurs especially in rural areas. Courts must also give homeowners multiple chances to make their appearance at the initial conference. We all are facing so many obstacles in our daily lives. It's very difficult for homeowners to be able to make these appearances, and it is essential that they be given multiple chances and multiple initial conferences to ensure that their rights are protected. There are so many technological disparities, childcare issues, rigid work schedules, illness, and all the other things that are going on in people's lives today. So leniency on the part of the courts is essential and necessary to make sure that homeowners' rights are protected. Regarding tax foreclosures, we are concerned about the ability of municipalities to obtain a judgment of foreclosure to proceed to auction at this time. There are very few protections in place for defendants in tax foreclosure matters, and these difficult times have highlighted the need to impose greater protections and possibly institute a settlement process, court facilitated settlement process for those defendants. So with that, I will conclude, and I thank you very much again for having me today.
Very much, Amy. Now, let's hear from Jacob Enwald, Director of Foreclosure Prevention at Legal Services NYC.
Thank you, Senators. I'm Jacob Enwald. I'm the Director of Foreclosure Prevention at Legal Services NYC, the largest civil legal services provider in the country. We also have the largest foreclosure prevention practice in the country. We've submitted very detailed testimony, which actually includes copies of very detailed communications we've had with the Uniform Court System, making very detailed recommendations, which I refer you to, and I'm not going to go into those recommendations at length because it would be tedious and impossible to do in the 5 minutes allotted to me. I also want to mention that my colleagues who practice in housing court submitted as well their own separate set of testimony dealing with the housing court issues. The one thing I want to start by saying is foreclosure cases are fundamental to issues of racial justice. We know that New York State's low and moderate income communities of color and the elderly bear the brunt of the impact of the pandemic, but we've also known for years that foreclosure cases disproportionately impact communities of color. So when we're talking about the process of what goes on in court in foreclosure cases, we're talking about racial justice. The other thing I want to start by saying is we know there's going to be an uptick in new foreclosure cases. They haven't come yet because we've had a patchwork of moratoriums and forbearance plans keeping them at bay. But just yesterday, Bloomberg ran a story that revealed that FHA-insured loans, which are the affordable loans that first-time low-income and minority borrowers typically use, to access homeownership, have their highest delinquency rate in 40 years right now, with 16% of them in default, and with New York's rate of default third in the nation. So that's a harbinger of where we're headed. As I said, we sent a detailed letter on behalf of New York City legal services providers, not just my organization, but all of them, on June 24th, which detailed the concerns and made very numerous specific recommendations on resuming court activity, along with an earlier letter to him where we had separately expressed the concerns about the impact of virtual court appearances on the unrepresented. You've heard a lot about that already today, so I won't belabor that, but that is a big part of our concerns. The overriding theme of what we wrote to the court about is the need to connect homeowners at every stage of the proceedings with advocates and to replicate the court clinics, friend of the court tables, and other courthouse interventions that we have created in partnership with the judiciary, which have shut down since the onset of the pandemic, like several of my colleagues have already mentioned. We're hoping the judiciary will consider our recommendations, but so far much remains to be seen. We'd like to see guidance to ensure best practices in every courthouse in the state, but so far considerable discretion has been left to the individual courts, resulting in some questionable practices, such as a judge in Suffolk County demanding in-court appearances with 4 conferences in one case, in 4 separate cases happening simultaneously in the courtroom. And there's no reason why conferences like that with parties represented by counsel on both sides can't happen virtually. Similarly, although the guidance encourages, actually says that unrepresented people are not supposed to be compelled to participate in virtual conferences, we're seeing unrepresented parties compelled, which is hugely problematic for people who are on the wrong side of the digital divide. We've made detailed suggestions for the 3 major stages of foreclosure litigation: the settlement conference stage, the litigation stages, discovery and motion practice, that is, and post-judgment phases. In particular, there's huge concerns about auctions and surplus proceedings, which are plagued by a lack of transparency and lack of information. So we're hoping the court is willing to have a dialogue with us, but so far we have some concerns. I'm thankful that my colleagues already mentioned the HOP program. The judicial foreclosure process can't function without that program, but it's been talked about, so I'm going to skip finally to policy proposals. This relates to the question that Senator Kavanaugh asked on the previous panel. I have an answer to that, and it's a bill that he in fact sponsored. S8789 A10851 would go an enormous way towards reducing the cases that become foreclosures. It would provide for a private right of action to be able to enforce New York's pretty strong mortgage servicing rules, which the mortgage servicers disregard with impunity right now because there's no way to enforce it. So that would be something that the legislature could actually do that would keep cases away from the courts and prevent them from becoming foreclosures. So miraculously, I got through that. My time's up. Thank you very much for letting me testify today.
Thank you very much, Jacob. Well done. David Crossman, staff attorney at the Legal Aid Society of Northeastern New York.
Thank you, Senators. Thank you for the opportunity to speak today. My name is David Crossman. I am a staff attorney at Legal Aid Society of Northeastern New York. I represent tenants primarily in Schenectady County, both city and town courts. I've started doing landlord-tenant law as a pro bono scholar in law school, and decided to stay here at Legal Aid because I feel it's one of the most important things I could do in the civil context. And obviously, it's no surprise that we've been in the middle of a housing crisis for quite some time in this country. And I don't envy the task of the state leaders here today grappling with this in the midst of a public health crisis and an economic crisis at the same time. I appreciate the recognition from all three branches of government that moving forward with evictions presents public health issues, not just economic issues. And I thank you for the attention that's being given to these issues in today's discussion and the opportunity to speak. Right now, I am speaking pretty much anecdotally and a little bit prospectively. I have yet to have to appear in a landlord-tenant case since March, although some of my colleagues have, and this is obviously changing. I can say with some certainty, as anyone in legal services could say, that the cases that we see in legal services are only a small percentage of the cases that are out there. For instance, I administered the Attorney for the Day program in Schenectady City Courts. And during that time, we were able to represent 80 to 85% of tenants who signed up for assistance, but the percentage of tenants who were eligible and signed up was only 18%. That's 1/8. So obviously the Housing Stability and Tenant Protection Act was not even a year old when we entered into the pandemic. And that prompted some necessarily changing federal and state laws and executive and administrative court orders. So now we're at a place where a tenant's rights may depend on the mortgage that the landlord holds. And there are nuances, there are new arguments, and in these layers of the federal and state protections, including a scarcity of case law about the brand new HSTPA that increased the risk that a tenant could lose her home without ever knowing she had a defense to the eviction. And I would say that even with representation, these landlord-tenant cases are much more complicated than ever and may require a new level of review, unlike previously. In my research on disclosure, which is not allowed as of right in landlord-tenant cases, I did come across this quote. We're used to hearing in evictions that evictions are called summary proceedings for a reason. However, in 1955, the first department appellate term said, quote, "A summary proceeding, despite its name, is nonetheless a judicial proceeding, and the ends of justice ought not be sacrificed to speed," end quote. That said, 4 months seems like a long time since March. However, since the day New York went on pause, many of my clients have a similar story. Landlords are not showing apartments. They are unable to relocate even if they want to in some instances. They do not want to take apartments sight unseen. Some tenants are also unwilling to avail themselves of protections of their local code enforcement for fear of being ordered to vacate and spending the night in a homeless shelter, which would further expose them and their families to the risk of COVID. In some cases, the landlords with a building with violations reports the violations him or herself, sometimes after turning off the electricity or other utilities. Luckily, we have been able to, or at least I personally have been able to straighten out a lot of these issues without having to file an essential matter. I'm also kind of assuming that most of these new eviction proceedings will be served either through substitute or conspicuous place service. Many of my clients are extremely reluctant to open the door and accept a piece of paper from a stranger at this point. Right now, my colleagues and I are working on running down details from various courts on pre-March 17th filings and warrants. And we also have seen, at least in a handful of instances, we believe there are a couple of post-March 17th filings that are being scheduled. And hammering out details of virtual appearances in some courts has been described by one of my colleagues as a bumpy ride. I would point out, I don't necessarily disagree with a comment that was made earlier about the courts not being necessarily a place for children right now. However, I would point out that the vast majority of my clients are single parents, mostly mothers, or they're the primary caregiver. Childcare was largely beyond their means prior to this, and it certainly is now, and it's also fraught with some other risks. So I think when we think about respondents, sometimes we also have to think about the family that would come along with them. Thank you for the opportunity. I'm ready to take questions.
Thanks so much, David. Let's now hear from Adrian Holder, attorney in charge, civil practice at the Legal Aid Society.
So sorry. Can you hear me now? Thank you. Good afternoon. I'd like to thank the Senate Standing Committees on the Judiciary, on Codes, and on Housing Construction and Community Development for taking the time to hear from us today and to express interest in exploring this very important issue of the reopening of the courts. The Legal Aid Society will be submitting written testimony outlining our suggestions for all the high volume courts where we all appear. And you'll be hearing from, you've already heard from my colleague Tina Luongo. You'll be also hearing from my colleague Dawn Mitchell on the next panel. I am the attorney in charge of the civil practice of the Legal Aid Society. And although I represent more than 500 staff working on more than 50,000 cases each year, I'm not only focusing my oral testimony on the impact on the reopening of the housing courts for our clients and staff, but also the hundreds and thousands of litigants who are not entitled to counsel, the unrepresented. The just reopening and operation of New York City's housing courts are crucial to our client community. Before the pandemic, housing courts were crowded each day by throngs of unrepresented litigants fighting to stay in their homes. The shortcomings of our housing courts have always disproportionately impacted low-income communities, people of color, and those with the least resources to weather forced displacement. We know that eviction prevention and homelessness prevention is a racial justice issue. And as we look towards the reopening of our housing courts, it is crucial that we do so in a way that reflects what we have learned about access to justice. First, we must extend the eviction moratorium. So while infection rates in New York City are down, epidemiologists warn that a resurgence is all but inevitable as we loosen the very restrictions, including the eviction moratorium, that have helped New York stay safe. If we allow evictions to take place at the cusp of a second wave, we will be flooding homeless shelters, subways, and streets at the very moment that we need to maintain the status quo to prevent the death toll from climbing again. And in addition, new filings will mean more people entering the courthouses across the city, violating norms for social distancing, isolation, and quarantines. These outcomes and the prospect of the eviction of thousands of individuals and their families do not represent the ideals of a fair and just system. Second, equity requires that no one be mandated to come in court in person at this time. It is well documented that the pandemic has disproportionately impacted low-income people of color. And in fact, I testified before the Senate and the Assembly on those issues and our statistics surrounding that. Increased density in the courts increases the risk to advocates, to other litigants, and to court personnel. Housing courts should allow any litigant to appear virtually at any time without the need to prove a medical exemption. And at the very least, it is critical that high-risk individuals not be required to appear in court. Moreover, parties and their representatives should be given an opportunity to resolve pending matters outside of court, which may successfully divert many cases from the system altogether. We must provide fair, transparent, vital access to the courts. In recognition that the digital divide and vulnerability of the COVID-19 crisis often overlap, courts should partner with other public agencies and community leaders to bridge the gap by, for example, creating community kiosks or providing hotspots and devices to any litigant who needs to appear virtually. Further, OCA should ensure language access and interpretation services for vital virtual appearances and should widely advise the public of the option to appear virtually. OCA should adopt uniform rules for virtual appearances so that litigants have clear expectations on how a case will proceed. The court should provide private spaces where litigants and their attorneys can confer at a distance. Third, where parties should choose to appear in person, OCA must ensure the maximum degree of safety for such in-person appearances. Tenants who feel they cannot navigate virtual appearances or feel that they really want to have the opportunity to appear in person should have the opportunity to do so if they choose to defend their homes in that manner. Housing courts should work with epidemiologists to develop safe reopening plans and should subject such plans to a public notice and comment period. No eviction case should proceed until such notice and comment period is completed. Among other procedures, housing courts should distribute PPE to all litigants free of charge. Fourth, we must provide rent relief. The pandemic has wrought unprecedented levels of economic loss. Tenants are struggling to make rent payments and living in fear of displacement. At the same time, the loss of rental income threatens some owners' abilities to maintain their homes, pay taxes, and meet their mortgage obligations. And we need a subsidy program to support any tenant family who's rent burdened, access to rent arrears for both undocumented families, and rules barring landlords from bringing non-payment cases for apartments with hazardous violations. And with these recommendations, we hope the state can work to ensure that New York City's housing codes reflect the best of our city and our collective will to protect the most vulnerable New Yorkers. Thank you.
Thank you very much to this panel. Much appreciated. And we really, as both public officials and as New Yorkers, appreciate all the work you're doing. So thank you so much.
Can I jump in?
Oh yes, I'm so Senator Kavanaugh. I figured you'd have a question because, but I did not see your hand raised. But of course,
that's okay. We're work in progress here. Thank you.
This is your panel.
It's all of our panel as tenants and residents and people. In seriousness, we've spent a tremendous amount of time, all of us, working on these issues that you're talking about today. And Senator Hoylman, as chair of the Judiciary Committee, has really been essential, especially as we've looked at how the eviction issue has played out. You mentioned, Adrian, you mentioned now the need to have additional funding for rent relief in place. Can you talk about, and I want to get to the eviction moratorium in a second as well, but can you talk about the role of rent relief as a component of how we're going to unravel the tenant crisis that we're facing?
I think it's a two-pronged discussion, right? So I think that there definitely needs to be rent relief to alleviate the stress that so many folks in our community are witnessing right now. There's unprecedented job loss, loss of hours, so loss of wages. We are really concerned and have been working with the state to try to make sure that there could be expanded eligibility for folks to be able to be eligible for rental arrears, even if they cannot necessarily prove a future ability to pay the rent, but the idea that we need to delay until there can be some additional revenue that comes into the state or additional way in which the legislature can act to really try to save those homes, because we don't want to find folks going into the shelter system because it would be a health emergency. But at the same token, we also understand that there needs to be, part of this crisis predates the pandemic. So many of you all on this, legislators before me, you all are my heroes, whether it's because of reforms on criminal justice or whether it's been reforms around housing. You all have been the ones that have really stepped out there and really pursued with real gusto and really looking at reforms on what it is that we can do for New Yorkers. And we really do need to deal with the fact that close to half of New Yorkers are rent burdened, and a quarter of them are severely rent burdened. We need really meaningful subsidies. And the last time I was before your committee, co-chair Senator Kavanaugh, was to talk about statewide Section 8, which is something that we really would hope the state would take seriously to really deal with the ideas of stabilizing our communities, because we know pre-pandemic, post-pandemic, that stable and affordable and adequate and safe housing is good health policy, is good education policy, is good employment policy.
Great, thank you. And thank you for your kind words. On the issue of the moratorium, I think you favor the sort of what was called earlier in here, the gold standard, which is a bill Senator Myrie is carrying, which I co-sponsor. There's very little that we've done so far in this pandemic that goes a year and a half into the future. We've done these things incrementally, for better or for worse, and I think that has caused some lack of predictability going forward. The courts have now put this moratorium in place until September 30th, which is, I think, a relief for a lot of us who are looking at that expiring on August 20th and then September 4th. But if what the legislature and the governor can agree on is a shorter term moratorium to tide us through the current situation and assess where we are in the future, if we were to do it through January so that we're back in session and can revisit the situation then, I mean, would that be welcome from your perspective?
Listen, the way that I look at it, I would like to support any and all measures that would assist my clients. I am so fatigued at the fact that so much of the burden of what is going on right now, whether it's the reopening of the courts or whether it's actually, advocacy around housing, the burden always seems to fall on tenants to have to somehow, take what it is that they can get. Of course, I would support the longest moratorium that we can have, but, tying things to a date. Even as I look at what it is that I need to do for my staff as we work remotely and as we continue to be engaged with our client communities, but having to do it under this catastrophe of a pandemic, I don't know what's going to happen tomorrow. I certainly don't know what's going to happen October 1st, November 1st, January 1st, or a year from now. And so because I don't have a crystal ball, I would say that we have to look and we have to be flexible and we have to respond as we do as first responders to what it is we have before us. I support anything that's going to continue to protect our clients and keeping them in place in their homes and safe. And this is a public health crisis as well as a humanitarian crisis about keeping people in their homes. It's a really, eviction itself seems to be a disproportionate a penalty for the inability to pay your rent. But during a pandemic, it is harrowing. And the idea of a moratorium to me should be extended for as long as our community needs it to be extended.
My time is up, so I'll yield it back, but thank you.
Thank you very much, Senator Crowder. Thank you, Adrian, for those words. Senator Bailey, co-chair of our hearing, has 5 minutes.
Thank you, Chair. I'd like to congratulate myself on finally learning how to use the raise hand feature on Zoom. I'm very proud of myself for that.
We're happy to have experienced that with you.
Listen. It's a great day in the legislature. 2020 is bringing us lots of firsts, some bad, some great. But my words are more here for appreciation. I won't take up the time. I just want to say thank you for all that you do. Housing is still one of these critical issues that our constituents are calling us about consistently, and your offices by and large are the ones that we're speaking to, that you're having conversations with our constituents and you're helping to counsel them. And as Adrian, as you said, you are first responders, because when somebody has a crisis situation, when somebody is at their wit's end and they're concerned about losing not just their job, which is the unemployment, but losing the roof over their head and that of their children, and trying to figure out where are they going to sleep at night. It's a rather simple sentence, but it can cause people a lot of fear and anxiety. And so I just wanted to thank you for the work that you do in this space. And I remain committed to trying to make sure that we continue to try to house everybody and get us to a point where we can, in essence, get it together. So this is more of an appreciation statement. So thank you.
And we appreciate you. You have been a wonderful partner on so many of our issues. And thank you for all your help. And thank you for, even despite the fact that you had to make a run, remaining so engaged in this hearing. It really shows a lot.
Thank you very much. And now, thank you again, panelists, for your contributions today and for all the work you do.
Can I just jump in and say I'd be remiss if I didn't thank you to those who are working on the foreclosure and Mr. Inwald for your comments about the legislation around private right of action. We will be looking to try to advance that, but we appreciate all your thoughts and all the work all of you do and so, to keep New Yorkers safe in their homes. Thank you.
And we appreciate how responsive your office has been to working with us on those issues.
Great.
So thank you for all your support.
Okay. Thank you. Now we're going to have the next two panels together. So we will convene panels 8 and 9. Conrad Johnson, clinical professor of law and co-director of lawyering in the digital age at Columbia Law School. Lourdes Rosa Carrasquillo, Director of Advocacy at the Center for Independence of the Disabled. Dawn Mitchell, Attorney in Charge, Juvenile Rights Practice at the Legal Aid Society. Hello, Dawn. And Hamra Ahmed, Director, Development of Law and Policy at Her Justice. So let's start with Conrad. Conrad, you have 5 minutes, please. And thank you for being here.
Sorry, thanks for letting me unmute. Okay, so with all due respect to my colleagues in academia, asking a law professor to come to the point in 5 minutes is a tall order, but I'll take up the challenge as best I can. I'm a clinical professor of law at Columbia Law School. I've been there full-time faculty for 31 years. 20 of those years, I've been running the Lawyering in the Digital Age Clinic, which focuses on the intersection of technology and law practice. Our clients are exclusively public interest legal organizations like Legal Aid Society, Legal Services, Western New York Law Center, and prominent jurists like Chief Judge Jonathan Lippman, late Chief Judge Judith Kaye, who all seek our help in using technology to expand access to justice. Prior to joining the faculty, I was the attorney in charge of the Legal Aid Society's Harlem neighborhood office. So my friends, the chickens have come home to roost. My experience as an academic and an attorney working in the public interest arena for the past 40 years makes it abundantly clear that the unequal distribution of resources that afflicts our society generally is manifested in the resources that are available to many New York courts. Most, if not all, proceedings that involve predominantly lower income communities are afforded far fewer resources and are available in venues that adjudicate the claims of more moneyed interests. This results in many shortcomings that have been noted throughout the hearing: overcrowded courtrooms, inadequate staffing, bulging dockets, insufficient space allocations, all of which make it unsafe to reopen proceedings in person. We're all in this together. The pandemic has taught us anything, it's that we are interconnected. Therefore, the caution with which the courts have approached reopening is abundantly wise. The chief among those precautions is the moratorium on evictions that must continue, and that's vital to our public health, as many have remarked. That said, the Administrative Order 160/20 issued on August 12th, permitting 200,000 eviction cases filed before March 17th to proceed and another 14,500 eviction warrants to move forward, is unwise. The virus doesn't care whether judges, court personnel, attorneys, and litigants are forced together to resolve old or new cases. The threat of infection transmission is just as real whether the case was started before or after March 17th. I must say I was also troubled by the strong inference by Judge Marks earlier today that eviction moratorium will end as of October 1st without legislative intervention. That moratorium on evictions and proceedings must continue. So what do we do to move forward responsibly? First, it's important to understand that the digital divide is real and it exists along the fault lines of inequity that have been exposed by the pandemic. Technology is still in short supply when it comes to meaningful access to virtual proceedings for huge swaths of New Yorkers. 1.5 million New York City residents have neither a mobile connection nor a home broadband connection. 46% of New York City households living in poverty do not have broadband in their homes. These barriers are not reserved for low-income communities or communities of color. They extend to many seniors, as well as those grappling with physical and cognitive deficits. Virtual proceedings present a myriad of difficulties that can prevent meaningful participation. Those challenges include hurdles to presenting relevant evidence, maintaining confidentiality, allowing for private attorney-client consultation in real time that meets the standards of effective assistance of counsel, not to mention the simple ability to see, be seen, hear, and be heard in the face of unstable internet connections and expensive data plans. I leave you with one simple principle that might guide your efforts. In considering measures that the courts can take, courts should abide by the principle that litigants can waive due process rights to the extent that the waiver is based on informed consent. This is a time-honored problem-solving tool the courts already use all the time. For example, in housing court, litigants in a resolution part can choose to waive the right to a trial through a mutually agreeable stipulation of settlement, just as criminal defendants can consent to plea bargaining. However, due process rights should not be trampled by the court through procedural devices that fail to recognize and mitigate the disparate impact and due process consequences that significant segments of the population will face in virtual proceedings. I want to close by endorsing the call by many, including the Legal Aid Society, for continued rent subsidies that will help stem the tide and prevent wholesale homelessness resulting from the economic impact of the pandemic. Thank you for the opportunity to be heard.
Thank you, Professor. And 5 minutes, that was perfect.
I know, how about that?
Next, we're going to hear from Lourdes Carrasquillo, Director of Advocacy at the Center for Independence of the Disabled.
Hello, it's Lourdes Rosa Carrasquillo. And thank you, senators, for having this joint hearing and giving me the opportunity to speak on behalf of people with disabilities. I also want to raise that people with disabilities are people of color, are seniors, and every other group that is disenfranchised and not. So what here is to request that the moratorium be extended to even to tenants whose matters are going to be commenced in March 17th. We serve people with disabilities on various benefits and services, but I'm going to focus right now on housing. A lot of what we hear before the pandemic has been risk of eviction and filings for eviction because someone requests a reasonable accommodation or modification, or because of source of income. And that is problematic in many ways. And we're concerned how the court will address all those two key issues that are very complex and detailed. We're also concerned that before the pandemic, the Department of Social Service, as you've heard, has what's called the one-shot deals. And if you can prove going forward, you can pay the rent, you'd be eligible more often than not. However, due to the pandemic, tenants before COVID-19 most likely won't have an opportunity or didn't get to file for it prior to it. So they will not have the benefit of a one-shot deal. And as someone had mentioned in the prior panel, also that they cannot guarantee paying rent moving forward because of their lack of employment. Tenants with disabilities and who have tenants who have children with disabilities, unlike people without disabilities or don't have children, have to choose between obtaining or continuing healthcare treatment to live their normal everyday lives or paying rent. In addition to, like people without disabilities, they struggle to keep food on the table. The Chief Judge Mark's procedure states that consideration will be given to parties affected by the virus. It references the New York State Harbor Law, sponsored by Senator Hoylman and Assemblymember Dinowitz. Thanks both and everyone that supported its passing. After its passing, I want to quote something very powerful that I think Senator Hoylman stated. No single law can single-handedly solve the eviction crisis, but the Tenant Safe Harbor Act is one crucial step to address the looming tide of wave of eviction. In that statement, Senator, you really raised the issue of the tidal wave of evictions and how powerful that law is, but it still can't solve the crisis. The court has always had a heavy burden and extremely large caseload. The intent to hold status or settlement conferences that include, confirmed compliances, notices, doesn't necessarily ensure that people with disabilities' rights to accommodations will be able to be met. That is a difficult and long process that in the past the court has had difficulty in doing. So I'm really concerned that if you're going to allow commencements for prior to March 17th, how are we as people with disabilities going to be protected to have our rights in the procedures, in the process? Yes, we have the issues of being no social distancing, all those safety issues, but we also have the issue of trying to educate and push and having legal aid representatives, attorneys who are underpaid and understaffed, be able to handle such complex cases. So I really hope there is some mechanism that you can assist all of you in ensuring that commencing cases prior to March 17 will not happen. And again, I thank you all for this time, and my written testimony is substantially longer.
Thank you very much, Lourdes. Much appreciated. Next, Dawn Mitchell, Attorney in Charge, Juvenile Rights Practice at the Legal Aid Society. Hello, Dawn.
Hello, and thank you for this opportunity. Can you hear me? Great. I'll start off by just saying that there's no question that the COVID pandemic has had a devastating impact on all New York residents and institutions, and the family court is no exception. Judges, court officers, and my colleagues, and the people who the court was created to serve have been greatly impacted. What is astounding is that even during these darkest moments of this crushing public health crisis, the family court never stopped functioning, and neither did the advocates that represent the children and the families the court is set to serve. And when remaining open for in-person appearances became literally a matter of life and death, the court pivoted to a virtual platform. And the Legal Aid Society juvenile rights practice shifted to a virtual-based practice as well. And before the pandemic and during this unprecedented time, I've had the greatest opportunity and privilege of working with the most dedicated and hardworking professionals whose devotion to our client community has been unwavered and uninterrupted. We continue to serve vulnerable children and young people in the city of New York who have child protective matters and juvenile justice matters every day. And it is our goal to continue to ensure that their rights are protected and their voices are lifted. When COVID-19 pandemic halted normal family court operations and suspended in-person appearances, only emergency proceedings were scheduled. And then gradually, there was expansion. Brief appearances were permitted to resolve matters that we could resolve through stipulations and motions, and/or brief appearances before a court in virtual court. New York City operated initially with just 3 virtual court parts for the entire city. We now are operating in about 30 virtual court parts citywide. And even when the virtual court logistics made our work even that much more challenging, the collaborative work and the creative problem solving of not only the attorneys for children community, but also the parent provider community, it's been remarkable. It's the only way we can get work done. Our partnership is evident, and we have asked all along to work collaboratively with the court to advance greater access and greater resolution of family court matters that are pending. But even with the gradual expansion of virtual court capacity, the lack of access to the court has created profound and detrimental impact on the clients that we serve. Black and brown children are grossly overrepresented in the family court matters, and this pandemic has only elevated the critical needs our clients and their families face. All of their matters are essential. All of their matters are urgent. and access to court time has been meted out in a manner that does not always appear to be consistent with that thought. There is a lack of consistency among the jurists in determining which cases get court time. There is lack of access to courts, and it has contributed to children languishing in foster care, while services to support them and assist their parents and facilitate reunification has been disrupted. For example, permanency hearings. It's an essential mechanism for the court to oversee child welfare agencies in their efforts to achieve child permanency. However, during this period, there have been no permanency hearings scheduled. Only recently did we receive notice from the court that these matters will begin to be calendared. However, the court has not put forward a plan or a procedure to prioritize those matters and to address the backlog in the court in a coordinated manner. And while we've seen a reduction of juvenile delinquency cases being filed, we have not been able to proceed to hearings and trials on these cases. And as a result, there is a backlog of juvenile delinquency cases, and youth are languishing in detention centers as a result. Or for those children or youth who are paroled on those matters, those pending matters have been adjourned for months. And in fact, they are deprived timely resolutions because of that. The court has continued to explain that the lack of court time is due to court resources being constrained. Specifically, they don't have enough court reporters. Something as simple as putting court reporters into the virtual context has somehow been unachieved. And therefore, there is an enormous number of cases that are going unscheduled and unheard. On cases where we have to have children in court, and that's on many cases, but specifically on the juvenile delinquency cases, I'll draw your attention to the example that is quite challenging to represent a youth in a virtual court setting when we're in two different places and unable to speak confidentially with our clients. The court uses a system, Skype for Business. It's a web-based system. It's said to be available to everyone, but you might imagine the communities we serve don't have access to the technology and the devices, and therefore getting access to the court process and having the ability to manage.
If you could wrap it up, please. I'm so sorry to interrupt.
Oh, I'm so sorry. Okay. I just want to also say that one of the key issues that we really need is a collaborative process with the court to resolve some of these standing issues that actually prevent our access to court time. Thank you.
Thank you, Dawn. And now Amra Ahmed.
Thank you, Chair Hoylman, Chair Bailey, and Chair Kavanaugh for this opportunity. I am Hamra Ahmed. I am the Director of Law and Policy at Her Justice, a nonprofit organization that stands with women living in poverty in New York City. For 27 years, justice for women living in poverty has been at the core of why Her Justice exists. In 2019 alone, we provided a range of legal help to more than 4,000 women and their 5,000 children in the areas of family, matrimonial, and immigration law. Our service delivery model makes us unique. Our small legal department of 21 who speak 10 languages other than English recruits, trains, and mentors volunteer lawyers from the best firms across the city. These volunteer lawyers then stand side by side with women who would otherwise have to navigate the complex legal system on their own. Our clients are the working poor with very limited resources. They live in all 5 boroughs of New York City. More than half are foreign born. A quarter of them need interpreters in court. Most are mothers, and more than 75% of our clients are victims of domestic violence. In this crisis, our unique model has positioned us to be able to pivot quickly and smoothly to provide services remotely, leveraging private volunteerism to prepare clients to engage with courts when they reopen. Our civil legal services are essential services, preventing greater crises for people living in poverty down the road. We recognize the severe shortage of lawyers available for low-income New Yorkers. In the civil courts, that burden falls disproportionately on women who represent the bulk of the unrepresented in family and divorce matters. While our offices are physically closed, our team continues to serve clients and support our pro bono attorneys. Our legal helpline remains open, and we connect with clients via phone and video conference when available and exchange documents electronically. We offer information, advice, brief services, and full representation in support, custody, and order of protection matters in family court, divorces in Supreme Court, and immigration matters. We continue to mentor our pro bono attorneys virtually and send regular communications about court updates. We also have reached out to our community-based partner organizations to offer information and support. While our services to clients may look different in some ways during this time of court closures, the need for legal support for women living in poverty is as real and urgent as ever. Pro bono legal services in the family courts and matrimonial parts of the Supreme Court are an essential component of OCA's efforts to close the justice gap. During this crisis, the court's commitment to justice for all litigants, particularly those New Yorkers with fewer resources to weather this pandemic, is severely challenged. By necessity, all of us have learned a great deal about working in non-traditional ways, including about the efficacy of remote family court services. Given the substantial number of unrepresented litigants in family court and the digital divide that has been made clear in the pandemic, Her Justice is concerned about how litigants will be able to appear remotely in court. For represented litigants with few resources, appearing in court remotely may be extremely difficult. For pro se litigants, it may be impossible. Moreover, many of Her Justice clients cannot safely or privately appear in court by phone or video. And even if courthouses reopen while there is still a public health risk, some litigants will be unable to appear in person because they remain high risk or are ill themselves. We believe now is the time for innovation. The public health crisis has presented an opportunity to evaluate the functionality and efficiency of the courts and better understand how the system does and should respond to the needs of all litigants. We understand that there are various task forces and discussions about technological and other reforms of the civil court system at this time. We and our law firm partners can contribute significantly to that dialogue. Adopting reforms now, based on our shared learning experience during this pandemic, could benefit the administration of justice for years to come. Many of our clients engage with the New York family courts to get legal relief that is critical to their safety and well-being, including orders of protection, financial support from partners, or clear visitation schedules. All of these remedies are particularly essential for victims of partner violence. The family courts are providing virtual access for certain matters deemed essential, including applications for temporary orders of protection, motions for urgent issues that arise in pending cases, and more recently, modification of child support orders. And while we understand the challenges facing the courts, prohibitions on the filing of some new family and matrimonial matters does mean that critical court relief is unavailable in some cases. For single mothers living in poverty, child support can mean the difference between remaining safe and independent or returning to a dangerous situation. Women often shoulder the burden of supporting children. While the New York City Family Courts recently expanded to accept modification petitions, they've not accepted new filings. We have urged the New York Family Courts to consider allowing filing of initial child support petitions by email, even if the courts cannot adjudicate the matters at this time, so that parents can preserve filing dates to which final support orders or modification of orders would be retroactive. Thank you for the opportunity to highlight the particular challenges for the most vulnerable New Yorkers without access to the legal courts during this public health crisis, along with the opportunity for reform. We are grateful for the legislature's support for the essential legal services that we provide to women living in poverty and its commitment to improving access to justice for all New Yorkers. Thank you.
Thank you so much. Senator Bailey.
Thank you, Chair. So first and foremost, let me thank you all for taking the time out of your busy schedules to come on. I'm a CUNY law grad, so public interest law speaks to the heart of who I am. So I appreciate the references to that. Legal Aid Society, Ms. Mitchell, thank you for supporting the juvenile interrogation bill. I truly appreciate your support in that. And Ms. Carrasquillo, thank you so much for advocating. I don't know if you're still on the line. I want to thank you for advocating for people with disabilities, and I am appreciative of that. And you highlighting some of the issues that that may seem to be double whammy, so to speak, for those of us who have disabilities, invisible and visible. The question I had was for Ms. Mitchell is concerning, you mentioned children languishing in detention centers. Could you elaborate a little bit on that, and like how long are they there, and to what extent? And I obviously the due process rights are being rather complicated, but if you could explain a little bit about how long these things are happening for.
That's right. So youth that are entering into the detention centers don't have access to the trials. For due process issues, we really can't put forward those trials through the virtual process. We certainly can't do it with court reporters, and we can't do it with court time. But it appears that the court has not necessarily made efforts to construct an opportunity for those cases to be heard. So what we are doing on those cases, and unfortunately, it puts a lot of pressure on the youth, because many of them, just to move forward into a plan to return to their communities or to begin services, are actually taking pleas. The court has actually had offered no communication, no resolutions, no plans to get trials started. So there's pre-trials on those cases, there's hearings that we have to do, and we just cannot get them done. The only thing that we are able to do, quite frankly, are arraignments. And then we work through negotiation and planning off-site and offline to get those cases moving behind the scenes.
Yeah, because that alongside with some of the other testimony that was earlier concerning the essentially the suspension of discovery has made me very concerned about people doing what they did pre-justice reform, which was taking pleas so that they don't have to be incarcerated any longer. This is a problem, and we cannot allow a pandemic, which is out of the control of all of us, we can't permit that to have increased incarceration. Ms. Ahmad, I had a question for you. One, Her Justice is an incredible organization, and I've heard about it, and I wondered, one, how do people find out about the services that you provide? And then I had a question about the child support paper that you mentioned, because that seems to me to be rather, I guess, disturbing that because of the pandemic that you can't have an online application for child support, and what's the rationale behind that they've given you?
Yep, absolutely. Thank you for the opportunity. So clients find out about us through a variety of ways. Our community-based partner organizations, we do a lot of outreach to make sure that they can refer clients. The courts have our information, so they know to share our helpline information that runs every Thursday from 10 to 1. And the family justice centers, which right now are physically closed, as many are, but they continue to refer clients to us. And that's generally how people come to know of our services. And I'm happy to share more information about that. With regards to child support, as with other issues that the courts have independently decided what is essential, we've been told that capacity has been an issue. So that the courts are not able to be open fully and have determined to triage what they deem as the most immediate situation. So orders of protection were the first to be heard. And there remains a lot of confusion about what that means and a lot of discretion from clerks and magistrates about that. So depending on where you file. And of course, we appreciated opening up here, receiving modification petitions. But to your point, and how significant now more than ever in this financial crisis, child support plays a huge role in families' abilities to receive support, who would otherwise now also need to rely on public benefits. So we're losing critical time, we're losing money, and also to the point of payors and their ability to, finding work is hard. So modifications, enforcement is an issue. So the court's capacity has been the issue that the reason that they've told us that they're not able to open fully to accept new petitions.
Okay. Well, thank you. And I see that my time is up. I just wanted to make sure I stated for the record that while, I guess child support circumstances are rather largely contextual, not largely, they're always contextual, not allowing a parent the opportunity to simply apply for that, it seems to be a bridge too far, and it's something that we should certainly be taking a look at as a legislature, or we should be communicating it to OCA
or the governor's office via directive or executive order, because if we're not providing people with the ability to obtain financial means, I'm not certain what it is that we're doing. And again, thank you all for testifying today. Thank you, Mr. Chair.
Thank you, Senator Bailey. And again, I echo your comments about the importance of the work that our witnesses do. Senator Kavanaugh.
Thank you, Senator Hoylman. I also echo, I, as usual, learned a great deal from Senator Bailey's exchange with all of you, and appreciate all of your expertise and his expertise as well, bring to bear on these issues. Just one question, I know the hour is late, but for Professor Johnson, you mentioned in your testimony the value of having having participants in litigation voluntarily waive certain processes and certain rights in order to facilitate adjudication of cases. Can you talk about how that works? Or I guess my question is, does that have a more limited value in cases where people are unrepresented, where they may not understand the options and what rights they're waiving? And just more generally, as you're the professor of law and lawyering in the digital age clinic. So I think you're particularly apt to, but can you just talk about how unrepresented clients interact with these sort of digital processes?
Sure, and I appreciate the question. So one of the things I tried to make clear in my remarks is that the waiver can only happen if it's a knowing waiver. And of course, that's all the more difficult when you're dealing with unrepresented clients. You can get a lot of stuff past people with some legalese, make it sound very palatable, and the next thing they know, they've given up substantial rights. And so that's a real problem. And one of the things that we've done when we work with the judges and we work with the legal services and legal aid organizations is to focus very much on the pro se folks who aren't getting the access to justice that we just can't afford at this point. Unfortunately, there have been great inroads. We are doing a great job as a result of work in legislatures to fund projects like universal access and the like. But the gap is still out there in so many other areas. You've heard people speak to that. And there's no getting around the fact that the folks who are left behind don't have meaningful access. I will make an offer to you all, because I've been very impressed by the way you've handled this hearing. My clinic is building its docket for the fall. And one of the things that we're going to be working on pretty much exclusively is the idea of building best practices for doing work in virtual proceedings. This will take a lot of thought, a lot of gathering of information that's already out there. And to the extent that this committee or the Senate is interested in participating in that and working with us, we would be happy to share our findings, to work with you to disseminate best practices and the like, if that's helpful to you, because it's particularly useful, Senator Kavanaugh, when it comes to the unrepresented, because they're completely at sea.
Great. I think we'll take you up on that. Thank you very much, and thank you for your answer. And again, thanks to everybody who participated today and all of your comments and all the work you're doing, on the ground in our communities to make sure people have access to justice.
My pleasure.
Thank you.
Well, what a fantastic day and such important information we learned for all of the senators who were here, and my co-chairs. I want to extend a very heartfelt thanks to Senator Bailey, Senator Kavanaugh, for your expert questioning of witnesses, for all the witnesses, including this panel, to our Senate team from Conference Services, Ken and Kurt, who helped prepare a memo for us that we utilized in helping educate ourselves before this hearing. And of course, Senate Media Services, and namely Stanley De La Cruz, who's kept everyone on time and on Zoom. So thank you, Stanley. A real shout out to you. I hope everyone has a good weekend. This will all be archived, and as was said earlier, the testimony is online for everyone who's watched and wants to dig in a little deeper to these crucial issues of access to justice during this incredibly difficult time for New Yorkers, particularly the most vulnerable and low-income New Yorkers. So thanks, everyone.
Thank you.
Thank you.
Thank you all.
Thanks, everybody.